Milord, court's audio is muted, Milord. We are unable to hear anything, Milord. I'm sorry, Milord.
ನಾನು ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ತಾ ಇದ್ದೆ ಶ್ರೀನಿವಾಸ್, ಅದೇನು ಇಂಪಾರ್ಟೆಂಟ್ ಇರಲಿಲ್ಲ, ಸ್ವಲ್ಪ ವೇಟ್ ಮಾಡಬೇಕಾಗಿತ್ತು.
Sorry, Milord. Sorry, ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
ನಿಮ್ ಕೇಸು ಅಲ್ಲ ಇದು.
ಇಲ್ಲ, I'm sorry, Milord. I'm sorry. ಗೊತ್ತಾಗ್ಲಿಲ್ಲ.
All right. What was the date? Huh? Which was based on a family partition. The said order is confirmed by second respondent deputy commissioner. Though mutations were effected based on a unregistered partition deed, it is evident from the records that pursuant to partition reported by petitioner and husband of fifth respondent, the partition prima facie appears to have been acted upon, and 40 proceedings are also effected in terms of the partition, alleged partition between family members. Therefore, this court needs to examine as to whether revenue authorities were justified in examining the partition deed rather than relegating private respondents to file a partition suit before a competent civil court. Matter therefore requires consideration at the hands of this court. In that view of the matter, petitioner is entitled for some protection till next date of hearing.
1 to 4.
Accordingly, the execution and operation of ಎರಡು order are hereby stayed till next date of hearing. Learned SCGP accepts notice to respondents 1 to 4. Issue emergent notice to respondents 5 to 7. Yes. Yes, Srinivas. Or an oral. Yes, sir. Huh?
Mandamus.
Implementation of annexure A not being passed to the third respondent under section 1.
What is annexure A?
Not passed for under section 192A or eviction.
Correct.
Section may say actual representation taking action under annexure D. Section may
Who was ordered to be evicted?
respondent there. Chandramohan.
Huh?
Ordered to be evicted.
He was ordered to be evicted under 192A. And who are you? What is your locus? Who are you?
So you also can take annexure B.
Yes. Who are you?
I filed repetition as PIL, in the PIL.
All right, all right.
On that ground, I gave a representation.
You are the whistleblower. Huh? Yes, sir.
Yes,
Implement your own order. What is this?
We will
I'm not inclined to.
we will
grant
consider,
any
madam.
detail.
We will consider.
But you take note of this.
Please, ma'am, we will consider.
That we will do. We'll direct. At your instance,
This is a public
Complaint was filed.
Kharab land matter, public property. We will do.
The eviction order was passed. I came before the Honorable Court in PIL.
PI.
In the PIL.
You were the petitioner? You were the petitioner.
Yes, ma'am.
Work out. All right. Learned SCGP accepts notice to respondents
1 to 3, madam.
1 to 3. Petitioner is seeking mandamus against respondents to implement the order passed by third respondent as per annexure A. Next, the consumer petitioner and learned SCGP reviewed the records, reviewed the writ papers. Petitioner has knocked the doors of this court, alleging that though third respondent / Tashildar invoking section 192A has ordered for eviction of, has passed an eviction order in respect of land bearing survey number 47/1,
1 and 2.
1 and 2 measuring 2 guntas and 20 guntas respectively, situated at KR Puram village. Kaba. Petitioner claims that this order is not implemented there by the revenue authorities. For result of the record, this court is satisfied that there is a lack of diligence on the part of respondents 2 and 3 in not securing possession of the land, though an order is passed under section 192, capital A of the Karnataka Land Revenue Act. This court has also noticed that the petitioner hearing, it has noticed that at the instance of petitioner, which led to filing of a PIL in WP 12877 of 2023, second respondent, third respondent Tashildar initiated proceedings under section 192, capital A of Land Revenue Act. If an eviction order is already passed, authorities are bound to implement the order and take possession of the land which was trespassed by the concerned person. In the light of discussion made supra, this court passes the following order. Petition is allowed. Third respondent, is yaar ಮಾಡಬೇಕು
Respond
implement.
2 and 3 ಅಂತ.
Huh?
2 and
Respondents 2 and 3 are hereby directed to implement the order dated 14/9/2018 as per Annexure A. Next, this exercise shall be accomplished within a period of 3 months from the date of receipt of order.
Please.
So number 3, Ravindra Prasad.
Yes, sir.
Take the name of the petitioner in the review report.
Based on what?
Based on conveyance.
Huh?
Convinced.
Based on?
Conveyance.
Teza, sell it in your favor.
But appeal has to be,
Huh?
our endorsement saying that, my lord, you have to file appeal before the AC.
Okay.
Because the checklist is not receiving the in conveyance date ಬರುವಾಗ my lord, ತಹಸೀಲ್ದಾರ್ ಒಂದು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಆ ಚೆಕ್ ಲಿಸ್ಟ್ ತಗೊಳೋದಿಲ್ಲ ಅಂತ. It
What
will
is the
not receive the checklist. ಖಾತಾ ಚೇಂಜ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ AC has to direct them to do it, my lord. Conveyance ಮೇಲೆ. Technical problem. AC has to approve, madam.
AC has to?
Approve.
Yes, to approve it.
Please, madam.
All right, I will pass order and let him furnish this
Please,
judgment
madam.
with the
Before the AC,
Assistant
please,
Commissioner.
please.
That we will do.
But here the reason is assigned, due to technical reasons, we are not able to produce. Kindly see.
Due to technical reason, my lord,
Actually, you should
because
have- No,
AC
you
has
do
to
one-
operate.
you
Therefore,
do one thing, you employed Assistant Commissioner as a second respondent right now and will issue direction.
please, madam.
Will issue direction. So what is the checklist, Mr. Harish?
ಚೆಕ್ ಲಿಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಮಲ್ಲಾಡು ಒಂದ್ಸಲ ಈಗ ಕನ್ವೆನ್ಸ್ ಮೇಲೆ ಮಾಡ್ಬೇಕಂತೇಳಿ ಈಗ ಸೇಲ್ ಡಿಡೋ ಅಥವಾ ಪಾವತಿ ಖಾತಾ ಆದ್ರೆ AC ತಹಸೀಲ್ದಾರ್ ಕ್ಯಾನ್ ಡೂ ಮಲ್ಲಾಡ್.
Huh.
ಬಟ್ ಈ ಕನ್ವೆನ್ಸ್ ಡೀಡ್ ಎಲ್ಲ ಇರುವಾಗ AC has to approve and permitted to do it, ಮಲ್ಲಾಡ್.
Conveyance is by the housing board.
ಪ್ಲೀಸ್ ಮಲ್ಲಾಡ್.
It is allotment.
ಎಸ್ ಮಲ್ಲಾಡ್. ಅಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ಅಲ್ಲ, KSBC is the owner. ಹೌಸ್ ಹೌದು.
They have executed the
ಎಸ್
conveyance.
ಮಲ್ಲಾಡ್.
deed.
ಕನ್ವೆನ್ಸ್ ಡೀಡ್ ಅದಕ್ಕೋಸ್ಕರ.
Purchase the property, KSB has purchased the property from third party. KSB is the owner. Not a allotment. But they have said the technical reasons we are not.
Now, whether a site is allotted to you or a residential house is allotted.
It's agricultural land.
KSB is required to develop.
But
the land.
ಇದರಲ್ಲಿ
KSB has purchased the land from third parties. KHB, Karnataka Housing Board, I am applying for KHB. And.
Oh, this is by KHB.
KHB has requested, for which they have given a reason assigned that KHB, due to technical reasons, we are not able to go and approach the other.
Yes.
Authority, not on the checklist or any other basis.
Work order. Petitioner is orally permitted to impede Assistant Commissioner Bangalore South
ಬೆಂಗಳೂರು.
as second respondent. Learned SCGP is directed to accept notice to respondents 1 and 2. Next, the counsel for petitioner and learned SCGP appearing for respondents. Caption petition is filed seeking a mandamus, seeking a writ of Shishoria to quash the impugned endorsement dated 24/6/2024 issued by respondent number 1. Consequently, mandamus is sought to direct the respondent authorities to mutate the petitioner board's name in the khata by taking cognizance of the conveyance deed executed by the owner
See, Sambai.
dated 26/10/2009 pertaining to survey number 34/2 measuring 2 acre 8 guntas. Next.
your logic, sorry to interrupt you. B may be simple, that is RDC. The other portion of land also PHP was purchased. That point of time, there is no impediment of any. AC or-
We'll direct them, we'll then do it. Petitioner, a Karnataka Housing Board has purchased the property from one,
Not by a-
ಎಲ್ಲಿದೆ ಹೆಸರು?
Same deed is that, wait, 70 or something.
ಅಲ್ಲ ನಿಮ್ petition ಎಲ್ಲೆಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? Is purchased from so and so
So, annexure 70 or something, the conveyance.
under conveyance deed dated 26/10/2009.
This is not by a-
The purchase is made by the board with a view to form a layout along with the adjacent land. Petitioner board is aggrieved by the impugned endorsement issued by respondent one Tashildar. Under the impugned endorsement, Tashildar has expressed his inability to effect a change in kata. ಯಾವ್ದು annexure B ನಾ?
CML,
Ah?
Annexure CML. Annexure C,
C,
please.
ಏನಂತ?
Technical reasons.
Conveyance deed ಮೂಲಕ ವರ್ಗಾಯಿಸಲು
Ah,
ತಾಂತ್ರಿಕ
as
ಕಾರಣಗಳಿಂದ.
inability on account of technical reasons. Being agreed by the impugned endorsement issued by respondent number one, petitioner board is before this court. Next, Leonard SCGP on instruction has brought to the notice of this court that that unlike proper conveyance through sale deed,
Please.
the authorities are supported by software to effect changes in the RTC.
Please.
He has brought to the notice of this court that in the present case on hand, there being a conveyance between a housing board and a private party,
Private.
the revenue officials cannot effect mutation unless it is
AC
approved by
approved by
assistant
the AC.
commissioner. Next, be that as it may, board has acquired title pursuant to conveyance deed executed by the erstwhile owner for valuable sale consideration. If there are any technical hindrances in recording changes in terms of section 128 of Karnataka Land Revenue Act, second respondent assistant commissioner shall take all appropriate measures and issue appropriate directions to first respondent Tashildar to effect changes in terms of conveyance deed dated 26/10/2009. Next paragraph, petitioner having acquired title based on a conveyance deed dated 26/10/2009 have a legal right to seek change of kata. Accordingly, the board has reported to first respondent special Tashildar by annexing a copy of a conveyance deed. Respondents 1 and 2 are obligated to give effect to the transaction and accordingly bring in changes in the kata aligning with the transfer of title under the conveyance deed. Since there is inaction on the part of respondents 1 and 2, this is a fit case to issue mandamus to the respondents. For the foregoing reasons, this court passes following order. Writ petition is allowed. Second respondent assistant commissioner shall
Then
ಏನ್ ಮಾಡ್ಬೇಕು ಅವರು ಏನ್ ಕೊಡ್ಬೇಕು?
shall approve the make a kata.
Shall issue necessary approval
Oh.
and communicate the same to first respondent Tashildar.
Please.
This exercise shall be done next by second respondent assistant commissioner within a period of 3 weeks from the date of receipt of order copy.
6 weeks,
Yes, only sent a communication.
please.
On receipt of communication from second respondent Tashildar, next to the first respondent special Tashildar shall effect changes in the kata pertaining to survey number 34/2 measuring 2 acre 8 guntas within a period of 8 weeks from the date of receipt of order copy.
Annexure C has to be.
ಅಲ್ಲಿ first ಬರೀರಿ. Writ petition is allowed. Impugned endorsement
Please.
issued by first respondent as per annexure C is hereby quashed.
Number 4. Verification.
Yes, yes, sir, Mr. Rao.
Service. Question number 2 is that there are the petitioner's father who was also in ex-service. Was actually serving in Indian organization. He was a Jodidar of Pulali. under the province of the Karnataka Personal Litigation Council.
So your rights are saved, huh?
What I mean, though our rights were saved, we did not really enforce them at that relevant point of time.
Huh?
But what happened was the compensation that was payable to us, both under the personal indemnity norms of our as well as under the land reform act has not been paid despite.
What you have challenged here now?
I am seeking for a mandamus to respond.
Yes.
Take appropriate action, fixing and paying the compensation payable to the petitioners. So
Adu.
both under the province.
Which is that section? 44 or 48?
What here, what had happened was because of the Odisha, under the Norms Abolition Act also, we were entitled to the compensation in respect to the land.
Correct, you're entitled. Yes, sir.
That was not given.
Seek in section.
Please.
Learned
What
AGA.
happened in this Melod?
Huh?
Special DC has convened a meeting. They have given separate two representation Melod. One is for Enam Subordination Act and another is for LRF Melod. On 6/8, they have given fresh representation as per the directions of the special DC. We'll consider.
Seek in section, I will dispose of at the next date. Learned AGA, accept notice to respondents 1 to 4. Place this matter in preliminary on. Yes, obviously, a date. We'll decide on the next date. Please see.
4/9.
Yes, yes, Prasanna. Yes, sir.
That's of time, yes, 66.
Your right is based on a grant order.
But the proceedings were initiated by the President, stating that this is Goma land. And mutation, the records were not properly fixed. 862 lots. Commissioner was exercise of the powers under 130 subsection 3. Powers.
Is a special deputy commissioner assigned only to inquire these grants, sir?
Yes, yes. At
Yes.
865.
Ah. Yes.
Proceedings under 136 in respect of land being number so and so is hereby dropped. The reason being that he recorded a finding that it was not a Goma land, it was a land actually belonging to the petitioner.
All right.
Now, after this, again, finality was, the regional commissioner directs the Tahsildar to file a review petition. And Tahsildar files a review petition. Based on that review petition, now what the deputy commissioner issues a notice.
Now, there is no provision for review
Review
under revenue, under revenue. Act. That's the point. That's the point.
That is the only point. Some report is-
All right, but heard the learners in the council.
There is no power, my lord, but kindly see the,
Seek in section.
Order,
And I
my
can
lord.
Harish, I'll list it in preliminary.
no, my, yeah, already the one other petition has been filed, it has been stayed.
Yavdu?
One writ petition number
That way-
19280 of 2024.
78, what they try to encroach upon our land. We find that
It has been already stayed, my lord.
Just explain what is.
What is stayed?
Can this be implemented?
Encroach upon the,
Whether this order is stayed.
same subject matter.
Harish, whether this order is stayed.
No,
That-
This order is
This
stayed,
order
Mr.
is not
Harish.
being-
And also
No,
explain that writ petition was after this order was passed. Tahsildar without the authority of law trying to encroach. We filed a writ petition seeking protection. Interim order was granted that since deputy commissioner's order.
And at that point of time, you were not aware that this order is reviewed. You were not aware.
Interim order is passed.
Subsequently,
But I
my
don't
lord,
want to say more. But in regional
no,
commissioner-
no provision, my lord, but
Wait a minute.
entire thing, if your lordship sees, there is no, the special deputy commissioner has not heard the Tahsildar.
But-
Straight away on complaint, sumoto 136 has been initiated, straight away, the come to the conclusion that it is a property of the vendors of the petitioner.
I think you didn't notice the question that I posed to the senior counsel. Short point is whether a deputy commissioner
No,
under
no,
the,
no
under the
power.
provisions of Land Revenue Act has
No
the
po-
power of review.
No.
I'm only admitting on that point.
Please,
Then why did you object, Harish?
please.
Are the learned senior counsel and learned SCGP preparing for respondents? Respondents 1 to 5. Learned senior counsel placing reliance on the order of the special deputy commissioner, evidence that the judge would point out that the genuineness of grant was subjected to an inquiry by a special deputy commissioner under section 136(3) of Karnataka Land Revenue Act. Special deputy commissioner on inquiry dropped the proceedings while order dated
1/4.
1/4/2024. As per Annex H, grievance of petitioner is that in view of directives issued by the joint regional commissioner, the jurisdictional Tahsildar seeks review of this order. And the special deputy commissioner has entertained a review order and has cancelled the grant
Notice to.
and has issued notice and has issued notice.
Seven.
And has issued notice. This notice is under challenge. The primary objection raised by the Learned City Council is that once an order is passed by a revenue authority, he becomes functus officio and has no locus to review his own order. Review, he would further point out that review is not permissible. Review is not permissible. I do find some force in the submission made by Learned City Council. He has also placed reliance on the judgment rendered by this court in the case of so-and-so. Produce the law laid down by this court in WP 20-882 of 2016. Matter needs consideration at the hands of this court. In that view of the matter, the proceedings pending before
Deputy.
first respondent,
Respondent number 3.
pending before third respondent are stayed until further orders. List this matter in B group.
No. Connected with the writ petition number 19280 of 2024 and date may be fixed, my lord, for preliminary hearing because we are trying to file a writ petition, my lord, challenging the special deputy commissioner order, my lord. If we file a writ petition, my lord, it will become infractions, my lord.
Whatever.
Therefore, my lord, kindly have it on after 15 days for preliminary hearing, my lord.
Infractions ಆಗಲ್ಲ. That order has to go.
Yes, my lord.
File ಮಾಡಿದಕ್ಕೆ infractions ಆಗಲ್ಲ. ಅದು file ಮಾಡಿದ್ರೆ then I'll
Get the
dispose.
interim order, my lord.
Ah,
If we get the interim order of the special deputy commissioner order, it become infraction.
list order at the request of Learned SCGP, Race is directed to tag this writ petition along with WP number so and so.
Please,
Release this matters in preliminary.
After 15
2 weeks.
15 days.
2 weeks, yes. Next.
Number 6.
Very good, very good. The legal area of the finance of Krishna, they seeking publication the entry of the names, the representation that we should. Therefore,
Yes, Harish,
my lord, I'll get the instruction, my lord, in this.
you did instruction.
Please, my lord, because
Your application is based on a grant order.
my father
Tara-
name, Krishnappa, originally is a re-grant because the annexure C.
There's a re-grant order.
it's a regrant order, my lord, make a kata and also they are seeking a remove the government Karab land.
Order, seek instruction.
Therefore, my lord, I'll
Learned SCGP accepts notice to respondents 1 to 3. At his request, release this matter in preliminary on.
please.
Next,
4 May. Say number 7.
yes.
Minister has given the representation to the Tahsildar to mutate the name in the Kata. In terms of Milot, court compromise decree entered between both family members with one brother. In return to that,
There's a compromise.
yes, compromise decree between one brother.
It's a compromise, my lord, but 11 is sketch is necessary, my lord.
Ah.
Then the
11 is sketch is necessary.
there is,
It's a, in a one survey number, my lord, they are seeking 2-3 partition, my lord.
I will explain the case.
No. You can mutate the name to the reflecting the extents.
No, they are seeking support,
Ah,
support.
but ಹಿಸ್ಸಪೋಡಿ ಮಾಡಿ ಅಲ್ಲ ಅದೇ 11 ಸ್ಕೆಚ್ ಅಂದ್ರೆ ಹಿಸ್ಸಪೋಡಿ ಹಿಸ್ಸ ಮಾಡಿದ್ರೆ 11 ಸ್ಕೆಚ್ ಅಲ್ಲ.
ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ 11 sketches. 11 sketch, even today, it is not being prepared.
For the endorsement issued by the Tahsildar Milot, seeking for me to submit the 11 is clear, which is against the judgment of this honorable court.
No, that is stayed now.
No.
I will. Another problem, another impediment is Milot, as blank as Milot, as there is no prisoner's name entered in the RTC, I cannot file the 11 application as per the circular
Yeah,
issued
that's
by the government.
Okay, Harish, you have to go stage wise.
Please.
If a compromise decree is recorded by civil court,
Yes.
reflecting the extents.
Yes, my lord.
You only reflect extents aligning with the terms of the compromise
Yes.
decree. Once that is done, then they will apply for 11 sketch, unless you don't mutate their name.
It may be direct, my lord, because in the judgment of
Got it.
coordinate bench of this honorable court, my lord.
Name ಇಲ್ಲ, name ಇದ್ರೆ ನಾನು apply ಮಾಡ್ಬೋದು.
Harish, I think,
Name ಇಲ್ಲ.
I think there should be no impediment for revenue authorities to reflect the shares in terms of
Kata,
compromise.
with respect to Kata, my lord,
ಖಾತಾ ಮಾಡಿ ಅಲ್ಲ ನೀವು
Please,
ಈಗ ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಕಾಕಾ, ಅದು ಸ್ವಲ್ಪ
Kata,
ಕಷ್ಟ
not Kata and Disappoint they are asking.
ಫಸ್ಟ್ ಖಾತಾ ಮಾಡಿ.
First Kata, my
Fine.
Kata will do, my lord, then Isapodi later on will. Because it is a Lebanese sketch, my lord, private surveyor can be engaged and they can do the survey. If they give,
after
it
mutation of
can
Kaka
be
mutation
do
survey.
it on the basis of a private surveyor report, my lord.
Yes, my lord, this honorable court has held that, my lord, when there is a compromise.
It's a sale, registered, sale deed ಗೆ. ಸೇಲ್ ಡೀಡ್ ಸೇಲ್ ಡೀಡ್ಗೆ ಅವ್ರು ಏನು ಇಲ್ಲಿ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ ಅವೆರಡು ಓನ್ಲಿ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್.
Not regarding sale deed, my lord. They are compromised. Annexure F, my lord, I will point out. Annexure F, page number 39, my lord, the petition copy. Very good. Page number 39, paragraph 3, my lord. Pursuant to the compromise decree passed in OS number 41 by the court of CH-13, but Kultagi, the petitioner appears to have filed an application before the court respondent Tahsildar to enter his name in the revenue records in the land clearing survey number 214, which has said to have been allotted to share in the compromise decree. Tahsildar considering the said application has issued the included endorsement stating that petitioner request can be considered only after he produces 11K. Challenging the said endorsement, the petitioner is before this court. Learners council appearing for the petitioner submits that since already a compromise decree passed by the competent in court and the land in question being allotted to the share of the petitioner, Tahsildar could not have issued the endorsement. He submits that though this court in the petition number so and so disposal of in 5th October 2021 has directed the revenue authorities not to insist upon 11 states for making necessary entries in the revenue records, even then they include endorsement.
Para 6 my lord, which I am quoted.
There is a next matter. Per contra, rather, AG appearing for the.
Para 6 my lord.
Where he submits that having regard to the order passed by the coordinate bench of this court. in
Issue is not only the regard to the for entry of the name of the person. In the land revenue records or record of rights, the purpose of the provision is to enable the
ಬೇರೆ reading,
maintenance
ಬೇರೆ
of
reading.
proper. Please my lord.
ಅವ್ರು ಓದ್ತಾ ಇರೋದು
ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಿದ್ದು 6 ನಾನು ಕೊಟ್ಟ ಜಡ್ಜ್ಮೆಂಟ್.
see he is reading annexure F reading. All right.
Sorry.
And para 6.
Sorry ma'am.
Yes, sir.
Further, the issue is not only with regard to the entry of the name of the person in the land revenue records or record of rights. The purpose of the provision is to enable the maintenance of proper record in the office of the survey department, revenue department. In the considered opinion of this court, the very purpose behind the enactment of the provision and the wisdom of the legislature in the mandating production of revenue sketch, properly known as Lebanese sketch, prepared by the licensed surveyor, wherever there is a division or subdivision of a land would be defeated if a direction is issued to the Tahsildar to enter the names of the person in the record of rights consequent to the compromise decree drawn before a civil court. No doubt, the state government has clarified in its subsequent circular dated 3/1/2019, 21/10/2019, and the circular dated 14/11/2016 issued by the Director of Bhumi and UPOR as noticed by the coordinate benches of the judgment cited here in above, clarifying that the sub-registrar need not insist upon furnishing the Lebanese sketch while registering a document. However, the same may not be readily acceptable in the case of the entry in the revenue record.
Case, my lord, regarding, my lord, where there is the entry of the petitioner's name, my lord, is furnished, but my case, my lord, I have no.
Wait, this was based on what?
This was based on
Sale deed.
say no, not sale deed, my lord. It's a pure partition compromise decree. ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅನೆಕ್ಷರ್ ಎಫ್ ಮೈ ಲಾರ್ಡ್.
ಸ್ವಲ್ಪ
ಒಂದು ನಿಮಿಷ ಇರಿ ಇವ್ರೆ.
what is this? What's the problem? Wait a minute.
ಇವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಅನೆಕ್ಷರ್ ಎಫ್ ಮೈ ಲಾರ್ಡ್. ಏಳನೇ ಪ್ಯಾರಾದಲ್ಲೂ ಸಹ ಅದು single judge of this coordinate bench dealt with my lord. Compromise decree enter into the before civil court. This would be enable the revenue authority department of surveyor to.
Now this
maintain
compromise decree is in a suit for what?
Suit for partition.
This was also for suit for partition,
Yes, my lord.
where it is indicated.
It is not been indicated here, my lord. But compromise ಆಗೋದೆಲ್ಲ suit decree ಗೆ ಅದೇ partition suit ಅಲ್ಲೇ ಇದು. 11 sketch arises. In the, if my lord one survey ಅಲ್ಲಿ ಒಬ್ಬರಿಗೆ ಹೋದ್ರೆ my lord the 11 sketch is not necessary. ಸರ್ವೆ ಒಂದ್ ಸರ್ವೆ ಅಲ್ಲಿ 3 ಜನಕ್ಕೆ ಡಿವೈಡ್ ಆದಾಗ ಆ ಸರ್ವೆ ಅಲ್ಲಿ ಕೋಡ್ ಮಾಡ್ಕೊಂಡೇ ಮಾಡ್ಬೇಕು my lord.
Harish, just, I think this is going on. This problem is really perpetuating, I'll tell you. Yeah, really? Yes, Mr. Devraj. You got to prepare a 11 sketch, all co-owners' names have to be reflected.
All the values that you want to produce a
You have to produce?
survey sketch.
Uh,
Survey sketch for our revenue survey sketch for our plus purpose boundaries fix ಆಗುತ್ತೆ.
uh.
Until unless all these three departments together.
Hmm.
But they are not doing it.
No, in a partition suit, parties have arrived at a compromise. Now, they have agreed which portion is to be taken. Now, unless mutation is effected in the RTC, in aligning with the terms of the compromise decree, how a party can go forward and seek subdivision? Primarily, can't he name whether authorities are not bound to effect changes in the khata based on that compromise decree? Only show the extent in the revenue, RTC. Based on that, he will go and apply for 11 sketch and gets.
My father's is not fine. Three brothers will be partition by perfect. Let the revenue account here entitled to pay the account.
Just ensure.
Fixing of the boundaries. is concerned.
No, that has to be done by way of 11 sketch. No. Now state is opposing. Their contention is that unless 11 sketch is prepared, you can't even get your name mutated to the RTC to the extent indicated in the compromise decree. No. Then,
Even in the recent judgment also, it says the revenue entry should not be compulsory to make it.
huh?
Recent judgment, what are not ready.
Yeah, yes, Mr. Alva. Mr. Alva. ಯಾರು ಲೋಕಲ್ ಬೆಂಗಳೂರು ಯಾರು ಮಾಡ್ತೀರಿ ನೀವು ಮಾಡ್ತೀರಾ? ಎಸ್ ಸರ್, ಯಾವ ಗುಡ್ ನೇಮ್? ಕನ್ವೆನ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತೀರಾ ಇಲ್ಲಿ ನೀವು ಬೆಂಗಳೂರಲ್ಲಿ? ಈಗ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಹಾಕಿ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ. Family members are allotted 1/3 share each ಅಂತ ತಿಳ್ಕೊಳ್ಳೋಣ. Under compromise decree, only one survey number. Now state is opposing. They say that you can't get your name entered based on a compromise decree. First you get L1 sketch ಅಂತ. L1 sketch ಅಂದ್ರೆ ಏನು? Subdivision ಅಲ್ವಾ?
Subdivision.
ಅದ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಫಸ್ಟ್ ಅವ್ರದ್ದು ಎಂಟ್ರಿ ಆಗ್ಬೇಕಲ್ಲ.
ಎಂಟ್ರಿ ಆಗ್ಬೇಕು ಮಲ್ಲಾಡ್. ಈಗ ಏನಾಗುತ್ತೆ subdivision ಅಂತ ಆದಾಗ ಮಲ್ಲಾಡ್.
I doubt whether I can do it or someone from survey department has to do it.
No. Unless there are 3 brothers. Let us presume that father's name is appearing in their RTC. The children's names are not mutated. They go and file a suit for partition. It is contested and it ends up in a compromise. As per compromise decree, 10 acres of land is divided in 3 parts. They say that all are entitled for 1/3 share. And probably they furnish a sketch also along with the compromise. Are they not entitled to get their name mutated to the revenue records, only reflecting 1/3 share each? Probably based on that, then they can approach the revenue authorities for further course of action. He says that they can't even get their name mutated based on a compromise decree.
Even
This
otherwise-
appears to be very,
Not even otherwise, basing on this compromise, they can approach the survey authority and get the sketch.
Yes.
That can be done.
ಮಲ್ಲಾಡ್.
Basing on this compromise,
ah,
they can approach the survey department and get the sketch prepared.
ಮಲ್ಲಾಡ್ one submission.
and then
Then they have to go for registration. Because for registration, they insist on this.
no,
No,
what
registration we are not.
the partitions,
Partition.
compromise decree na partitions,
ಅದನ್ನ ಬಿಟ್ಟಿದೀವಿ.
it amounts to a final decree. ಅದು final decree ಅಲ್ವಾ?
ಮಲ್ಲಾಡ್.
Final degree ಆದ್ರೂ
One
ಕೂಡ again it requires
ಇವ್ರದ್ದೇ
registration.
ನಾನು
No.
ಆದ್ಮೇಲೆ
Final decree, no, pre-existing right.
ರಿಟ್ ಪಿಟಿಷನ್ ಮಲ್ಲಾಡ್. ರಿಟ್ ಪಿಟಿಷನ್ 20 ಪೇಜ್ ನಂಬರ್ 21 ಅದ್ರಲ್ಲಿ ನಾನು ಒಂದು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತೀನಿ.
Ah,
ರಿಟ್ ಪಿಟಿಷನ್ ರನ್ನಿಂಗ್ ಪೇಜ್ 21 ಅದ್ರಲ್ಲಿ ನಾನು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡ್ತೀನಿ.
page 21.
Please, ma'am. ಇದರಲ್ಲಿ my lord, B schedule property petitioner ಹೋಗಿದೆ. The B schedule property is been alerted to the petitioner, my lord. Here what happened, my lord? 43/1 ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 2 ಎಕರೆ. 33 ಗುಂಟೆಯಲ್ಲಿ 35 ಗುಂಟೆ ಪೈಕಿ 8 ಗುಂಟೆ ಜಮೀನಿಗೆ ಚೆಕ್ಕು ಬಂದಿ ಅಂತ ಕೊಡ್ತಾರೆ. ಇವರು ಪ್ರಿಪೇರ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. Here my lord 43.1 ಅಂತಿರೋದನ್ನ ಅಗೇನ್ ನಾವು ಅದನ್ನ ಸಬ್ ಡಿವಿಷನ್ ಮಾಡಬೇಕು. 43/1 P ಆಗ್ಬೋದು, 2 ಆಗ್ಬೋದು, ಆ ತರ ಆಗುತ್ತೆ. ಅವಾಗ ನಾವಿಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಕ್ ಹೋದಾಗ ನಾವು ಇದ್ರಲ್ಲಿ ಏನು ರೆವಿನ್ಯೂ ಎಂಟ್ರಿ ಮಾಡಕ್ ಆಗದೇ ಇಲ್ಲ. ಎಲ್ಲಾರ ನೇಮು ಸೋರಿಸಬೇಕಾಗುತ್ತೆ. ದೇರ್ ಫೋರ್ ಫಸ್ಟ್ ಪೋಡಿ ಮಾಡಿ then we will come to the entry. This is the problem we are facing, my lord.
They have to approach the assistant director of land.
Because that's why, my lord, the coordinator bench of this honorable court, my lord, private surveyor na ನೀವು engage ಮಾಡ್ಕೊಂಡು ನೀವೇ ಸರ್ವೆ ಮಾಡ್ಕೊಂಡು ತಗೊಂಬಂದ್ ಕೊಡಿ, ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದೀವಿ.
All right, no. Here, under compromise decree, actually extents with boundaries are reflected.
Please, man.
Maybe you're right, maybe.
Please.
Yes, sir.
It is an Excel sheet. I have already made an attempt to apply for 11 scale. There is a clear circular issued by the government, my lord, which implements the applicant, my lord, unless and until there is name in the Pani entered, my lord, I cannot apply it. I have also tried it, my lord, an Excel sheet, kindly see. Page number 26.
ಇಲ್ಲ ನೀವು ಡೈರೆಕ್ಷನ್ ಕೊಡಿ, my lord, ಮಾಡ್ತಾರೆ. As per this, my lord, direction may be issue, my lord, they will give, my lord.
That is also placed on record now.
Yes, no, here it is, here it is. I am putting it.
Today, place it on record, place it on record.
ಕೊಡಿ.
All right, we'll hear it on Tuesday.
Please,
Mangalar ಹಾಕ್ಕೊಡ್ತೀನಿ.
please, man. Please, man.
Ah, preliminary. ಬರ್ಕೊಡ್ರಿ. List this matter in preliminary on Tuesday.
ಅಷ್ಟ ನಾನು ಸರ್ವೇಯರ್ ಹತ್ರ ಇನ್ನೊಂದ್ಸಲ ಅದನ್ನ ತರಿಸ್ತೀನಿ, ಇದನ್ನ ಕೇಳ್ಕೊಳ್ತೀನಿ. ಅದು
ಅಲ್ಲ
ಯಾವ
ಮಾಡ್ಬೋದು. You have a point in this case.
ಪ್ಲೀಸ್.
But I'll tell you, there are instances where a technical land is ends up in a compromise. Plaintiff and defendant take five acre
Please.
each. All right. There, they say 5 acre each. Sketch is not produced.
ಅವಾಗ ಬೇಡ, ಇಂಥದ್ರಲ್ಲಿ ಆಗುತ್ತೆ.
Then ನಾವು ಅದನ್ನೆಲ್ಲ distinguish ಮಾಡಿ ಬರಿಬೇಕು.
ಬರಿಬೇಕು, ಅದನ್ನ ಬರೆದ್ರೆ ಒಳ್ಳೇದು.
ಇಲ್ಲಿ you are 100% right.
ಪ್ಲೀಸ್, ಮೇಡಮ್.
ಯಾಕಂದ್ರೆ extent with the boundaries ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರೆ.
So in terms of this compromise, that sketch has to be, division has to be effected by the ADLR.
ಹೌದು.
Then post division again, there will be change in the revenue,
ಎಸ್ ಮ್ಯಾಮ್.
survey number,
ಎಸ್ ಮ್ಯಾಮ್.
Tuesday.
ಪ್ಲೀಸ್.
8, Gopal Krishnamurthy. Yes.
Notice that he has recorded his own order by excessive KLR, saying that the earlier report submitted to the response number 2 that is issued that. So that is not correct. But even without issuing the notice to the petitioner, that he has recorded his own order and he has cancelled the earlier order.
What was the earlier order?
But in relation with this petitioner. That's what we can do. You can share.
All right, all right. And what the private respondents here?
ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಲ್ಲ
Ilva,
ಇದ್ರಲ್ಲ.
idara.
ಅಲ್ಲ ಇದರಲ್ಲಿ
Had the consumer petitioner.
ಇಲ್ಲ.
Petitioner is agreed by the order passed by first respondent assistant commissioner Mandamus. Council would bring to the notice of this court that first respondent assistant commissioner, having allowed an appeal while ordered dated 6 April 2024, has recalled the order in gross violation of principles of natural justice. Petitioner is aggrieved by the order on the ground that this order is passed without notifying the petitioners. I find some force in the submission made by learned counsel for petitioner. Matter requires consideration for the reasons stated supra. The impugned order dated so and so as per Annex A passed by first respondent is stayed until further orders. Learned SCGP is directed to accept notice to respondents 1 and 2 issue emergency notice to respondent. 3 and 4, yes.
Is not enough for the petitioner to expect.
Yes, Mr. Alva,
ಹೇಮಾವತಿ ರಿವರ್ಸ್ HR.
covered by. ಏನಿದು? Only one reason?
ಮರಮಲ್
ಮರ ಮಾತ್ರನಾ?
ಮರಮಲ್.
We've lost lands, sir. You have lost your lands, ancestral lands in this project?
Now they have.
The correct, this land was allotted to you in compensation.
They had lost land, submerged the.
Work order. Landed SCGP is directed to accept notice to respondents. 1 to 8. Petitioner is agreed by the impugned order passed by third respondent. Provided annexure A. By the counsel for petitioner and landed SCGP appearing for respondent state. Peruse the records. Facts leading to the case are as ended. The state reserved lands for granting the same to the displaced persons who had lost their lands due to submergence of on account of implementation of Hemavati Reservoir project. Petitioner contends that that her mother-in-law lost lands and she was accordingly granted the present petition land under rehabilitation package. Petitioner claims that the fifth respondent issued a Sagolicit pursuant to grant made by who granted fourth respondent?
Land was granted by this third respondent.
Third respondent. The third respondent, the third respondent special land acquisition officer on the premises that petitioner has failed to deposit the value of the value of the trees grown in the land granted to petitioner has proceeded to cancel the grant. Next, the coordinate bench in identical cases has set aside the orders passed by this special land acquisition officer only on the premises that the cancellation of grant is not preceded by an inquiry. The case on hand is squarely covered. The case on hand and the facts are identical and squarely covered in the light of the judgment rendered by the coordinate bench. In the present case also, the third respondent, special land acquisition officer, has unilaterally cancelled the grant without notifying the petitioner. Since the order under challenge is not preceded by an inquiry, this court is of the view that the impugned order under challenge is not sustainable. For the foregoing reasons, this court finds with the following order. Writ petition is allowed. Impugned order passed by third respondent dated so and so is hereby quashed and set aside. Next, tell us assembly. Roman 3 to 6. All three. Yes, sir.
Question matter serial number 12. Yes, but.
These appeals are not yet admitted. Partition.
Now, partition, declaration and position. Appeal was filed, both the RFIs were filed in the year 2013. I am the contesting respondent in the trial court also and here.
You appear for the plaintiff.
Not, I appear for the defendant. There in the trial court, I appear
These appeals are by plaintiff or what?
plaintiff. One One judgment, two appeals have been come now.
Why two appeals?
Two sets of defendants have there. One plaintiff has filed, another one is filed by the defendant. Both the suit came to be
You know,
dismissed.
who has died?
ಸುಮಾರು ಜನ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ so many respondents have been died. ಕೆಲವರು LRC ಇನ್ನು ಬಂದಿಲ್ಲ, ಕೆಲವರಲ್ಲಿ ಇನ್ನು ತಗೊಂಡಿಲ್ಲ ಸ್ಟೆಪ್ಸ್.
You have to take steps now, whether notice has to be ordered on this
ನೋಟಿಸ್ ಹೋಗಿ
application.
ಬಂದಿದೆ ಸುಮ್ಮನೆ ಒಂದ್ಸಲಿ ಹೋಗಿ ಬಂದಿರೋದು ಕೆಲವರಿಗೆ.
ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರಲ್ರಿ, ಸುನಿಲ್ ನಾರಾಯಣ್
IPR for respondents 1, 3 to ABC.
to second respondent has died.
ಅದಾಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರ LRSಗೆ application I have filed, I filed ವಕಾಲತ್ on the
We'll
application.
allow this application.
That application can be allowed.
Barcode. Second respondent has died. Applications are filed. Notice on LR applications are served on the proposed LRs. Council appearing for proposed LRs submits no objection. Accepting the cause made in the affidavit filed in support of I-1 of 2017. This court is of the view that delay in filing LR application needs to be condoned in the interest of justice. Accordingly, accepting cause, delay of 414 days in filing LR application is condoned. Consequently, abatement is set aside. Appellants are permitted to bring the legal heirs of disease R2 on record. Similarly, respond number 8, ಅದೇನಾಗಿದೆ 8 notice
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ. I am not
notice ಹೋಗ್ಬೇಕಾ? Notice ಹೋಗ್ಬೇಕಾ?
ನೋಟಿಸ್ ಹೋಗಿ ಬಂದಿದೆ ಒಂದ್ಸಲಿ, ಇನ್ನೊಂದ್ಸಲಿ ತಗೋಬೇಕಾಗ್ತದೆ ಪುನಃ ನೋಟಿಸ್.
ಎಲ್ಲಿ ಏನು ತೋರಿಸೇ ಇಲ್ಲಲ್ಲ ಅವರು. What is that?
ಇದೆ ಸುಮ್ಮನೆ.
Serve ಆಗಿದೆಯಾ? Finally, week's time is granted to take fresh steps to propose LRs of diseased R8. We will see. First, no. First, PF to be paid within 1 week. If PF is in order, official issue notice to the proposed LRs of respond number 8. Yes. Next.
Number 13. Then Madhusudan.
No time, sir. Delay in filing? Admit ಆಗಿಲ್ವಾ? ಅಲ್ಲ delay in filing ಇದು? There is delay of 515 days in filing this appeal. There is no contest to the application filed in I-1 of 2015, accepting the cause. The delay of 515 days is condoned subject to appellant depositing a cost of 1,000 to the clerk's welfare fund. Both the appeals are admitted. The lead appeal is admitted. Paper book ಹಾಕಿದಾರೆ ಅದರಲ್ಲಿ. Paper book dispense with ಯಾಕೆ ಮಾಡ್ತಾರೆ? Injunction suit, partition. ಅದು 2014. Final hearing ಯಾವ್ದೀಗ ನಾವು ಯಾವ ಹೋಗ್ಬೋದು? Final hearing. Yes, next. ಯಾವುದು? Mister, you have to file paper book in third matter, 13.2. Finally, allu steps ತಗೋಬೇಕು. Finally, 2 weeks time to take steps in respect of disease R2. Finally, 4 weeks time is granted. ಅಲ್ಲ ಎಷ್ಟು adjournment ತಗೊಂಡಿದ್ದೀರಾ? Finally, 4 weeks time is granted to file paper book, subject to payment of cost of 1,000 rupees. ಇದಕ್ಕೂ ಅಷ್ಟೇ. Next.
Number 14.
Yes, sir.
13th respondent.
Arvind. ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ತಗೊಂಡ್ ಬಂದ್ರಾ?
I
ಅದೇ
commence.
ಕೇಸ್ ಅಲ್ಲ ಇದು?
ಹೌದು,
ಹಾ. Where is the family tree, sir? Today?
ಇಲ್ಲಿದೆ. I am filing. Copy ಕೊಡಿ ಅವರಿಗೆ. ಇತ್ತು. ಎಲ್ಲ ಒಂದೇ. I have filed family tree as well as a list of dates and events which
Thank
are necessary
Yes,
to decide when succession opened up in the family.
yes, sir.
Now please turn to page number 3.
Let him argue, Arvind, or Madlu.
ಆಗ್ಬೋದು,
Let him argue.
ಆಗ್ಬೋದು.
This appeal is by whom, sir? Plaintiff's
Right.
appeal. Good for partition. Not in dispute.
Vote for partition after the only property was sold by the brother.
Yes, sir. Aito, you allow him, you allow Sadashivappa sir to argue, Mr. Sitaram Rao. One property. Yes. Originally, this property was owned by whom? By the father. Who has sold? What is the date of sale date?
2 sons.
2 sons.
3595, my lord.
95 sale.
3595 is the sale date. Sharabalingam died on 17/5/1949 before Hindu
Oh,
succession.
14.
Yes.
And when the widow died? ಆಮೇಲೆ ತಾಯಿ ಯಾವಾಗ ತೀರೋದ್ರು? ಇಲ್ಲಾಂದ್ರೆ if mother was alive, then Daya Singh versus Dankor, 1934 judgment.
Mother died in 67,
67,
1967.
ಇದು this matter purchase from where? ಏರ್ ಬರಲ್ಲ ಇದು, ಬಾಂಬೆ ಸ್ಕೂಲ್ ಅಲ್ಲ,
Bangalore.
ಬ್ಯಾಂಗ್ಳೂರು, ಮೈಸೂರು ಕರ್ನಾಟಕ. ಹೆಣ್ಮಕ್ಳಿಗೆ ಏನು ಕೊಡಲ್ಲ ನೀವು. ಏನ್ರಿ ಸೀತಾರಾಮರಾವ್ ಅವ್ರೆ, ಜಾನ್ರು ಎಲ್ಲ.
ಇಲ್ಲ ಪಾಪ ನಮ್ ಕ್ಲೈಂಟ್ ಸತ್ತೋದ್ರು, ತುಂಬಾ ನೈಸ್ ಮನುಷ್ಯ, ಇವ್ರ ತರನೇ ಮಾರ್ದಾಗ ಎಲ್ಲಾ ಹೆಣ್ಣು ಮಕ್ಕಳು ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವರು ಈ ಹೆಣ್ಮಕ್ಳು ಒಪ್ಕೊಂಡ್ರು, ಅವ್ರ ಮಗ ಒಪ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಬಂದು
It's a pure question of law.
ಎಸ್.
Yes, sir. Sadashivappa sir. What are the grounds urged by you now? Now propositors, yardidu, who died? Sarbalingama Naidu. He died in 1949.
1949 May 17th.
And the daughters, now the suit is filed by daughters.
Yes, married daughters who were married before the Succession Act came into force.
That's a short point. What big point, sir? A codification 1956. No. ಅದು that ಸದಾಶಿವಪ್ಪ ಸರ್, ನೀವು ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ 2005 ಅಮೆಂಡ್ಮೆಂಟ್ ಇದಕ್ಕೆ ಅಪ್ಲೈ ಮಾಡಬೇಡಿ. ಸಕ್ಸೆಷನ್ ಓಪನ್ ಇನ್ 1949, ವೆಸ್ಟಿಂಗ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಕೋಡಿಫಿಕೇಶನ್ ಇಸ್ ಇನ್ 1956 ತಗೊಂಡಿರೋದು. ಸೇವಿಂಗ್ ಕ್ಲಾಸ್ ಇರ್ಬೇಕಲ್ಲ 1956 ಆಕ್ಟ್ ಅಲ್ಲಿ.
ಹೌದು.
56 Act apply ಆಗೋದಿಲ್ಲ. There is another act by name Mysore Hindu Women's Right to Property Act. According to section 4 of that act.
ಅದು ಡಾಟರ್ಸ್ ಬರಲ್ಲ, ಅದು ವಿಡೋಗ್ ಮಾತ್ರ ಬರೋದು.
ಅದರಲ್ಲಿ there is a list. Daughters come at the 3rd place, sons come at 1st place, widow comes at 2nd place. And what important thing to be noted is the law says in this order. In this order ಅಂದ್ರೆ ಮೊದಲು A, ಆಮೇಲೆ B, ಆಮೇಲೆ C. That is in this order.
ಅಲ್ಲಿ ಮೇಲ್ ಸನ್ಸ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬರುತ್ತೀರಿ ಅದು ಆರ್ಡರ್. ಇಟ್ ಇಸ್ ದಟ್ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಇರಬೇಕು. ಕೊಡಿ.
Yes.
ಕೊಡಿ.
If sons are there,
then exclusion. Not simultaneously.
Not simultaneously. That was.
ಮತ್ತೆ simultaneous ಬರಲ್ಲ ಇದು.
Simultaneously ಬರೋದಿಲ್ಲ. ನಾನು ಹೇಳ್ತಾ ಇದ್ದೆ.
First sons.
In that order. A, B, then C. C, daughters are at C.
this fell for consideration of this on court. in M.N. Venkateshaya's versus G.N. Krishnappa's case,
ಎಲ್ಲಿದೆ judgment?
1990 Part 4 KLJ 579 Division Bench Judgment.
ನನ್ನ ಪೇಪರ್ ಬುಕ್ ಜೊತೆ
It
ನಾನು
is
citations
cited
ಕೊಟ್ಟಿದ್ದೀನಿ.
in para 21 of the judgment, the
Wait,
trial.
now Sadashiv has cited a judgment, sir. One ನಿಮಿಷ. Yes, sir.
Case my lord. The other guys, right tonight.
Yes.
My lord, in leave. May I request Mr. Sadashivappa through my lords to
On ಮಾಡಿ,
use
mic on ಮಾಡಿ. He's not able to.
1937 Act, the learned judge considers it and passes this order, my lord. Section 3, Hindu male dying interstate in 1941. Held, his widow and daughters become his heirs, and other members of the joint family had no claim against them. In the instant case, my lord, as I submitted to my lord, there is no dispute among the relationship between the parties except the 13th defendant. 13th defendant is the one who has purchased it from the first defendant. Only one defendant. And in fact, at the time, it is also come in the pleadings and also in the notice that they offered 1 lakh rupee to each of the sister. I just take my lord's attention to that pleading also. In the instant case, my lord finds the appeal under section 100, this is under second appeal, 100, has been filed by defendants 1 and 2 against the plaintiffs 2 to 4. Plaintiff 1 is since deceased. The first plaintiff is the mother. 2 to 4 are the daughters of the first plaintiff. They filed a suit before the principal municip Dharwad against 6 defendants for partition and separate possession of their shares. The trial court decreed the plaintiff's suit and granted the plaintiff's 1/3 share in the suit scheduled properties. The defendants 1 and 2 agreed by the judgment and decree passed by the trial court, preferred an appeal before the principal civil judge Dharwad. The appeal preferred by the defendants 1 and 2 was dismissed. Defendants 1 and 2 have filed the present second appeal. The suit properties are 3 items, A, B, and C. Items A and B are residential buildings. In this case, it is necessary to set out the family pedigree, which is as follows. I just skip off that, not necessary to read it. Then my lord could say it should be borne in mind that the first plaintiff, Chandrava, is the wife of Hanumantappa. Hanumantappa died in the year 1941 itself. The present suit, out of which the present second appeal arises, was filed in 1987, after the Hindu Succession Act came into force. In the court, it is contended that in view of Section 23 of the Hindu Succession Act, 1956, which insofar as it is relevant for our present purpose, says that the right of any female heir to claim partition of the dwelling house shall not arise until the male heirs choose to divide their respective shares in the dwelling house. The suit was not maintainable. It was the contention there. In this court, it is contended by the learned counsel for the appellants, defendants 1 and 2, that in view of Section 23 of the Hindu Succession Act, 1956, the suit filed by the female heirs was not maintainable. The plea has not been taken in the written statement. This is entirely a new plea urged before this court. I have already stated that the suit was filed as far back as 1987, and an entirely new plea cannot be permitted to be taken up by the appellant defendants at this stage. In law also, the plea raised before this court by the learned counsel for the appellants defendants 1 and 2 cannot be accepted. I have already stated that the first plaintiff's husband died
in the year 1947 itself, 41 itself, long prior to the coming into the force of Hindu Succession Act 1956. In view of the Hindu Women's Right to Property Act 18 of 1937, the first plaintiff became the heir to her late husband, along with her daughters. The succession to the estate of her late husband, Hanumantappa, opened in the year 1941 before the Hindu Succession Act came into force. The Calcutta High Court in Upendranath Das versus Chintamani Devi has held, where a Hindu dies intestate before the Act 1956 came into operation, leaving a widow and 2 sons. The succession to his estate, so far as the widow is concerned, is governed by the Hindu Women's Right to Property Act 1937, and she became a heir to her late husband, along with his sons in equal shares on the 12th June 1956. With regard to all his properties other than the agricultural lands under the Act 18 of 1937, as such, the widow has unrestricted power of claiming partition of all the properties which she intends, including dwelling house left by her husband. That right is not taken away by Section 23 or of the provisions of the Act 1956. I agree with the view taken by the Calcutta High Court. It is argued by the London Council for the respondents plaintiffs that Section 23 of the Hindu Succession Act comes into play only if there is only one dwelling house and not if there is more than one. Plain schedule shows 2 dwelling houses within bracket. It is not necessary to this court to pronounce on this point. For the aforesaid reasons, in my opinion, no substantial question of law arises, so and so dismissed. Therefore, my submission to my lord is, as on the date Sharbalingam died, wife and the children were their daughters. Totally, he has 2 sons and 3 sons. Of course, one died. 2 sons and 6 daughters. And here, in this case, the 2 daughters are claiming the right. Now, when the one and the only dwelling house was sought or in fact sold to the 13th defendant, so the cause of action arose under Section 23 only when it was sold, not earlier to that. Having regard to the fact that the father dies, irrespective whether son or the daughter, all of them being the self-acquired property of Sharbalingam, all of them equally share. Under these circumstances, whether
under 33 Act or 37 Act, daughters are not entitled. Only widow, only widow.
Well, presuming for sake of argument.
Only widow.
only
Daughters are not entitled for it. It's only after codification, sir. Daughters will get a right only post 1956, not prior to that.
My lord, the law.
Examine it. When widow died, where are the pleadings?
Yes.
Lakshmi Kantama, when she died, what are her pleadings?
Yes.
Actually, you made a statement that she predeceased her husband,
Yes.
while Arvind is making a statement that she died in 1950,
49.
49,
66. You said
And that is from wife.
1966 here.
67.
67. Now, where are the pleadings? Plaint togoli nodana. Where the plaints?
Plaint ಅವರು equal rights ಕೇಳಿರೋರು, not the share of the mother.
Huh?
Share of the mother ಕೇಳಿಲ್ಲ. There is no pleadings. If they had sought for share of the mother, that would have been different. They claim equal rights with the brothers.
ಆಯ್ತು, ultimately ನಾವು quantify ಮಾಡಬೇಕಲ್ಲ. Question is whether widow is entitled for a share in the present case or not. That is the question. And you cited one judgment. Which is the judgment? Which is Sitaram Rao.
But,
ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ಜಡ್ಜ್ಮೆಂಟ್.
On video ಕೊಡಕ್ ಬರೋದು.
ಸೈಟ್ ಮಾಡಿ ಅದು ನೋಡೋಣ. We'll get that.
ಸ್ವಲ್ಪ ಕಷ್ಟ ಇತ್ತು, physically
ಈಗ
difficult.
ಸೈಟ್ ಮಾಡಿದ್ರಲ್ಲ ನೀವು.
I'm furnishing. Para 21 ನಲ್ಲಿ judgment of the trial court, where I like
ಬಂದಿದೆಯಾ?
para 21 of the judgment, Marat,
Yes.
ಇದರಲ್ಲಿ
21, 1990 part 4, KLJ 579. ತಗೊಳ್ರಿ ಅದು ನೋಡೋಣ.
Next judgment may also be relevant, my lord. 1992 to KLJ 548, again division bench.
548. Division bench, 1992, volume 2, KLJ 548.
For the sake of argument, my lord. If widow alone were
ಅದು
to,
ದಯಾಸಿಂಗ್ ವರ್ಸಸ್ ದನ್ಕೋರ್ ಜಡ್ಮೆಂಟ್ 1974. ತಗೊಳ್ರಿ ಅದೊಂದು ತಗೊಳ್ರಿ. AR 1974 SC 514. Get that judgment out. Arvind, you are supporting plaintiff. You are supporting plaintiff.
No, no, no.
who has
How
pur-
can you
who has
support
purchased,
Huh?
he has purchased it.
You are
He has-
purchased.
Yes,
Purchased.
from the
You are the
first-
purchaser.
purchaser?
the-
I am on.
You are the interested
Mr.
party.
Sitaram, he appears for other LRs.
Yeah.
Sitaram, Mr. Sitaram, who is on the video.
Ah.
Because he has sold, perhaps he supports.
No,
Buyer.
it's a pure question of law.
Sir, I can't be letting down my buyer, sir.
It's a pure question of law.
Hello?
If a widow was alive and there are pleadings in the plain,
My lord,
there are pleadings indicating when she died. If she died post husband, we'll examine what should be, how it has to be dealt. Now in both these, the division bench judgments, Mr. Sitaram Rao,
Yes, ma'am.
whether it says that widow will also not get any right if there are a male co-partner. If sons are there, she will not take
my lord,
together
here,
under
the question
1933 or
of
37 Act.
co-partner does not arise.
Is a self-acquired
Co-partner does not arise because it's self-acquisition of the father.
father. All right.
That self-acquired.
Therefore,
sir,
even
all
when
that come into
Vinuta
play.
Sharma and all those cases.
Allah,
also-
before codification,
Before
who would have succeeded?
Well-
Only the male members would have.
Only sons.
Only sons.
1986 Act ಮುಂಚೆ ಕುಡಿಪಡಿತ ಬರಕ್ ಮುಂಚೆ what was the scenario ಅಂತ
If Sitaram Rao,
Please, brother.
if widow was alive,
Yes,
died
brother.
post 1956,
Yes, brother.
then how it has to be dealt?
My lord, she during her lifetime had a share. If the sons had partitioned, no such has occurred.
Allah, merely because she died, as in the date of filing of suit, if she was not alive, will it,
Yes.
that
But
may
I-
not take away the rights?
Notional partition would not arise in this case because the property had already vested in the sons.
ಇಲ್ಲ it is not
Along
Whereas-
with mother, along with mother.
Not along with mother, not along with mother. She is
No,
at
no,
B.
mother had no share at all. Mother had a right. If there were to be a partition in the only dwelling house, she had a share. There was no such partition. Limited right which she had is also exhausted on her death. Therefore, she had no right to seek for partition or claim a share.
May I request, please see section 4,
ಯಾವುದು?
section 4 of that act.
Section 4.
Section
Then
4.
ಅಲ್ಲ ಬೋತ್ ಈ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 4 ಹಿಂದೂ ಸಕ್ಸೆಷನ್ ಆಕ್ಟ್ ಹಿಂದೂ ಲಾ ವುಮೆನ್ಸ್ ರೈಟ್ ಟು 1933 1937 ಎಲ್ಲ ಡಿಸ್ಕಸ್ ಆಗಿದೆ ಎರಡು ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಅದೇ ಓದ್ಬಿಡೋಣ. Sitaram
Please.
Rao, which paragraph we have to read? Which is the relevant paragraph?
ಆಫ್ ದಿ ಜಡ್ಮೆಂಟ್.
ಮೈಸೂರು section 4 ಸಾಮಾನ್ಯ ಪ್ರಕಾರ ಬಟ್ ವಿರೋ ಬದುಕಿದ್ಲು ಒನ್ ಆಫ್ ದ ಅನಿಮಲ್ ಡಾಕ್ಟರ್ ಬದುಕಿದ್ಲು ನೋ ಪಾರ್ಟಿಷನ್ ಸ್ಟೇಟ್ ಅಂಡ್ ಪ್ಲೇಸ್ ಇದ್ರ ಪ್ರಕಾರ
Section 4 of code deals with succession, my lord, that's all. Inheritance.
ಸಿಗ್ತಾ ಜಮೀನ್ ಸಿಗ್ತದೆ.
ಎಲ್ಲ ಇಟ್ಬಿಟ್ಟಿದ್ದೀನಿ. 3 ಸೆಟ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಇದಾಗ್ತದೆ. ಸೆವೆನ್ ಲ್ಯಾಕ್ 60 ಲಕ್ಷ. ಸೆಟ್ ಇದೆ 4 ಸೆಟ್ ಇದೆ.
ಇದು ಪ್ರಯೋಜನ ಅಂತ ನಮ್ಮ ಅಗೇನ್ಸ್ಟ್ ಹೇಳಿಲ್ಲ. ನಿಮ್ದು ಬೇರೆ. Forty-six. ಇದು 46.
Yes, Mr. Arvind, what is your argument?
So please take the family tree. The dates are not in dispute. The propositors died in 1949 before coming into Act of Hindu Succession Act. Then succession opened up in the family. He had 2 male children and rest others are daughters. The property came to 2 sons to the exclusion of daughters.
Yes.
Section 4 and subsection 2 of section 6 applies.
Yes, sir. Section 4.
Section 4 and subsection 2 of section 6 apply.
Section 6.
Section 4 says, the succession to Hindu male dying intestate shall, in the first place, vest in the members of the family of the propositors below in the following order. In the following order, A is male issue to third generation.
Correct.
If there are male issues to the third generation, then the succession does not go to next stage.
Next.
So daughters are at.
They are
place num-
vertical, ಅದು vertical ಕೊಟ್ಟಿದ್ದಾರೆ, horizontal ಕೊಟ್ಟಿಲ್ಲ.
ಹೌದು.
Not
Place
simultaneous.
number 3. Place number 3. Compare this, the language employed in this section with section 9 of Hindu Succession Act. The word used in section 9 of Hindu Succession Act is simultaneously.
Correct.
ಎಲ್ಲರಿಗೂ ಜೊತೆಯಾಗಿ. So employment of different language indicate different intention of the parliament. Order of succession among heirs in the first schedule. Among the heirs specified in the schedule, those in class 1 shall take simultaneously and to the exclusion of all other heirs. This language is not employed in section 4. This excludes daughters. Now I rely upon 3 judgments. Sorry, copy. There are 2 judgments with the same cause title. Annamaya versus Patama. The one by learned single judge was in MFA. Annama filed suit under similar circumstances. She sought for declaration and partition.
Annama was daughter.
An order of temporary injunction was not passed in her favor. Therefore, she approached High Court.
Yes.
Now, please see the first paragraph. These were the questions framed by the learned judge. Question number 1 to 4. Whether there can be any order of temporary injunction in respect of a property wherein plaintiff claimed that they have an undivided share. Whether as per section 6, subsection 2, read with section 4 of Mysore Hindu Women's So-and-so Act, the plaintiffs are entitled to succession to the property. Number 3, whether the succession should go according to the order as mentioned in those 2 sections by way of succession or by survivorship. Whether as per section 6(2) of the Act, in spite of the word used male or female, can it be said that both male and female succeeds to the property simultaneously? All these questions were answered in the negative. The discussion starts from para 18. At page number 17, not 8. According to me, even if section 6(2) and section 4 read with section 3(j) of the Act are read together, by virtue of Chinnappa Mudliyar's death, the succession will be only in order as mentioned in section 6(2) of the Act, that is male or female and not male and female. Secondly, order of succession shall be in the case a male died intestate, succession is first by sons who excludes widow. If son is dead, widow succeeds, and if both are dead, then daughter. Widow excludes daughters, and if son and widow are absent, then daughters succeed. This portion has been further clarified in the case reported by this court in so and so, then the section is quoted.
Yes.
Thus, I have to hold that succession takes place not simultaneously by both male and female as contended by Sri so and so, but it shall be only in accordance with the order as mentioned in section 4 of the Act. Thus, succession not by survivorship, but by succession. Of course, as far as possession is concerned, the same is not disputed by so and so. Rest other things are not relevant. They relate to possession.
All the judgments directly on that point.
Directly on the point. Then the matter came back to civil court. Civil court decided in favor of Patama. So Anama suit was dismissed. Then and again appeal was preferred. That is the next citation. Para 7 onwards may please be seen.
Para 11, I think. Para 11.
Yes, para 11. That answers the question. Then there is a judgment of the Supreme Court also. In the very head note itself, the succession to Hindu male dying intestate shall vest only in the widow under section 412 of the exclusion of daughters who are mentioned in subsequent clause, that is clause 3.
Allied laws. 1937 Act 33 Act. Yes, Arvind sir.
Yes, that's all my argument.
Either Supreme Court judgment, which paragraph you are relying?
Head note dalle ide.
Head note dalle ide.
The succession to male Hindu dying intestate shall vest only in the widow under section 412. Because it was between widow and daughters.
Clear.
Same proportion.
ಅವ್ರು ಮುಗಿಸಿದ್ರೆ ಹೇಳ್ತಾರೆ.
So this legal portion, this legal portion clinches the issue in my favor.
My lord may accept that as on the date of the death of Mr. the owner,
Sharabalingam.
widow was there.
No, where are the pleadings? No pleadings.
My lord,
ಎಲ್ಲಿ ಪ್ಲೇಟ್ ಓದಿ ನೋಡೋಣ.
ಅಲ್ಲ ಈಗ ಅವರೇ ಹೇಳಿದ್ರಲ್ಲ 67 ಅಲ್ಲ
ಅವ್ರು ಹಂಗ ಅವ್ರು ಅಡ್ವೊಕೇಟ್ ಅಡ್ಮಿಷನ್
ಅಲ್ಲ ನಮ್ಮನ್ನೇ ಮತ್ತೆ ತಾವು ಕೇಳೋದು.
There is no such claim.
ನೋ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಅದೆಲ್ಲ ಬರಲ್ಲ.
There is no
recap them.
ಅಲ್ಲ
Improve your case.
they don't dispute about the death.
We'll read your plaint. We'll read your plaint.
Yes.
Where is the plaint?
ಅಲ್ಲ before I could read it, I put it this way, that as on the date when he died, his wife and children were available.
ಅಲ್ಲ ಇದ್ರು it says orderly. The widow exclusion. Widow is also excluded.
Exclusion in law is one thing. What I am respectfully submit is, if widow were to be there, she inherits it. Either under 33 Act or under 37 Act or 1956 Act.
No, she will not.
There are 3.
ಅಲ್ಲ Supreme Court judgment says there is exclusion.
Exclusion.
Both the right to succession of daughters is thereby excluded in view of order of succession prescribed under section 4(1) of 1933 Act. Supreme Court judgment directly on that point.
There are 3 acts, my lord, altogether. 33, 37, 56.
Yes.
These are the 3 acts governing the succession.
Yes, sir.
Now, since he died, all this difficulty is because he died before 1956. If he had died after 1956, there would not have been any dispute at all because all of them were entitled
Yes.
equal share.
Simultaneous.
Wives simultaneously, wife and the children.
ಎಲ್ಲಿ?
If Sharwal,
56 ನಂತರ ಆಗಿದ್ರೆ
ನಾನು ಹೇಳ್ತಾ ಇರೋದು 56 ನಲ್ಲಿಗಿಂತ
There's no
ಮೊದಲು
confusion. Section 8.
question is not
Count
when,
heads.
question is not when he died. Question because there was only one dwelling house. No, I'll come to that.
when he died.
The
First
reason-
time there is a succession opened up.
ಅವ್ರು ಆಯ್ತು ಅಂತಾರೆ ಈಗ ಮತ್ತೆ ಮಾತಾಡ್ತಾರೆ. ನಾವೇನ್ ಹೇಳ್ಬೇಕು?
All right, it's all deliberations. We'll go slow. It's a first appeal.
ಇಲ್ಲ ನಾವು
He must allow me to argue or they must argue.
Just a minute.
Yes.
What's the law on section 8 of Hindu Succession Act?
Yes.
Our
19
expert has interpreted it
Sadashiv
as the
doctor
prospective ಅಂತ
ಹೇಳ್ಬೇಕು.
ಹೇಳ್ತಿದ್ದಾರೆ.
1956 Act.
Section 8 is held to be prospective. There
Section,
is the matter.
section?
Section 8 is held to be prospective. There is a judgment.
My
That
lord,
was
now
subjected to,
prospective,
that was put to test before honorable apex.
now,
court.
Vinod Sharma's case, if you, my lord, looks into. Vinod
Yadu-
Sharma's case, Supreme Court will
that,
bring.
that is a totally different footing. You can't apply to.
No, no.
Sir, codification
this-
to,
For the sake of prospective and retrospective, I am speaking.
no, that,
Yeah,
Allah, Supreme Court judgment is section 8 male.
50?
Section 8 is held, it's prospective, section 8.
The one which submitted to my lord, if I may say with grace and respect,
Yes,
is also straight away on the point.
yaudu?
My lord Justice Vishwanath. This learned single judge.
Yenanta?
Good. ಅದಕ್ಕೆ ಅದು ನಾನು ತಮಗೆ ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದು ಅದನ್ನೇ ನಾನು.
ಅಲ್ಲಿ ನೋಡ್ರಿ ಮಕ್ಕಳಿಲ್ಲ ಅಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ ಅದು
ಅಲ್ಲ.
ಅಲ್ಲ ಬಟ್ ವಿ ಕಾಂಟ್ ರಿಲೈ ಆನ್ ದಿಸ್ ಜಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ದಿಸ್ ಕೋರ್ಟ್ ಇಸ್ ಬೌಂಡ್ ಬೈ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ದ ಅದರ್ ಟು ಜಜ್ಮೆಂಟ್ ಸೈಟೆಡ್ ಆರ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಇಫ್ ಐ ಆಮ್ ಕರೆಕ್ಟ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್
Yes.
In RFA.
But ಅದರಲ್ಲಿ
RFA. In RFA.
ಇದು
one unmarried daughter was also there. She was residing in the same house. Whether I could have sought for my share when they're all living in that house is a question. Cause of action for me arose only when they sold it, not prior to that. I never wanted to disturb my.
Sir, I'll tell you, we look at the family tree. This proposition is correct, 100% correct. This was a case where a Hindu male died, leaving behind a wife and 2 daughters. So the principle laid down by this court has no application to the present set of facts. In the present case on hand, there are 2 sons.
Of course,
That was the case where a male Hindu died, leaving behind a widow Chandrava and a pre-deceased son Shankar was not alive, and 3 daughters.
facts in each case differ, my lord.
Not only facts.
Only I am trying to put out.
No. In context of section 4 of 1933 Act, ಅಲ್ಲಿ ಮಕ್ಕಳೇ ಇರಲಿಲ್ಲ, ಗಂಡು ಮಕ್ಕಳು ಇರಲಿಲ್ಲ. ಅವಾಗ ಏನ್ ಮಾಡಬೇಕು, how it is to be dealt. So that principle may not apply to the case. ನೋಡಿ ಅದು ನೀವು ಯಾವ cited ಅಲ್ವಾ?
ಹೌದು.
ಅಲ್ಲಿ ನೋಡಿ ಅದು. Hanmantappa died in 1940, leaving behind wife Chandrava, plaintiff number 1. Shankar died. ಅದು ಯಾವಾಗ died ಅಂತ ಅದು ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅವರು. Section 3, Hindu male dying intestate. He is held his widow and daughters. And other members ಅಂದ್ರೆ ಅದು ಅವರ ರೆಸಿಡ್ಯೂರಿ ಅವರು revisionist had no right because widow was there.
Yes.
So vesting is deferred, and by 1956 Act, the widow gets the right.
If widow gets, daughters get.
No, because there were no sons.
After the death of widow.
ಅಲ್ಲ, you are mixing up. ಸದಾಶಿವಪ್ಪ ಸರ್, ಅಲ್ಲಿ ಗಂಡ್ ಮಕ್ಳು ಇರ್ಲಿಲ್ರಿ.
ಹೌದ್ರಿ, ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, ಈ ಕೇಸ್ ನಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ನಮ್ಮದ್ರಲ್ಲಿ ಇದಾರೆ.
ಅದೇನಂತಾರೆ ಅದು, widow will hold the estate. Vesting is deferred. Revisionist will not get any right till widow is alive. Then if she dies after 1956, property stays with that branch only, even if they are daughters.
So she died according to them after 1956.
No, according to them ಅಂತ ಬರಲ್ಲ ನೀವು.
66 ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
ಅವ್ರೇನೋ ಹಂಗೆ ರೆಕಾರ್ಡ್ ನೋಡದೆ ಹೇಳಿದ್ರು ಅವರು. ಹೇಳಿಬೇಕಾದ್ರೆ ಅರವಿಂದ್ ಅವ್ರದ್ದು it amounts to admission ಅಂದ್ರೆ ನಾವಿಲ್ಲ exam.
Typographical mistake.
Of course,
That is really
I may say with
Yeah, there is no pleading. There is no pleading. There is no pleading.
There is no
Pleading.
pleading.
ವಿಡೋ ಯಾವಾಗ ತೀರೋದ್ಲು ಅಂತ ಏನಿಲ್ಲ.
Written statement ನಲ್ಲೂ ಇಲ್ಲ, plaint ನಲ್ಲಂತೂ ಮೊದಲೇ.
ಅಲ್ಲ, ವಿಡೋ ಇದ್ರೂ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಇದೆ.
ಹೌದು.
ನಾವ್ ಹೇಳಿದ್ದಕ್ಕೆ ಎಸ್ ಅನ್ನೋದು ನಮ್ದು ಧರ್ಮ. ನಾವ್ ಹೇಳಿದ್ದಕ್ಕೆ ಎಸ್ ಅನ್ನೋದು ನಮ್ ಧರ್ಮ, ಅದಕ್ಕೆ ಸೀತಾರಾಮ್ ರಾಯರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು ಅಂತಾರಲ್ಲ ಅವರು. For a change is really accepting the court's view.
There is only one written statement by all the heirs, that is defendants 1 to 12. The 13th defendant, who is the buyer, he has filed a separate written statement. Except these 2 written statements before the court, there is nothing else. And also, evidence also only 2 witnesses, one on behalf of the plaintiff.
Why you want to refer to witness? It's a pure question of law. None of the parties were required to step into the witness box except plaintiff.
My lord.
It's a pure question of law. Admitted set of facts. ನೀವು ಒಂದು ಮಾಡಿದ್ರೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಲೀಡ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, ಮಾಡಿಲ್ಲ ಅವರು.
ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ.
ಇಲ್ಲ.
ಇಲ್ಲ ಬೋನಾಫೈಡ್
ಮಾಡಿದ್ರ ಅಂತ ತಾವೇ ಕೇಳ್ತೀರಿ ಮತ್ತೆ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ತಾವೇ ಹೇಳ್ತೀರಿ.
Anything else, sir? Anything else?
Yes, yes. Because the daughters cannot be excluded like that. Really, ನಾನೇನು
There are two other points.
Ah,
The trial court has come to the conclusion that they were not in possession of the property. Therefore, this court fee of rupees 200 is wholly insufficient.
35(2) na? ನಿಮ್
ಹೌದು.
ಪ್ರಕಾರ?
ಹೌದು.
You want to further punish the daughters, ah?
ಇಲ್ಲ, ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರು. ಏನಂತಂದ್ರೆ having given that
Withdraw
decree,
ಏನು ಬೇಡ. ಅಪೀಲ್ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಕ್ಲೈಂಟ್ ಗಳಿಗೆ ಹೇಳ್ತೀನಿ, ನಿಮ್ಮ ಅಪ್ಪ ಬದುಕಿದ್ದಾಗ 1 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂದಿದ್ರು, ಅದನ್ನ ಕೊಡಿ ಅಂತ ಹೇಳ್ತೀನಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರು. Having come to that finding, decree ought not to have been written unless deficit court fee was paid.
Oh, ಮಾಡಿಲ್ಲ ಅದು.
Yes, ಅದು ಮಾಡ್ಲಿಲ್ಲ. Therefore, even before this honorable court, unless it is paid, my prayer is decree should not be written.
ಎಲ್ಲಿ ಇದು ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ? ಬೆಂಗಳೂರಾ?
ಬೆಂಗಳೂರಿನ
ಬೆಂಗಳೂರು.
ಚಾಮರಾಜಪೇಟೆ.
ಮೈಸೂರು ರೋಡ್
ಸೂಟ್ ಯಾವಾಗಿದು? 90 ಸೂಟಾ?
96 ರೀ. 96 suit.
96 suit.
Appeal of the year 2008.
Yes, sir.
We are in 24.
Anything else, sir?
Huh?
ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ?
Yes, ಅಲ್ಲ ತಾವು ಪ್ಲೀಡಿಂಗ್ಸ್ ಕೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಜಸ್ಟ್
ಅಲ್ಲ ಪ್ಲೀಡಿಂಗ್ ಅದೇ ನಮ್
ಅಲ್ಲ to what extent the defendants 1 to 12 admit that it is the property of Mr. Sarbalingam, that is the father of the children and the husband. But the 13th defendant says it is all false in his written statement. Kindly take to the statement filed by the defendant number 13.
Sir, he is an outsider, sir.
Wait, sir. Sitaram Rao re ಸ್ವಲ್ಪ allow senior counsel to argue. What is this?
It is false that the property in question was the self-acquired property of late Sarbalingam Naidu. My lord finds it in paragraph 2 of the written statement of defendant number 13. And as far as the defendants number 1 is concerned, whose statement is accepted by the other remaining up to 12 defendants,
Yes, sir.
the acquisition, self-acquisition, all that is admitted. The property detailed in the schedule to the plaintiff originally belonged to late N. Sarbalingam, the father of this defendant, that is first defendant. Late C. Sarbalingam purchased the property under registered sale deed dated 2/1/1931 from so and so. That is not in dispute. From whom he purchased and all that out of question. Then Sarbalingam, he died on 17/5/1949.
You can stop here.
That is
You
the
can
only,
stop here.
that is only the hitch.
Huh?
That is only the point
Yes.
for consideration if my lord thinks. But what I respectfully submit is the case on the date on which the case was filed and the case on which the court is hearing it, the law prevailing on that day should be taken into account.
I'll answer that. I'll answer that. All right, I'll answer.
Then Hindu Succession Act 1956. As such, the married daughters of late C. Sarbalingam Naidu did not succeed to the estate of late Sarvana Naidu when the succession opened on 17/5/1949. It is respectably submitted that if Sarbalingam Naidu had died after coming into force of the Hindu Succession Act 56, there is every possibility that the defendants could have succeeded to the estate of Sarbalingam Naidu. But if the property is a dwelling house, the married daughters do not have any right to succeed to the estate of Sarvalingam Naidu as the property is a dwelling house. Considering the matter from any point of view, the daughters of late Sarvalingam Naidu did not have any right either on 12/5/1949 or subsequently. It is only the two sons of late Sarvalingam Naidu succeeded to estate of the father to the exclusion of their sisters. The death of Sri N. Kotilingam, the brother of the first defendant on 3/12/1986, does not enable the plaintiffs to claim any share in the properties of their father. As on 3/12/1986, with the death of Kotilingam, her wife and children succeeded to the undivided half share. In the presence of the wife and children of late Sri Kotilingam, the sisters of the Kotilingam cannot claim to be the heirs of late Sri Kotilingam. In any view of the matter, the plaintiff do not have any enforceable against the defendant 1 to 12 to any extent whatsoever. The suit is brought by the plaintiff is patently not maintainable in law and is liable to be dismissed in limine. Even otherwise, they do not have any right carve out their alleged 1/7 share each for the property in dwelling house. This defendant submit that neither the plaintiff nor the defendants are residing in the scheduled premises, as could be seen from the address of the plaintiffs. Joint possession, my lord is aware, is not physical possession. It is a legal fiction, joint possession. So here they say, I am not residing there because I am residing with my husband. Therefore, they say that I am not in possession of that property. If I am one of the sharers, irrespective whether I am residing there or not, still it could be said I am in possession. It is the 13th defendant, which is the registered firm, the partners of which are members are in possession of the property. The way of the plaintiffs have sought for the relief against the 13th defendant is not to meddle with the property and not to change the nature of the property clearly suggests 13th defendant is in possession who is total stranger person to the family. As such, the plaintiffs have to pay the court fee on the market value of their 1/7 share each. The property was sold by the defendants for a total consideration of 33,50,000 and the plaintiffs have to pay court fee of rupees 60,000 on the plaint. The plaintiffs have deliberately made undervalued the suit, knowing very well that the 13th defendant is in possession of on the date of the suit. It is the specific case of the plaintiffs that they are in joint possession of the property along with the defendants 1 to 12, which is patently false. The plaintiffs were married long prior to the coming into the force of the Hindu Succession Act 1956. As such, they did not acquire any right on the property to any extent whatsoever. The defendants submit that the rights of the plaintiffs were denied long prior to the filing of the suit. As such, the plaintiff should seek declaration of their title or the property by paying proper court fee on the plaint regarding their alleged share of the property. The plaintiffs have deliberately undervalued the suit. As such, the suit is liable to be dismissed in limine as per orders 7 Rule 11 CPC. The court may direct them to file the proper valuation slip and any proper court fee. Plaintiffs have deliberately approached the court by placing total ignorance of the sale in favor of the 13th defendant and the possession of the property held by the 13th defendant. As such, the plaintiffs are to be non-suited, having suppressed the facts from the court. There is no cause of action. This is all the defense that is taken by them. My submission to my lord is in this context. Joint possession, as my lord is there, it is a legal fiction. If he is a member of the family, no matter whether he physically resides or not, still, if he has got a share, it could be in a suit for partition, a joint possession. But they have made much about it. Question is, only one brother has sold this property. They say two brothers have sold it, but neither to show one brother or two brothers, no document is placed before the court by either defendants 1 to 12.
You could have produced the sale deed.
My lord?
You could have produced the sale deed.
ಇದೆ.
Now,
It's marked, huh? Produced and marked, who has sold? Kotilingam has sold or Krishmurti has sold?
They have not produced the sale deed at all.
Niಮ್ಗೆ ಯಾರು sell
Neither we have produced nor
I have copies,
Who has sold to you?
both of them by two different sale deeds.
Under two different things. They are half share, they have sold it.
Yes,
Yes,
On the
yes.
same day or on different dates?
on same day.
On the same day. All right.
kindly see the last page of the judgment, my lord will find that only one witness from the plaintiff, one witness from the defendant, and documents nil.
No, that is not
Sale-
in dispute, sir. Sale you have admitted, you have pleaded about the sale.
Just a minute, just a minute.
It is not in dispute.
One ನಿಮಿಷ ಇರ್ರಿ, ಸೀತಾರಾಮ್ ಅವರೇ. One ನಿಮಿಷ. Not required, sir. It's a pure question of law.
If that is so, my lord, with
The
great,
judge has taken a lot of pain in writing and very.
with great respect,
Ah.
if it is just a point of law, the case has taken decades.
To your
because
standing,
It
to
is,
your standing, I should not have adjourned it on the previous date also.
it's,
Yeah,
no,
this is
not
the
here.
memorandum.
I'm telling about the trial court. Trial court has 11 years it has taken. And previous day, ಒಂದು ದಿವಸದ್ದು
Your
ಅದೇನು
The clients
ಒಂದು ದಿವಸದ್ದು
strongly advised,
ಅಲ್ಲ ಒಂದು ದಿವಸದ್ದೇನು ಮಹತ್ವದ್ದಿಲ್ಲ
not a
ಯಾಕೆಂದ್ರೆ
case, not a case to fight this. You have no right.
my lord, after all, my lord, if that wife died, her share at least should come to us,
No,
all
no.
children.
We will not find it out. Not fair.
Otherwise,
No
why
pleadings,
why the
nobody's
daughters,
case.
the whole
See,
position,
your conduct, look at your conduct. You don't disclose the date of death of your father in your plaint. Look at the way, the conduct from at inception.
ಅಲ್ಲ ನಾನು ಹೇಳೋದು,
You should come with the clean hands. You
Is
should
that-
at least have the grace to tell that when your father died.
this is all between the
The council, see, the council
Children-
was drafted.
ಅಲ್ಲ, children and grandchildren, all of them, all of us know what is the date and all that.
No, no.
Merely because it is not stated in the
ಅಲ್ಲ
plain-
ಕೋರ್ಟಿಗೆ ಬೇಕಲ್ಲ, ಕೋರ್ಟ್ ಡಿಸೈಡ್ ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಬೇಕು ಬೇಡ.
court ಗೆ ಬೇಕು. But ನಮಗಂತೂ
From the
ಗೊತ್ತಿದೆಯಲ್ಲ,
court's perspective, I'm asking. Within the family, you might be knowing when your
ಅಲ್ಲ
father died.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರು ಹೇಳ್ಬೋದಾಗಿತ್ತು.
ಅವ್ರು ಹೇಳಿದ್ದಾರೆ.
ಹೇಳಿದೀವಿ.
ನಾನು ಓದ್ಬಿಟ್ಟೆ, ಪ್ಯಾರಾ 1 ನಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ ಅವರು.
ಹೇಳಿದ್ಮೇಲೆ we have not disputed that. Therefore, death cannot be disputed. Anything else on the earth could be disputed.
All right.
Therefore, my submission to my lord is that right of the women, that is daughters, cannot be denied merely because the father died prior to 1956. As I submitted to my lord straight away, if he had died after 1956, no dispute could have been there straight away. Question is whether 33 Act, 37 Act, whether they give right to any
All right.
to the daughters.
Yes, yes, sir.
I have cited one citation.
Yes.
That is perhaps the
Example,
direct
madam.
on the point.
Yes, sir. What's
I will
the
also-
second ground?
I will just one minute.
What's the second ground?
That's all my,
ಅದೇನ್ ಕೋರ್ಟ್ ಫೀ ಬಿಡ್ರಿ, ಅದೆಲ್ಲ ಮತ್ ಮಾಡ್ತಾರೆ.
ಬಿಟ್ಬೇಡ,
ಆ?
ಬಿಟ್ಬಿಡ್ಬೇಕು.
ಸೀತಾರಾಮ್ ಅವ್ರು.
ಅಲ್ಲ, the correct practice is,
Ah,
unless
correct,
that is-
actually
that is-
correct.
that is made good.
ಅಲ್ಲ,
Whether issue was framed, whether issue was
ಅಲ್ಲ,
framed on that.
ಅಲ್ಲ, ಒಂದು ಪ್ರಶ್ನೆ. ಇಫ್ ಈ ಸದಾಶಿವಪ್ಪನವ್ರು ಕೂಡ ಹೇಳಿದ ಲೀಗಲ್ ಪ್ರಪೋಸಿಷನ್, ಇಫ್ ದೇ ಹ್ಯಾಡ್ ಎ ರೈಟ್, ಲೀಗಲ್ ಫಿಕ್ಷನ್ ಪೊಸೆಷನ್, ದೇ ಹ್ಯಾಡ್ ನೋ ರೈಟ್. ಆಗ
That is-
ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. ವಿ ಆರ್ ನಾಟ್ ಅರ್ಜಿಂಗ್ ಇಟ್ ಸೀರಿಯಸ್ಲಿ.
ಅಲ್ಲ, ರೆವೆನ್ಯೂ ಅಲ್ಲ ಅದು. We'll ask the,
Please see,
ನೋಡಿ,
page 51.
oh, issue number 2.
That is the first and. the
That is
first and
answered, that is answered in their favor, huh?
Yeah,
ಅಲ್ಲ, there
Answered
is
in the affirmative.
answered in our favor, but they were not required to pay. deficit
Oh, that
court
is
fee.
also answered. ಈಗ ಕೊಡ್ಲಿ, ಎರಡು ಕೊಡ್ಲಿ.
ಹೌದು.
Office
now,
to collect the proper.
Yes.
on
yes.
that point, there is already an order by this honorable court. They made an application regarding that. There is an order already.
ಅದರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು, ಫೈನಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಕೋರ್ಟ್ ಫೀ ಕೊಡಬಾರ್ದು ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಂತ. ಮತ್ತೆ now my lord said my friend also says I have no right at all. Well, for the moment, it may be accepted. But they themselves offer 1 lakh to me.
Huh?
1
ಹೆಣ್ಣು
lakh.
ಮಕ್ಕಳು ಗರಿಷ್ಠ
Kindly see.
ಪೇ.
ಅವ್ರು ಅಲ್ಲಿ ಮಾತಾಡ್ತಾರೆ, ನಾನು ಇಲ್ಲಿ ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಅರಿಶಿನ ಕುಂಕುಮ ಕೊಡ್ತಾ ಇದ್ವಿ ಅಂತ
In the
ಹೇಳಿದ್ದು.
reply to our legal notice, before institution of the case, my lord, a notice was sent by telegram. There is a reply to that. That is also produced by as exhibit P2 in the present case, P2. I just take my lord's attention to what they have said in paragraph 3 of the reply. My clients represented that they have sold the property to Sri Makbul Ahmad under registered sale deed dated 3/5/1995. It is further stated that my clients, out of love and affection and as a matter of gesture are ready to pay a sum of rupees 1 lakh to each of the 3 living daughters, as well as the heirs of the deceased daughters of late Sri Sharbalingam. Paragraph 3 of the reply.
ಇದು ಕೋರ್ಟ್ ಫೀಸ್ ಆಕ್ಟ್ ತಗೊಳ್ಳಿ. Court holds that they were required to make a valuation on the 35-2.
Yes.
Where is the discussion on issue number 2?
Joint possession ಅಂತ ಹೇಳಿ 35-2 ನಲ್ಲಿ
Possession
all
ಇರ್ಲಿಲ್ಲ ಅವರು. That was not even a constructive possession. That is the finding given on issue number 1 and 2.
ಎಲ್ಲಿದೆ ಅದು?
Issue number 1 at page number.
Page 35, sorry. ತೊಗೊಂಡ್ಬಿಡ್ರಿ. ಪೇಪರ್ ಬುಕ್ ಹಾಕಿಲ್ವಾ ಇದರಲ್ಲಿ? ಇದೆಲ್ಲ
Page 59.
ಇದು ತಗೊಳ್ರಿ, ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ತಗೊಳ್ರಿ. ಯಾವ ಸೆಕ್ಷನ್ ಅದು?
Section 11 of Karnataka Code.
No. If the court fee paid is improper and if there is a determination,
So, Kodi.
court has to fix a date. Court has to fix a date and call upon the party to
Make good the court fee.
made good. Otherwise, till then decree can't be drawn.
ಕೋರ್ಟ್ ಫೀ ಕೊಡೋ ಬದಲು ಸದಾಶಿವಪ್ಪನವ್ರು ಅಪೀಲ್ ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ರೆ ಮುಗಿದೋಗುತ್ತೆ.
ಇಲ್ಲ ಅವರು with all vigor Sadashivappa sir is arguing.
ಮೂಡಿಲ್ಲ ಅವ್ರಿಗೆ.
Straight away.
ಅವ್ರು ಈಗಲೂ he was able to hold the field in our court for 45 minutes. ಬಿಡ್ತಾ ಇಲ್ಲ ಅವರು.
Straight
Short
away.
point ಇದು.
Straight away, I cannot on my own withdraw, my lord. I must ask my parties only, as if my lord is.
Right.
Huh?
No need to withdraw. We'll give a coitus. We'll
My lord?
decide it on merits. We'll give a coitus. Court seal is important. ಬರ್ಕೊಡ್ರಿ ಇರ್ಲಿ ಬೇಡ. Chamber. Chamber. ಕೂತ್ಕೊಳ್ಳಿ ಸರ್. The caption second of first appeal is by unsuccessful plaintiffs who are assailing the judgment and decree rendered in OS 1563 of 1996. The trial court had dismissed the suit by holding that plaintiff's father, having died in 1949, are not entitled for a share. Next, for the sake of brevity, rank of parties so and so serves. Plaintiffs have filed a suit for partition and separate possession. Plaintiffs contend that the social property is owned by their father, N. Sarbalingam Naidu, and he was the absolute owner of the social property. Plaintiffs also contend that the father acquired this property and it is itself a property. Plaintiffs contend that they, along with the defendants 1 to 12, being legal heirs, being class 1, being legal heirs of Sarbalingam Naidu, are entitled for a share in the social property. Plaintiffs alleged that defendants 1 and 2, without consent of plaintiffs have alienated the social property, and therefore the present suit is filed, seeking a partition and separate possession of their legitimate share in the social property. plaintiffs contend that they are entitled for 1/7 share each in the social properties. Next. Defendants 1 to 12.
May I request my lord,
Defendant number 1,
may I request my lord kindly to defer by 5 minutes. I'll just ask my clients.
you want to withdraw?
ಅಲ್ಲ ಬೇಕು ಅಂದ್ರೆ ಅವ್ನು ಕೇಳ್ಬಿಟ್ಟು ತಮ್ಮ ಹೇಳ್ತೀನಿ 5 minutes defer ಮಾಡಿ.
All right, you ask. Keli.
No, it is not by choice.
It is not.
Payment of court fee is not by choice.
ಸುಮ್ನೆ ಇದ್ ಮಾಡಿ.
Even if you withdraw, I have to say that that question has to be answered.
10%.
Sir, you have utilized court machinery for almost how many years? 96 for 29 years. Court has invested its time, sir. You know the consequences. And I am very particular. No. Court fee will be recovered from you. Assured. Otherwise, doubt ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ ನಮ್ಮ ಸೀತಾರಾಮ್ ಹೇಳಿದ್ರು ಅದ withdraw
No,
ಮಾಡಿದ್ರು.
you can't escape the
Actually,
consequences.
they have agreed to pay 1 lakh to each of the sisters, as is the reply. We have filed it. Delay is not only on the part of the plaintiffs, as you, my lord, is aware. It could be court, opposite side, everything.
I am not responsible.
ನಾವು
for
ಟೈಮ್
delay.
ತಗೊಂಡಿಲ್ಲ.
Huh?
Time ತಗೊಂಡಿಲ್ವಂತವ್ರು.
Time ತಗೊಂಡಿಲ್ಲ.
I will write it, I'll pass orders. But
I leave it.
next. Defendant number 1, on receipt of summons, tendered appearance and filed written statement and stoutly denied the entire affirmance made in the plaintiff. First defendant contended that father died in 1949 and therefore plaintiffs being daughters are not entitled to seek any share in the social property. This written statement is adopted by defendants 2 to 12 by filing a memo to the effect. Defendant number 13, who is the purchaser, has filed his written statement and has contested the suit and has prayed for dismissal of the suit. Next, plaintiff and defendants to substantiate their respective claims have led in oral documentary evidence. Second, plaintiff has examined herself as PW1 and has produced 2 documents which are marked as exhibit P1 and P2. First, defendant is examined as DW1 and has not chosen to produce any documentary evidence. Next, trial court on proper appreciation of pleadings, oral and documentary evidence. Answered issue number ಯಾವ್ದದು core issue number 4 I think issue number 4 alva.
Issue number 4 is
Whether they are entitled for a share.
there.
Probably their trial court has answered that.
How?
Huh?
How?
Nodi, check ಮಾಡಿ issue number
Yes.
4.
That is issue number 4.
While answering issue number 4 in the negative,
Discussion start from.
has taken cognizance of the law prevailing as on the date of death of propositors. Trial court noting the date of propositors held that daughters are not entitled to seek share in the property left behind by the father as he died on 17/5/1949. Learned judge was of the view that before codification, the daughters were not entitled to succeed to the property left behind by a male Hindu. Precisely on this point of law, the trial court proceeded to dismiss the suit. While dismissing the suit, trial court has also answered issue number 2 in the affirmative. trial court held that plaintiffs have not properly valued the relief sought in the plaint. And referring to the evidence on record, learned judge held that plaintiffs were required to value the suitable property under section 35(2) of the Karnataka Court Fees and Suit Variation Act. Consequently, appeal is dismissed. Next.
Issue number 2 ನಲ್ಲಿ ಇದೆ, 4 ಅಲ್ಲ, 4 only regarding the share issues.
ಅದನ್ನೇ ಹೇಳಿ.
Issue number 4 is entitled to share in the settled property.
ಅದೇ ಅಲ್ಲೇ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ. ಆ 4 ಅಲ್ಲಿನೇ ಎಲ್ಲ ಅದು part 1933 Act, 37 Acted are discussed under issue number 4, 3 and 4. Recorded by the Learned Counsel appearing for plaintiffs, reiterating the grounds urged in the appeal memo, has vehemently argued and contended that that the date of death of propositors is of no consequence in the light of law laid down by Honorable Apex Court in the case of Vinita Sharma versus so and so. It would contend that that the daughters, that the rights of the daughters has to be determined in the light of the law prevailing on the day the suit is instituted. To buttress his arguments, he has placed reliance on the judgment rendered by this court in the case of Ramchandra Bhimappa Murgod and another versus Sushila and others. Citing the dictum in the above judgment, reported judgment, he would contend that the coordinate bench in a reported judgment has rightly held that a widow with her daughters are entitled to claim share in a husband's property, in her husband's / father's property before codification of Hindu law. Citing the above said judgment, he would contend that that the judgment and decree rendered by the trial court clearly contravenes the law laid down by the coordinate bench in the case of Ramchandra Bhimappa Murgod, cited supra. Next paragraph. Learned Counsel, while assailing the finding recorded by the trial court on issue number 2 relating to valuation of the social property, has contended that plaintiffs, being daughters, were all along in possession, in joint possession with the contesting defendants, and therefore it is argued that the finding recorded by the learned judge on issue number 2 is perverse and would warrant interference at the hands of this court. Next, per contra, learned counsel appearing for defendant number 13/purchaser, justifying the findings and reasons recorded by the trial court, has straightaway placed reliance on judgment rendered, has straightaway placed reliance on 3 judgments. Referring to the judgment rendered by Apex Court in the case of L. Gauramma, he submits that the law in regard to the entitlement, law in regard to daughter's right in a property left behind by a Hindu male prior to codification of Hindu law is no more res integra. Citing the above said judgment, he would contend that the right of succession of daughters is clearly excluded in view of order of succession prescribed under section 4(1) of Women's Rights Act 1933. He has also placed reliance on the judgment rendered by the coordinate bench of this court in the case of, has also relied on a judgment rendered by division bench of this court in the case of Annamma versus Pattamma. Referring to the said citation, it would contain that where a Hindu male dies prior to codification, the succession to such a property left behind by a Hindu male has to be determined under section 6(2) of the Mysore Hindu Women's Rights to Property Act 1933. Placing reliance on these three judgments, you would contend that the judgment and decree, that the findings recorded by the trial court clearly aligns and adheres to the law laid down by the Honorable Apex Court and the division bench of this court. Therefore, you would request this court to dismiss the appeal. At this juncture, you would also point out that the learned, that the trial court held in drawing a decree, having answered issue number 2 in the affirmative. Next panel. Learned counsel appearing for defendants 1 to 12 has argued in the same vein and has contended that since it is admitted fact that propositors died in 1949, plaintiffs being daughters are not entitled to succeed to the property left behind by the father. You would point out that the vesting had already taken place immediately after death of father in 1949, and therefore daughters cannot take benefit of the Hindu Succession Act 1956. The right conferred on a daughter for the first time under 1956 under 1956 Act has no application wherever propositors has died much prior to 1956 Act. Next, have the counsels on record, peruse the pleadings, oral and documentary evidence. The following point would arise for consideration: whether the finding of the trial court that plaintiffs who are the daughters are not entitled for a share in the property as far as the propositors, Nilambaram, and what is his name? As propositors,
Sharabalingam Naidu.
Sharabalingam Naidu died on 17/4/1949 ಅಲ್ಲ? ನಿಮ್ WS para 1 ಅಲ್ಲಿ ಇದೆ.
17/5/1949.
1949. 17/5/1949.
5/1949 is perverse, palpably erroneous, and warrants interference at the hands of this court. Next, my finding on the point formula, on point number 1. It is not in dispute that Sharabalingam Naidu was the absolute owner of the social property. Plaintiffs admit that it is a self-account property of late Sharabalingam Naidu. Defendants 1 to 12 also admit that the social property was self-account property of late Sharabalingam Naidu. Defendants, however, at para 1 of the written statement have specifically pleaded that Sharabalingam Naidu died on 17/5/1949. The law relating to right of a daughters in the event father has died before commencement of 1956 Act is no more res integra. The Honorable, the division bench of this court in the case of Mandamus versus Pattamma, while examining this issue, has held that in terms of section 6(2) of Mysore Hindu Women's Right to Property Act, the succession does not take place simultaneously Referring to section 6(2) and 4 of 1933 Act, the division bench held that these two sections read together only reveals that succession will be only in the order as mentioned in section 6(2) of 1933 Act. In the light of law laid down by the division bench in the judgment cited Supra and the Honorable Apex Court in the case of L. Gauramma, plaintiffs for the daughters are not entitled to succeed to the estate left behind by their father. The above said sections clearly excludes the daughters in terms of order of succession prescribed under section 4(1) of the 1933 Act. The Honorable Apex Court, while examining the rights of the daughters, where a male Hindu died much prior to commencement of 1956 Act, has clearly held that where a male Hindu dies prior to codification of Hindu law, his interest would devolve upon male members by survivorship. Supreme Court judgment ಅಲ್ಲಿ ಯಾವ paragraph?
Eighteen. 18. Not in 18.
In the light of law laid down by the Apex Court and division bench of this court is of the view that succession in the present case on hand on account of death of Sarbalingam will vest only in the surviving sons under section 4(1) Ayala, small Ayala, first, at the exclusion of all other legal heirs. The daughters who are mentioned in clause 3 by virtue of expression, double inverted comma dalli, in the following order. Double inverted comma clearly clinches the controversy on hand. Plaintiffs admittedly have not succeeded to the estate left behind by the father. The property immediately stood vested and devolved on the sons. And therefore, plaintiffs being daughters could not have maintained a suit for partition. Next paragraph. Second point madidira. Whether adu second point innond ಮಾಡಿ. Whether trial court having held that the plaint was required to be valued under section 35(2) erred in drawing a decree without securing the deficient court fee. Other remember my finding on point number 2. ಅಲ್ಲಿ ಡಿಟರ್ಮೈನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಅವರು ಮಾಡ್ಲೇ ಇಲ್ಲ. ಡಿಟರ್ಮೈನ್ ಮಾಡಿ ಯು ಹ್ಯಾವ್ ಟು ಫಿಕ್ಸ್ ಎ ಡೇಟ್.
ಹೌದು,
ಡಿಟರ್ಮೈನ್ ಮಾಡಿ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು.
ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು. ಡಿಟರ್ಮಿನ್ ಮಾಡಿದಾರ? ಹೌದಾ?
ನೋಡಿ,
But date was not fixed.
A date has to be fixed and plaintiff has to be called upon to deposit. ಮಾಡ್ಲಿ ಅಂದ್ರೆ dismiss ಮಾಡ್ಬೇಕು so only on that point. And decree should not be drawn till that.
ಅಲ್ಲ, ಡಿಕ್ರಿ ಡ್ರಾ ಮಾಡಲ್ಲ ಅಷ್ಟೇ.
ಆ ಡಿಕ್ರಿ ಡ್ರಾ ಮಾಡಬಾರ್ದು. ಮಾಡಿದಾರ? ವೆದರ್ ಇಟ್ಸ್ ಕ್ವಾಂಟಿಫೈಡ್? ಅದು ಮಾಡ್ಲಿಲ್ಲ ಅವರು, ಮಾಡ್ಬೇಕಾಗಿತ್ತು. The learned judge, while answering issue number 2 in the affirmative, has held that the plaintiffs were never in joint possession. It is in this background, trial court was of the view that plaintiffs were required to value the plaint under section 35(2) and not under section 35(1) of the Karnataka Court Fees Act. Having answered issue number 2 in the affirmative, this court has noticed that the trial court has not adopted the procedure as contemplated under section, ಯಾವ್ದು ನೋಡಿದ್ರೆ 22 no civil rules of practice. Section 22 and in Court Fees Act area. Section 11. Correct. Section 11. Level 4 is appeal. Appeal. ಎರಡು ಮಾಡಿ. ಇದೆ ಯಾವ ಸೆಕ್ಷನ್ ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಅಲ್ಲಿ ಇದೆ. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು. ಈ ಪೇಬಲ್ ಆನ್ ರಿಟರ್ನ್. ಏನ್ ಬಂದ್ರಿ ಮೇಡಮ್? Under
Order
section
7
11 of
rule 11 is also on the point. Order 7 rule 11 is also on the point.
Under section 11, read with order 7 rule 11 of civil procedure code. Having answered issue number 2 in the affirmative, the court was required to fix the date, was required to determine the deficient court fee and a date should have been fixed, notifying the plaintiff to make good the deficient court fee. Without recovering the deficient court fee, the letter judge has drawn the decree. Section 11(4) of the Karnataka Court Fees Act empowers the appellate court to examine the correctness of the proper court fee payable in the plaint. Under 4B, this court would call upon the plaintiff to deposit the deficient to deposit the court fee payable under section 35(2). Plaintiff is not only required to deposit the deficient court fee payable before the trial court, but is also required to pay the deficient court fee before this court in terms of section 49 of Karnataka Court Fees Act. Registry is called upon to determine the deficient court fee and notify the plaintiffs. Registry, it's made clear that registry shall not draw the decree unless the deficient court fee is paid. Accordingly, point number 2 is answered in the affirmative. For the foregoing reasons, this court is of the view that the trial court has rightly appreciated the law applicable in the present case on hand. The findings recorded on issue number 3 and 4 is found to be clearly adhering to the law laid down by the Honorable Apex Court in the case of L. Gauramma and the judgment rendered by this court in the case of Annamma versus Pattamma. I do not find any error in the findings recorded by the trial court while dismissing the suit. Appeal is devoid by its instant.
If I heard it correctly, ಅಲ್ಲಿ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ dependent number 1 and 2 and 2 sold property ಅಂತ ಬಂತು. In the very beginning.
1 and LR ಸಾಬೇಕದು.
1, 3, 4, 5, 6, 7.
ಡಿಫೆಂಡೆಂಟ್ ಮೇಡಮ್ ಮೇಲೆ ಯಾರು ಸೇಲ್ ಮಾಡಿದಾರಲ್ಲ ಡಿಫೆಂಡೆಂಟ್ 1,
3, 4, 5, 6, and 7.
1, 3, 4, 5, 6, and 7. Yes.
Please.
Yes, sir. Yes.
Respondent number 2 here.
I pay for the collect council. Plaintiff's appeal, madam. The trial court has dismissed the suit of the plaintiff. Suit is one for a partition
Yes.
of a 1/7 share, madam. So for the genealogical tree may request, my lord, in the relationship is not in dispute, madam. And the page 95 is the appeal memo. So last may kindly find the originally appeal memo that has been S.A. Parameshwaraya, that has been Saraswatama, is the family genealogical tree, madam.
Yes.
So far the 1 to 4 are the sons, 4 to 5 and 6 are the daughters of late Parameshwara Urala.
Will is held to be proved.
So far the execution of the will is admitted. So far the will is execution of the trial court given a finding under the execution of the will is being so far. Only
You'll
the
succeed.
circumstance, suspicious circumstance that had to be looked at.
Allah, you will succeed only if bill goes, correct? Ashte alva?
Yes.
So your argument should be confined to issue number 4.
Only issue, yes, exactly, my lord. In fact, so far the issue number 1 to 3, my lord, they are given a finding negative and anyway, they answered on issue number 5.
ಯಾರು ಮೃತ್ಯುಪತ್ರ ಯಾರು ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ?
Now, will is executed by S.A. Parameshwara Urala, that is the father of the plaintiffs and the defendants. The relationship between the parties, my lord. So far 1 to 4 is the sons, 5 and 6 are the daughters of Parameshwara Urala. The date of the execution of the will is relevant, my lord.
Will in whose favor?
Will is in favor of the all. Now the only the pith and substance of the defense is, my lord, the unequal shares. Kindly appreciate, my lord, with this background, I have got a proportionate.
Sitaram Rai idare.
I prepared a chart. Unequal share how such a ನನಗೆ 9% ಕೊಟ್ಬಿಟ್ರು. ಫಸ್ಟ್ ದೊಡ್ಡ ಬ್ರದರ್ಗೆ
ಅದು ಮೃತ್ಯುಪತ್ರ ಅಲ್ಲ. ಏನು ಕೊಡದೇನು ಇರ್ಬೋದು.
ಕೊಡಬಾರ್ದಾಗಿತ್ತು ಮನೆಯಿಂದ
ಅವರೇ ಪ್ರೊಫೌಂಡ್ ಅವರೇ ಸೀತಾರಾಮ್ ರಾವ್ this property the property and only one property man so far
ಇದು ಬೆಂಗಳೂರಾ?
ಬೆಂಗಳೂರು ವಿದ್ಯಾರ್ಥಿ ಭವನ್ that is in ಬಸವನಗುಡಿ DVG road ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ವಿದ್ಯಾರ್ಥಿ ಭವನ್ that is the property in there.
ಪ್ರಾಪರ್ಟಿ ಅದಲ್ಲ, ವಿದ್ಯಾರ್ಥಿ ಭವನ್ ಮಾರಾಕಿದ್ರು.
ಅದು ಬೇರೆ ಅದಾಯ್ತು ಸ್ವಾಮಿ.
ಮನೆ
ರೆಸಿಡೆನ್ಶಿಯಲ್ ಪ್ರಾಪರ್ಟಿ.
ಅದು ನಿಮ್ದೇನ್ ಗ್ರೀವೆನ್ಸ್ ಈಗ ಬಹಳ ಕಮ್ಮಿ ಕೊಟ್ರು ಅಂತ ನಿಮ್
ನಮ್ದು
ಅವ್ರು ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ತಾವು ನೋಡಿ ಒಂದ್ಸಲ ಡಿಸ್ಟ್ರಿಬ್ಯೂಷನ್ ಇದೆಯಲ್ಲ
ಅದು
ನಾವು
can't be a suspicious. ನೀವು ಅವ್ರು ಮಾಡಿದಾರೆ ಇಲ್ಲ ಹೇಳಿ. How the what's your cross examination to the witnesses?
ಅವ್ರಿಗೆ 51% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನು ತಪ್ಪಿಲ್ಲ, ತಂದೆ ಅವ್ರದ್ದು, ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು.
ಸೆಲ್ಫ್ ಅಕ್ವೈರ್ಡ್ ಸರ್.
I do agree with that.
ಯಾರಿಗೂ ಕೊಡದೆ, ನಿಮ್ಗೆ ಯಾರಿಗೆ ಕೊಡದೆ ಅವ್ರು ಯಾವ ದೇವಸ್ಥಾನಗೂ ಕೊಡ್ಬೋದಾಗಿ
ಕೊಡ್ಬೋದು.
I do agree.
ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್
ಅಲ್ಲ, I do agree with your so far the lordship said. But the question is, my lord.
ಅಲ್ಲ, ತಂದೆಯವ್ರ ಜೀವಂತಿದ್ದಾಗ ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಸೇವೆ ಮಾಡ್ಲಿಲ್ವಾ ನೀವು?
ಅಲ್ಲ, ನಾವು ಮಾಡಿದೀವಿ. Because I have taken to the hospital. I have treated him. No.
ಹಾಸ್ಪಿಟಲ್ ನೀವು ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ, ನೀವು ವಿಸಿಟ್ ಮಾಡಿದ್ರಿ.
ವಿಸಿಟ್ ಮಾಡಿ.
ಸೀತಾರಾಮ್ ರಾಯರ ಜೊತೆಲಿದ್ರು.
ಅವರ ವಿಟ್ನೆಸ್
ಎಲ್ಲದ್ರಲ್ಲೂ ಈದಿನ ಆಫೀಸ್ ದಟ್ ಬಿಲ್ಡಿಂಗ್ ಅಂತ ಕಾಣುತ್ತ.
ಇಲ್ಲ ಅವರೇ ನನಗೆ ಆಶ್ರಯ ಕೊಟ್ಟಿದ್ದು 17 ವರ್ಷ
ಆಶ್ರಯ ಕೊಟ್ಟಿದ್ದು.
ಚೆನ್ನಾಗಿ ಗೊತ್ತು ನಿಮ್ಮನ್ನ.
ಡೇಟ್ ಆಫ್ ಸೂಟ್ ಮೈ ಲಾರ್ಡ್.
How it is doubtful ಅಂತ ನಿಮ್ ಪ್ರಕಾರ?
ನಾನು I will only the date of will and the date of will is relevant, man. Exhibit D9. That is the date of will is on 16/7/2000, madam.
One minute.
286, madam, 298 page. 286 to 298.
1 minute. Exhibit,
Exhibit D9, madam. 16/7/2000, madam.
16/7.
16/7/2000.
Yes.
Date of death of my father, that has been that is also relevant. 27/8/2006. Prior to 6 years.
28.
27/8/2006, madam.
Yes.
There is no dispute about this fact. Date of suit, my lord, on 7/11/2008. In fact, after a hearing for some time by the earlier your lordship, in fact, there is a sincere, the court has suggested to somehow arrive except one brother that is facing commercial shops. All are agreeable for the rearrange the share, and unfortunately, only one brother is not willing to agree for. That is all are are agreeable to modify the shares or somehow adjust the shares mutually, or so they are willing to dispose of the property or somehow. At this stage, the matter has been deferred after hearing for some time. Now it is your lordship may kindly even the counsel for the Sitaram, the appearing for the first respondent, first defendant, he is the first respondent, Krishnamurthy. He has also sincere attempt is made for the settling the matter, but unfortunately, the efforts have not been fruitful.
You will succeed only if will is disbelieved. Otherwise,
Ah.
no court
Agreed.
should alter.
One
No
submission,
court,
Lord.
no, just a minute. No court should alter the last will of will and wish of a noble soul. We should not alter unless you are able to demonstrate that this will is manufactured by a beneficiary. ಅಷ್ಟೇ. ಏನಿದೆ
ಇಲ್ಲ,
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೋಡೋಣ ಏನ್ ಮಾಡಿದಿರ
Now exhibit the
ನಾವು
class
ಒಂದು ನಿಮಿಷ.
DW.
ಇದನ್ನ ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದ್ ಬೇಡ. ಜಗದೀಶ್ ಅವರು ಈ ಅಪೀಲ್ ನ ಬಿಟ್ಬಿಟ್ರೆ ಇನ್ನೂ ಏನನ್ನ ಸೆಟಲ್ಮೆಂಟ್ ಚಾನ್ಸ್ ಇರ್ಬೋದು. ಇವ್ರ ಅಪೀಲ್ ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರೆ ಒಳ್ಳೇದು ಅಂತ ನನ್ಗನ್ಸುತ್ತೆ.
ನೀವು ಎಲ್ಲ ಅಪೀಲ್ ದಲ್ಲಿ ಬಂದು ವಿಡ್ರಾನ ಮಾಡಿಸ್ತಾ ಇದ್ದೀರಲ್ಲ ಎಲ್ರಿಗೂ. ಆ
Right.
ಪ್ರೀವಿಯಸ್ ವಿಡ್ರಾ ಅಂತ ಇದ್ರಿ. ಹೇಳ್ರಿ ಸೀತಾರಾಮ
ರಾಯರ್ ಹೇಳ್ತಾ ಇರೋದು ಕರೆಕ್ಷನ್.
ಅಲ್ಲ ಅವ್ರು ಫಿಸಿಕಲಿ ಬಂದು ಏನಾದ್ರು ಹೇಳಿದ್ರೆ even now I am open minded.
ಅಲ್ಲ ಸ್ವಾಮಿ,
I am prepared to listen to him.
ಮೇಲ್
2012 matter, no adjournment that
No, I
you are going to settle it. If that has not happened for 14 years, it will not happen.
Yes, please.
ಇಲ್ಲ, ಕಡೆಯಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಆಯ್ತು. ಈಗ ಇವರು ವಿಲ್ ಬಗ್ಗೆ ಏನು ಒಂದು ಪದ ಹೇಳಕ್ ಆಗಲ್ಲ. ಪ್ಯಾರಾ 46 ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ PW1 ಹೇಳ್ತಾರೆ. 4 ಲೈನ್ ಓದ್ತೀನಿ ನಾನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ಡ್ಯೂರಿಂಗ್ ದಿ ಲೈಫ್ ಟೈಮ್ ಆಫ್ ಮೈ ಫಾದರ್ he never used to allow his children to deal with the business or transactions or matters pertaining to property, and he used to deal himself. It is true to suggest till his death neither me nor any other brother or sisters ever questioned my father's affairs or transactions. This is the evidence of PW1. ಇಲ್ಲಿ ಏನಾಗಿದೆ, ಇವರಿಗೆ ಕಮ್ಮಿ ಅಂತ ಹೇಳಿ ಇನ್ನೊಂದು ಕಮ್ಮಿ ಕೊಟ್ಟಿರೋರ್ ಮನೆ ಆಕ್ಯುಪೈ ಮಾಡ್ಕೊಂತಿದ್ದಾರೆ. ಅಲ್ಲಿಂದ ಡಿಸ್ಪ್ಯೂಟ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು. ಇವ್ರು ಶುರು ಮಾಡದೆ ಇದ್ದಿದ್ರೆ ಎಲ್ಲ ಸರಿ ಹೋಗಿರೋದು.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಅವ್ರು ಕೊಟ್ಟಿರೋ ಪೊಸಿಷನ್ ಇವರೇ ಬೀಗ ಹಾಕೊಂಡು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಇಟ್ಕೊಂಡು ರೆಸ್ಪಾಂಡೆಂಟ್ ನನ್ ಕ್ಲೈಂಟ್ ಅವ್ರದ್ದು ಬೀಗ ಹಾಕೊಂಡು ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಸ್ವಲ್ಪ ಬೇಕಲ್ವಾ ಸ್ವಾಮಿ?
ನಾವ್ ಯಾರ್ದು big
ಹೌದೌದು, I can display. I can
anyway.
today
Allow him to finish off. This is a half an hour time appeal.
Please, my lord.
ನೀವು ಇಬ್ರು ಒಂದು ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಬೇಕು.
Please, my
sir. You straight away come to cross
Sir,
examination.
Rashmi kindly appreciate the date of cross examination. May I request my lord on 27/1
cross examination.
page 142.
142.
142, my lord. 142.
Both the witnesses are examined.
Yes, examined. One attesting will, scribe is examined. Scribe and so far the will as per section 63 of the Succession Act and 68 of the Indian Evidence Act that has been
taken note care by the.
Allah, you can read exam, cross-examination.
Yes,
of plaintiff.
exactly. That's why I wanted to point out. That is all, that is, that's why I referred 142, my lord.
140.
Date is 27/1/2010. Some. Your Lordship kindly may read, my lord. Now, just I will read the cross-exam relevant portion only.
Yes.
That 143. It is true to suggest that wife of Manjunath is the daughter of my maternal uncle. I know that wife of Manjunath is working. I do not know that she joined the job of 1980. Your Lordship may request to paragraph 22. This is more relevant. It is true to suggest that my parents had always treated all their children equally. This is a crucial point for the whole argument. This is only the part. Your Lordship may kindly appreciate what I try to pursue on this point.
Love and affection equally. Re. Probably. All right.
It is true to suggest, this is answer by the DWO, that is true to suggest that my parents had always treated all their children equally. It is true to suggest that as I joined job, most of time I resided outside Bangalore only. It is true to suggest that we the sons, after our wedding, started to reside separately by arranging separate house. What I try to point out from the cross-examination admission of the relevancy is, here, my lord, all the sons and daughters are treated equally by so far the person one who was executed the will. Now whether unequal share, whether that is to be, that was, if at all that was the intention, assuming for an argument. Now here, my lord, DW1, there is a clear admission, he was not taken care. Even he was earlier, he was residing with another son, not with the present DW1, one who was the beneficiary under the will. He is a 51% beneficiary by virtue of the will. Well, actually, the relation between me and my father with my elder sister and her husband was always cordial. This is paragraph 24, paragraph. Just now here the relevancy, your Lordship kindly 145. Sushila advised me that my sister, I being the elder son in the family, should reside with my father. It is true to suggest that I accepted the suggestion as well. My father has accepted the same. It is true to suggest that thereafter I had sent my wife and children to reside with my father at Bangalore. At that time, my son was studying at Waspet. It is true to suggest that during the year 2000, my father had a small operation. Witness volunteers, it was on the leg. It is true to suggest that my father had clotting of blood due to joining of nerves. When my father was operated, it was Mahabaleshwara who had taken my father for the first time to the doctor. That is another son. That is, my father had told me that Mahabaleshwara had taken him to the doctor. Dr. Shanai Maya nursing home is the doctor who treated my father. Then it is not true to suggest that it was not Mahabaleshwara, but Manjunath who took my father to Shanai and got the treatment. That is the present appellant here. It is not true to suggest that, though I am aware that it is the Manjunath who so got treated my father, I am deliberately deposing falsely, stating that it was Mahabaleshwar. Only for the purpose of this case, it is true to suggest that I am very cordial with Mahabaleshwar witness volunteers. I am cordial with everybody. I am not cordial with Manjunath since he demanded the property right. This is further, my lord. I came to know, that is 26. I came to know that my father had executed a will only on 10/9/2006. It was in a sealed cover. There was no any writing on the cover of the said will. My father was admitted to hospital second time on 23/8/2006. While going to the hospital, my father told me that he had kept two documents in the bank locker. One cover contains the will, and therefore I came to know that cover so found by me, and they had a will, but only said there was a will in the Almera. 13th day ceremony of my father was performed at Guru Narsimha Kalyana Mantapa, and the ceremony was over 4:30 from Kalyana Mantapa. On 13th day ceremony only, I had told my sister her husband, my father, my brother, my uncle, that on next day, there is 14th function, everybody should be present so that the copies of the will could be furnished to all of them. All of them have come to on 14th day, main house, my father. They all came around 5:30 PM, so on 10/8/2006. It was a Sunday, on that day Narasimha Varala was also present. I had brought to the sealed cover by opening the bank locker at Karnataka Bank, Basungudi branch to the house. The said sealed cover was opened in the presence of my sister, my brother and my uncle. I found there was a notarized copies of the will inside the sealed cover. There were 7 notarized copies of the beside the original will. If the holder of the bank locker is dead, his nominee will be permitted to open the bank locker and claim it had to be made LR with the bank. It is true to suggest that none of the LRs of my father had subscribed their signature at the said bank consenting to the my locker. He is not a nominee, assuming for here. On the very day, on 10/8, only when we opened another cover, which was kept in the bank locker by my father. In the said cover, there were FD receipts and a share certificate standing in the name of my plaintiff, Manjana. I had not obtained any acknowledgement from my sister and brother for having served the notarized copies of the will of my father. I had not even obtained any acknowledgement for having distributed the FD receipt as well as share certificate which we had found in the other cover. I do not have any other witnesses other than my uncle Narasimha Varala to evidence that I had distributed the notarized copies. FD receipt and share certificate to my sister and my brother. My father had 2 bank accounts in Karnataka Bank, one is Basanagudi. Now here my next para 32, you will actually make kindly. It is true to suggest that as long as my father was alive, he was residing in the room adjacent to veranda. It is true to suggest that normally my father used to sit in the veranda and used to interact with the visitors and the children at the house. In the room adjacent to veranda, the almirah and all other belongs to my father was stored. During his lifetime, it is true to suggest that my father had kept all the valuables in the said almirah. It is true to suggest that he was in custody of the key of the almirah exclusively. It is true to suggest that subsequent to death of my father, the said key of almirah came to my possession. Only after the death of my father, I had opened the said almirah. No inventory of what was available in the almirah was prepared by me. I did not obtain any permission from either my sister or my brother before I opened the said almirah. It is not true to suggest that in the said almirah, my father had kept his unaccounted money, jewels and documents, witness, volunteer. There were only documents in the said almirah. My father had 2 almirahs in his room. It is true to suggest that my father was in exclusive possession of the keys of both the almirahs. I opened the lock of almirah and there was a cash of 1 lakh in other almirah, witness, volunteer. Here, the further, I go to the further paragraph 36, 151, page 1. I do not know who assisted my father in execution of the will. I do not know whether any plan or a sketch was prepared while drafting the schedule of the will. The said property measuring 34 into 139 feet, as per the will, have been confirmed an area of measuring 67.5 feet into 20 feet in the said will. Plaintiff Manjanath has been conferred in the ground floor on an area of measuring 34 into 15 feet only. The first floor on the said property given to Manjanath has been given to Vasudev. It may be that if they compare the allotment of the property under the will to Manjanath and Vasudev, what has been given to me is too much and it's too meager of them for them. So Lakshmi, this is the paragraph 36 is relevant. I have not withdrawn any amount from the fixed deposit by father. It is true to suggest that I have stated in my affidavit evidence and subsequent to death of my father, I had withdrawn the fixed deposit amount of my father, which he had received from the sale of property, and the premium amount received from the tenanted land has been deposited in FD. I have not obtained any permission in writing from my brother, sisters, and withdraw the amount. And I know the scribe, you will ask me kindly. I know the scribe and attestants of the will, and they are known to me. Till the death of my father, I did not know about the will of my father. My father was suffering only from BP and sugar complaint and also twisting of nerves in the light of the lower leg. It is not true. It is true to suggest that my father was taking a treatment in Netradana Hospital, Maya Hospital, and Wokad Hospital. He had also taken treatment at Jain Hospital. There are documents evidence about the various diseases suffered by my father and what was the treatment taken by him. The said documents are in my custody only. I have no object or producing them in this case. When my father was aged 83 years, he was not able to view anything, but he was operated here. The crucial point is, one of the major defense contention what we raised is, he was not in the position to read and the will that was in without the spectacle. That is in the admission, there is a clear admission. I'll take my lord to the relevant portion of it. No operation was done for hearing a problem, but he was used to using hearing aid. My father went to eye operation in 2002 and 3. It is not true to suggest that since 1995, when my father was aged 83 years, till his death, he was unable to see anything. He was unable to see anything. It is true to suggest that since 1995 till his death, my father was hard of hearing. It is not true to suggest that during the year 2000, my mother had no mental stability and dictate the detail of the will, which I am relying upon. It is not true to suggest that Exhibit D9 will has been created by me in collusion with Rama Urala and Narsimha Urala without informing the truth content of the said document to my father. It is true to suggest that my father was treating all his children alike. I do not know that my father never intended to unequally distribute his property among his children. Under the will, plaintiff Manjanath has been confirmed the property at the tail end of a building on the rear. To reach the same from the main road called DVG Road, one had to enter the common passage from the west to east and travel about 30 feet, had to take a deviation towards the north, and again had to take a deviation towards the east and reach the common passage at its entrance from DVG Road, measuring about 4 feet in width. When one takes a deviation to the north, the width of the passage is reduced to 2.5 feet. When turned towards the east from the said north deviation, the passage measures about 3 feet and it has also stairs in it. It is true to suggest that said staircase measuring 1.5 feet in width. At para 6 of my affidavit evidence, I have stated that the plaintiff Manjanath was not disciplined in life. According to said indiscipline is that he was not obeying my father, nothing else. It is not true to suggest that Manjanath was always obeying the commands of his father and never disobeyed him. My all brothers are aware of the disobedience of my father's words by Manjanath. There is no document to evidence that my father had confirmed my house to Yogi Upadhyaya. I do not have any document evidence to that my father had distributed the sale proceeds from the sale of Jainagar to my sister and others. I do not know the actual consideration amount of the sale, but as per the registered sale deed, rupees 5 lakh and add, I do not know what amount was written by my father after distributing a portion of it. Whereas the witness volunteer, I am only deposing in that regard as stated by my father, but I do not know the details. I do not know my father had retained the entire consideration amount with him at his house. I have stated in my affidavit evidence that my father, before taking all major decisions by him, he used to concern my brother-in-law Yogi Upadhyaya. My father had not consulted Yogi Upadhyaya before he scribed the will. Now, here, my lord, that Yogi Upadhyaya be examined as a PW2, your lordship. I am not personally aware whether my father actually measured the property and demarcated it before he scribed the will. I have only so stated on the statement of my uncle, and also after going through the contents of the will, it is true to suggest that in the will, there is no writing that my father had measured the property and demarcated it. So that is the
Yes, sir. Now come to attesting witness and scribe. What's your cross-examination?
correct. scribe, DW 4 and 5, that is a 4 and 5. They are the scribe and the attesting witness.
For DW 4 yaar avaru relative.
4 iವರು Mr. That is our brother-in-law. That is our Narsim Aurala witness, attesting witness, uncle.
Younger brother of the testator.
Younger brother of
And his evidence will be crucial. Let us see. Let's see what's his evidence.
younger brother
At
of
page
DW Narsim Aurala. That is
Page-
your lordship 188, my lord.
188.
Page 188 of the paper book, my lord. Your lordship kindly hear the cross-examination portion at point out that is dated, my lord, 24/9/2010 on 192, my lord, page 192. Your lordship kindly
Yes.
defendant number 1, Krishnamurthy, requested me to depose in this case, and therefore I am deposing. Since last 10 to 12 days, I am residing at Bangalore. It is true to suggest that I have been residing with defendant number only. Since last 10 to 12 days, it is true to suggest that the defendant number 1, Krishnamurthy, had taken me to his residence, his advocate in this case. It is not true to suggest that the advocate had instructed me as to what I should depose. Witness volunteer, I only instructed the advocate about the facts of the case. I do not know reading and writing in English. The advocate took my instruction and then on the next day brought me to the court where my affidavit was solemnized. Since last 10 years, I am hard of hearing. It is true to suggest that power of my memory has decreased compared to my earlier memory of younger days. It is not true to suggest that I am unable to state what happened about 20 years ago. Witness volunteer, I am capable of remembering and telling all those events. Plaintiff Mandamus was wedded about 30 years ago. I do not remember the year when he was wedded. His wife is Gauri. 2 months before execution of the will, I had come to the Bangalore, at which time my brother had told me about his intention to execute the will, and therefore had come to the Bangalore subsequently. Had come to Bangalore on July 13. After I was informed 2 months before to come to Bangalore, I directly went to the house of my brother. On that day, at his house, my brother and all sons, Krishnamurthy and wife, were present. On the very day, my brother told me that there was an immediate need for execution of the will, and he wanted somebody to scribe it, and I told him that I am known to one writer. One Sadashiva Rao is known to me for more than 20 years. Witness volunteer, he belongs to my native. He was a deed writer at the time of execution of the will. I do not remember the place of residence of Sadashiva, but he was residing at Bangalore. I called Sadashiva over phone, and he came in the evening, and I had his phone number. I am unable to recollect his phone number. I introduced Sadashiva to my brother. My brother had prepared notes, and he gave the said notes to Sadashiva, and also gave oral instruction as to what should be incorporated in the will. Sadashiva jotted down the instruction and returned only to return on the next day, and he measures the properties. Before signatures were subscribed to the will, Sadashiva had visited the house of my brother 4 times. He came to the second time after instruction were given to him on that first day. When I arrived to Bangalore, the third time he came on the next day, that is on 16, and he had brought a prepared draft of the will. My brother and Sadashiva alone measured the properties the way CTC. I was not present when they measured the property. I do not know who held the tape to measure the property and who noted it. I was present both on 15th and 16th of the said month. On 15th, Sadashiva came around at 4 p.m. and he was there in the house of my brother up to 5:30 p.m. I do not know the mode of transport in which Sadashiva had come to the house of my brother. On 15th, Sadashiva showed me the draft will to my brother. On seeing the same, my brother told that it was correct. I do not know whether my brother had retained the copy of the draft with him or not. I was present when my brother gave instruction to Sadashiva Rao. A witness volunteer, I remember some and I do not remember the other instruction. My brother told me that he had given the share to all his sons in the house. My brother did not inform me as to whether he had equally distributed the properties to his children or not. Witness volunteers, he was not in the habit of informing anybody that he used to take his own decision. He never had any habit of consulting me before doing anything or before taking any decision. If questioned whether I was asked to come to the Bangalore only to the signatory to the will, I say not like that, but I was simply asked to come Bangalore and therefore I had come, and only after he gave the instruction to write the will, I came to know about his intentions. So long as I was staying in 4 days at the house of my brother, at that time, none of his brother and other sons and daughters visited my brother's house. At that time, in the suit property, none of the other sons of my brother were residing in any of the portion except the wife of and children of Krishnamurti. The second daughter of my brother is Jayalakshmi. I do not remember when she was wedded, but she was wedded at Bangalore. The second daughter, Jayalakshmi, was wedded even prior to the execution of the will. I do not know where she started reside after her wedding. I do not remember that in the year 2000, both Jayalakshmi and her husband were living in the downstairs of the portion of the suit property. At the suit property, there are in all 5 houses and 2 shops apart from that portion in which my brother was residing. I do not know where Ramavrala was residing in the year 2000. If suggested that in the year 2000, said Ramavrala and his wife and children were residing in the downstairs of the one of the outhouse of the suit property, I say I do not remember the year, but they were residing at some point of time at the said property. I question who are taking care of my brother and taking him to the hospital during the year 2000. I say it was the wife and children of Krishnamurti, but I do not know about the other sons and daughters as to whether they are taking him to hospital and taking care, as I was not present at Bangalore. I do not remember when the wife of my brother died. Subsequently to death of my wife, of my brother, Vasu, the son of my brother, as well as his wife, were living with my brother. There was some misunderstanding between wife of Vasu and my brother, and therefore they went out of the house, and subsequently my brother had visited my native place along with Krishnamurti. My brother had visited my native place along with Krishnamurti to visit a temple, and he had told me to ask his children as to who would take care of my brother, and he would grant the house in which he was residing to those who had taken care of him. I had then inquired with Krishnamurti as to whether he was prepared to take care of my brother by telling him that the house belongs to my brother and he would grant it to those who take care of him. And if Krishnamurti was not agreeable, then my brother would inquire other children and grant property to them. And if nobody was prepared, he would grant the said property to some institution. Then the Krishnamurti had agreed to take care of my brother. At that time, Krishnamurti was working at a Coimbatore. At that time, my wife and children of Krishnamurti were also residing at Coimbatore. And after Krishnamurti agreed to take
Continue.
care of his father,
Continue,
Yes.
230.
problem.
ಅಲ್ಲ ಎಷ್ಟು ಇದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನಿದೆ ಸರ್?
Allah, who the grievance is melad.
ಇಲ್ಲ ನೀವು ನೋಡಿದ್ರೆ ಓದ್ತಾ ಇದೀರಲ್ಲ, ನಾನು ಹುಡುಕ್ತಾ ಇದೀನಿ ಎಲ್ಲಿ ಏನ್ ಕೇಳ್ಬೇಕು
That is the finding of the.
ಕಡೆ ಎಲ್ಲಾದ್ರೂ ಕೇಳಿದೀರಾ ಇದು ಕೊಟ್ಟಿದೆ ಅದು ಬಾಡೆ ಇಲ್ಲ ಅಂತ ಎಲ್ಲ ಕಡೆ ನೋಡೋಣ ಮುಂದೆ ಕೇಳಿದೀರಾ? ಕ್ರಾಸ್ ಅಲ್ಲಿ ಏನು ಇದು ಎಕ್ಸಾಮಿನೇಷನ್ ಚೀಫ್ ತರ ಅನ್ಸುತ್ತೆ ಇದು.
ಹೌದು.
I got confused. I went back and checked out whether it's chief examination or cross examination.
Oh, cross examination.
Cross.
There is a very
polite cross examination. Sounds like examination.
Oh, examination chief is doing it. You are Rashid is
Admitted.
All right, continue at 230.
Oblige them, please.
ಬೇರೆ ಕೋರ್ಟ್ ಅಟೆಂಡ್ ಮಾಡ್ಬೋದಲ್ಲ ಸಾಮಾನ್ಯ 4 o'clock
ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಲಾಸ್ಟ್ ಫ್ರೈಡೆ ಕಾಂಪ್ರಮೈಸ್ಗೆ ಅಂತ ಇತ್ತು. ಇವತ್ತು ಪ್ರಪೋಸಲ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬುಧವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ ನಾನು ಪಾರ್ಟಿಸ್ ಇದು ಮಾಡ್ತೀನಿ. ವೆನ್ಸ್ಡೇ ಮೇಲೆ ಪಾರ್ಟಿಸ್ ಟು ರಿಪೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್.
For interruption. In matter, there is urgency for tomorrow, my lord, not move.
My lordship, kindly permit me. Serial number 19, my lord. I am for the plaintiff, I am the appellant in this case, my lord. Kindly have it next week, my lord. I can parties is engaged to seniors, my lord. Instruction ಬೇಕಂತೆ ಅದಕ್ಕೋಸ್ಕರ. My lordship in
Serial number, serial 53.
Petitioner is a university, my lord. Lord, in the year 1982, the land in survey number 149/2 was granted 8 acre 40 gunta. Sense was granted in favor of the petitioner, my lord. Now, my lord, the very same land has been granted to fifth respondent. Very same land. I have produced the sketch, my lord, at page number annexure C. And now they have come annexure C, my lord, at page number 35. That the portion which is marked, my lord. The total area, the sketch was granted in my favor earlier. Now, my grant was in the year 1981-82 month. Date of at annexure, my lord, D, the order. I have produced the order also, my lord. Date of the order on 15/11. 1 minute, my lord. Sorry. 1982.
26/3/82.
Yes. Good. Howದು. 26. That is to the fifth respondent. Same land, within my land only. Andre whatever is granted earlier to me, now they are making that puja and all. That's what to build a structure.
It is
What for stay of the.
this land was granted to the university for the purpose of Atada Maidana. But it has to be utilized within 2 years.
That has been.
ಅದು ಇವ್ರು ಈಗ ಬಂದು ಇದು ಮಾಡ್ತಾರೆ. ಅದೇ I'll get the instruction. Yes.
ಹೌದು ನಾನು that annexure A and B the grant order, my lord. Now that's the very
Annexure
same
A.
challenge, my lord. Annexure A and B, wherein 25% of the market value that 2 acre was granted. Then later that has been modified in the year 2023, saying that 25% ಬದಲಾಗಿ 10% of the market value. ಏನಿಲ್ಲ, it's DC ಅಲ್ಲ, ಇದು ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡಿ.
Government order.
Yes, sir.
To make further grant. Without cancelling their debt. Matter in first consideration. That is the matter. The order.
Order. Order is 2022 order.
23. Lord,
Ala,
I need a hand delivery, my lord, because the fifth respondent is now starting construction. Hand delivery. Fifth respondent is start. Please. Legitimate.
Fifty-six. Respondent. There is one aspect, my lord, which in fact I wanted to bring to your lordship's notice. They have sold, my lord, this southern half portion also, which has been granted to them. So, of course, they have sold that matter, left the place, settled at Bombay and Goa. ಅಂದ್ರೆ ದಕ್ಷಿಣ ಭಾಗದ ಅರ್ಧ ಗ್ರಾಂಟ್ ಆಗಿತ್ತಲ್ಲ ಅದೇ ಸರ್ವೆ ಸ್ಕೆಚ್ ಅನ್ನು ತೋರಿಸಿ No, there is not relevance, not only for confidence of the court. That's it's not relevant. It's a place. What relevant? Serial number 15.
Yes.
I'm reading the cross-examination portion of DW4. Actually, no, I'm not troubling. So for the Rama was-
ಇನ್ನೊಬ್ಬ brother.
There will be an exam. DW6.
DW6.
The scribe, very limited portions of. The scribe starts from 210 and examination, that's 212 is the cross examination. Now, only the limited portions are there. The 198, para 21. DW4. DW4 evidence, the attesting witness. Lakshmi, kindly, on 16th, Sadashiro came to the house of my brother at 3:30 PM and with the will. To my memory, my brother had not instructed Sadashiro to prepare the copies of the will to be given to his children. On the last day, that is on 16th, my brother read the will and then described the signature. My brother did not carry out any corrections in the will. He read the will for about half an hour to 45 minutes. After reading the will, he subscribed the signature to the will and asked me to subscribe my signature. To my memory, my brother had signed all the pages of the will. but I cannot say how many signatures he subscribed to the will. When Sadashivara brought the will and my brother read and signed it, myself, my brother Sadashivara and Somshekar were only present, and except we four, none of other was present. All this transpired inside the house of my brother. If questioned whether the Krishnamurti was aware of the writing of the will on that day, I say he was not present. If questioned whether Krishnamurti was informed over the phone about the said will, I say there was no telephone at the house of my brother. If questioned whether the wife of Krishnamurti was aware of the will, I say she was present in the house. Sadashivara did not read over the will to my brother. Witness volunteers, my brother himself read the will for himself. Witness Somshekar was residing nearby the house of my brother. Once my brother had shown me the house of Somshekar, and therefore I am aware. It is true to suggest that there was an advocate who was residing at the suit property in the year 2000. Where witness volunteers, I do not know his name and other details. I do not know that my brother was a very close friend of the said advocate. That is the present counsel appearing for the first defendant. After my brother signed the will, I subscribed my signature, and thereafter Somshekar and finally Sadashivara witnessed volunteers. Sadashivara had always affixed the seal. I had also written my address after I signed it. So also Somshekar and Sadashivara wrote their address. Subsequently, all the four of us went to the notary. There my brother signed in a register, and then the formality was completed. I do not remember the name of the notary, but I notary was a lady. Somshekar had informed about the said notary, and therefore all of us went to her. From the office of notary, we returned to the house of my brother. And the next day, I went to the house of my children at Bangalore. 2 to 3 days or later, I returned to the house of my brother. It is true to suggest that my brother had a separate room for his residence as well as to keep all his articles, which was on the right side of the house. If one enters the house, which was adjacent to drawing, witness volunteer, there is only one. It is true to suggest that my brother used to keep all his cash, valuables, and said, I do not know where the said will was preserved by my mother. During the year 2006, my brother was seriously ill and later died. It is true to suggest that I had visited him at the hospital at the time. All the children of my brother were cordial with me. The execution of the will was known to all the children of my brother, and therefore there was no need for me to inform them about the execution of the will by my brother. My brother died at the hospital only. I was not present when he died at the hospital. I came to Bangalore 3 or 4 days after the death of my brother. I was present at Bangalore only till all his performed. 13th day ceremony was conducted subsequent to death of. Subsequently, even the month of ceremony was conducted. The 13th day conducted at the Guru Krupa Kalana. I took her responsibility and lead the performance. Now, para 27. The wedding talk of the plaintiff Manjuna took place at the house of my brother only. It is true to suggest that Gauri, wife of Manjuna, was a relative through the wife of my brother, and she and her family was very well known to our family. There was no reason for my brother to refuse Manjuna's wedding Gauri. Witness volunteers. He was only stating that there should not be any relative added to Manjunath. Father of Gauri was not my relative, but was a relative of my brother. The panchayat was about performance of the wedding of Manjunath was at the house of my brother only. At that time, me and my brother and father Gauri was also present. My wife, my brother was absent at that time. I do not know the qualification of the Manjunath, but I have heard that he is an engineer. Gauri was working at the Bangalore Milk Dairy. I do not know where Manjunath was working and his place of working when he wedded. It is true to suggest that I did not agree for Manjunath wedding Gauri by stating that she belongs to poor family. It is not true to suggest that even Krishnamurti opposed the said wedding on the same ground. It is not true to suggest that Manjunath was not heeding to my words at all. Witness volunteer, he came to my village only as I told him to come. My brother did not perform the wedding of Manjnath at all. Only it is me who performed his wedding. My brother had told Manjnath, if you were to wed Gauri, you should not enter his house. And should leave separately. I advised my brother not to say so and entertain Manjnath and his wife to the house, but he did not agree. It is true to suggest all children of my brother started to live separately from my brother after they wedded. It is true to suggest that likewise even Manjanath started to live separately with his wife from my brother. It is not true to suggest there was only no any ill will or misunderstanding between Manjunath and my brother. It is not true to suggest that there was no any ill will or misunderstanding between my brother, Manjunath and my brother. It is not true to suggest I am deposing falsely. There is no writing the will my brother that he was unhappy with the Manjunath for he wedding Gauri against his wishes. I do not know my brother had got vacated a portion of suit schedule house and gave it to Manjunath. Witness volunteers. I only came to Manjunath was occupying a portion of the suit property. I never visited the house of Manjunath at Bangalore. Witness volunteers, but he has visited you to visit my house at my native. On 14th day of the brother at his residence, I told the Krishnamurti to bring a packet of which was kept in the iron trunk from the room of my brother. And after opening up the envelope, I asked him to furnish the copies of the everybody and he furnished. It was not appointed as the executant of the will or to distribute the copies of the will to all children of my brother. I distributed the copies of the will as per the direct. I do not remember whether there was any writing in the will about the preparation of the copies, and there were the bonds of my brother in the said iron trunk. The bonds are also distributed to my brother. It seems there is no writing. No property was willed by my brother to the eldest daughter. My brother had told me that he had kept 1 lakh for the performance of the death ceremonies. And there was no money except the said 1 lakh with my brother when he had died. Copies will be distributed to Krishnamurti at my instance, but I did not personally hand over the same to each of the children. No acknowledgement is obtained in handing over. It is true to suggest that the hotel of my brother was the most popular hotel at Bangalore during his time. It is true to suggest that he had a huge income. It is true to suggest that he had sold the site before his death. Witness volunteer, I was informed about by him. My brother told me that he had a distributed amount of consideration of sale among his children, but I do not personally know. I had not inquired as to what amount was paid to Manjunath. I do not know what was the medicine, what medicine was administered to my brother, and which doctor treated him in the year 2000. It is true to suggest that in the year 2000, Krishnamurti was working outside Bangalore. It is true to suggest that son Manjunath was also studying outside the Bangalore at the time. I do not know who was taking my brother to the doctor for treatment, who was fetching in the medicine. It is true to suggest that my brother was depressed over the death of his wife and his children were living separately. Witness volunteers, he are depressed to some extent, but not full. It is true to suggest that under the will, there is no equal distribution of the property. It is not true to suggest that at the time which I am stating that my brother wrote the will, he was incapable of executing any will. It is not true to suggest that the said will has been prepared as informed by me and Krishnamurti only. It is not true to suggest that my brother was unaware as to what property was given to whom under will when he scribed his signature to the exhibit D9 will. It is not true to suggest that even Krishnamurti was present when exhibit D9 will was prepared. I am deposing falsely. It is not true to suggest that my brother had no intention to executing any will at all. Witness volunteer, he had no confidence in these children. If questioned in whom my brother had no confidence, I say it is Vasu and Manjara. My brother had told me so. Witness volunteers, my brother had declared that he would not give any property to them. And I had told him that he should not do so at the time of wedding of Manjunath only. My brother had so declared 6 months prior to the will when my brother had visited my native place. He had declared that he would not give any property to Vasu, as he had vacated the house and residing separately. It true to suggest that Vasu vacated the house as there was misunderstanding between my brother and wife of Vasu. It is true to suggest that my brother was ill-tempered and never used to eat anybody. My brother had no any ill will against the children, his children, except that he was angry to some extent. It is not true to suggest I am deposing falsely, stating that my brother had told me that he would not give any property to Vasu and Manjanath. Children of my brother were all aware of the contents of the will of my brother. The envelope which during 1942 only our ancestral properties were divided between me and my brother and my father. I have retained my portion while portion of my brother has been cultivated by me. If questioned who used to take the yield of the property of my brother at my native, I say my brother never demanded for the said yield and I am using it. All the children of my brother were aware of that my brother had declared that he would not give any share to Manjanath and Vasu, that he would give his residential house to Krishnamurti only even prior to his death. Manjanath is a residential in the FTS. Manjanath is resident in the main house in which Krishnamurti is residential at the Sud property. In the ground floor in which Manjanath is residing, his sister Jayalakshmi is residing. If questioned whether I had visited the house of Manjanath, I say I am not and I am unable to climb the stairs due to my ill health. I had come to Bangalore in a car and not in a bus. I never came to my mind that I should visit the house of Manjanath and see his living. It is true to suggest that Krishnamurti is the eldest son among all children of our family. It is not true to say, therefore I have got extra affection towards Krishnamurti. It is not true to suggest, therefore I am deposing part. This is the attesting witnesses, the cross-examination. In fact, only what we tried to point out from the entire cross-examination is because the present DW4 is looking after the properties of my father. He was an interested witness. That is all what we try to. And next, my lord, DW5 is the scribe. He was now and cross-examination dated 19/10/2010 at page 200 and maybe kindly be. It is a very limited. I'll take my lord to the one is the relevant paras. I was not knowing permission. It is a page paragraph 5. I was not. I retired from service in December 1991. I know the procedure to be followed as a deed writer. I was not knowing Parmeshwara Urala prior to 2000. Witness volunteer, but I had heard about him as the owner of Vidyarthi Bhavan of Bangalore and that's all. I had ascribed will of a Parmeshwara Urala. At the instructions of Parmeshwara Urala only, I scribed the will. One Mr. Narsimha Urala, the brother of Parmeshwara Urala, had introduced me to him. It was on 13th July 2000 only. I was introduced by Narsimha Urala at the residence of Parmeshwara Urala at DVG Road, Vasanugudi. On 13th July 2007, I was called over phone by Narsimha Urala to the residence of Parmeshwara Urala. I was asked to morning. I went out to the Urala at 3:30 p.m. On the said day, I might have left my house at about 1 p.m. As it is necessary to travel a long distance from my house to the said house, which may consume not less than 2 hours. I was residing at a judicial layout, Telanka. Narsimha Urala was aware of my phone number as well as my residential address. When I visited the house of Parmeshwara Urala, only he and Narsimha Urala were present in the house. Parmeshwara Urala had told me that he wanted to execute the will. I should scribe it by saying so. He had given me the details of his children property. He gave it in writing. Parmeshwara Urala had noted in his writing that to which property should go to which of his children. Then I prepared a list of myself in a proper form to my convenience and then scribed the will. Parmeshwara Urala had 2 sale deeds with him and he had given me xerox copies of the same. Parmeshwara Urala had not prepared any sketch, much less he handed over any sketch to me. I do not know what happened to the information given in writing to me by Parmeshwara Urala, but it might be given, it might have been destroyed and I did not preserve it. I had carried the said writing to Parmeshwara to my house, my home, prepared the draft will and returned the Parmeshwara on the next day. I had destroyed the said writing of the house of Parmeshwara on the next day of 13th July. I revisited. The draft was prepared by me at my home on 13th only. On the next day, I had returned with a draft to the house of Parmeshwara, and it was also in the afternoon. Even then, only Parmeshwara and Narasimha were present, and none other. Parmeshwara read the will, and also we measures the properties later. Only your Parmeshwara read the will, and also we measure the properties later. Only myself and Parmeshwara measure the properties, while Narasimha confined himself to the house and did not came out of the house. We measure the properties with the help of big tape and should be round in the nature in a box. The length of the tape measured more than 10 meters. In the writing given to me by Parmeshwara, I had not mentioned the property number, measurements, and the boundaries and other details as to whom the property should go to. I had prepared the draft will in accordance with the said written instruction only. I had entertained a doubt about the measurement of the properties as well as certain places. Parmeshwara had mentioned the measurement at 2.5 feet and sometime 4.5 feet etc. And therefore there was a measurement. I do not remember the east-west measurement and north-south measurement of the property that was willed. I do not remember the width of the passage of the extreme side of the east, and I have to go through the documents clearly, correctly answer it. We had measured the property that it was willed to Krishnamurti. I do not remember the measurement of the same as well as the boundaries. Witness volunteer, I have to go through the document to read, depose, and read the will at the 16 July. I am unable to state the measurement. I got the draft translated to stamp paper by way of typing. It may be that I have preserved the draft will, but I am not sure. And sometimes I preserve it, and if it is available, I would produce the same to court. Only Parmeshwara, Narasimha were present. Then fair will was prepared. The will was drafted on the stamp paper of ₹90. I purchased the stamp paper on 13th only at Telanka. The stamp paper vendor was 1 Rupashri. I purchased the stamp paper at 6:30 p.m. even prior to the approval of the draft by Parmeshwara. I had purchased the said stamp paper. I got the will typed at a typist at BDA complex of Koramangala. If questioned why I had got the same prepared at Koramangala, which is one the extreme south extreme of Bangalore, while I reside at the extreme north of Bangalore. I say I have been visiting Koramangala once in 3 days or so, and therefore on 14th I got will typed on the stamp paper. I again say it was on 15th. I had handed over the typed will to Parmeshwara on 15th only. It was about 3:30 p.m. Parmeshwara went through the will and stated that it was correct, and I should revisit him on 16th next day. It is true to suggest that after the will was prepared and handed over, my job was over. I came to him on the next day as it was necessary for him to sign in my presence so that I could subscribe my signature as a scribe later. It is true to suggest there is no law or a rule which mandates that the executant should sign. If the presence of the scribe and only the scribe should affix his signature to the document. It is true to suggest that Narasimha is my friend. I do not have any information about the number of issues of Parmeshwara Urala and how many were wedded at the time and whether they was residing with the children or living separately. It is true to suggest that scribing the will, it is necessary to inquiry about the nature of property and the family background to the executant of the will. I was not aware about the previous health condition of Parmeshwara Urala and his mental condition before I visited him, but he was physically and mentally fit when I visited him. I did not know about personal relation between Parmeshwara and his brother and depth of it. Parmeshwara had equally distributed his property to his children, but he had given a little more to one of his sons. It may be that in the said will, nearly 50% of the property is alone given to the Krishnamurti only. Parmeshwara had given one property to his one daughter and told me that he had sufficiently given to his other daughter. He had not specified at what actually he had given to the other and daughter to understand that it was sufficient. Even on 16th, when I visited the house of Parmeshwara, only he and his brother Narasimha were alone present, witness volunteer. Only later the other were invited. They had called Somshekar to their house. He had visited the house of Parmeshwara at about 4:30 p.m. I do not remember whether it was called with my presence or was called earlier. On 16th, when I had visited the house of Parmeshwar, I had mentioned the measurement in writing, as it was only in figures earlier. I had also obtained the signature to the said document. I had visited the house of Parmeshwar in all 4 times. Each time I visited, I had sat in the drawing room of the said house of Parmeshwar. On my 4 visits to the said house, I did not see any other person in the said house other than the Parmeshwar, and I was supplied a coffee each occasion I visited the said house. The said coffee was supplied by me by a lady. For the first time, I saw Krishnamurti Urala only during 2 August 2010, when he visited my house on 16 July 2000. I had subscribed my signature to the will as a scribe. After scribing my signature, I did not return home. If I question where did I go, I say we had gone to the notary subsequent to the signatures Parmeshwara. The name of the notary looks to me Nagalakshmi, but her house was very near to the house of Parmeshwara. I am unable to state her address. In the presence of notary, I did not subscribe any of my signature to any document, including the will. Only Parmeshwara Urala subscribed his signature before the notary. I returned to my home directly. It is not true to suggest I am deposing falsely, stating that Parmeshwara Urala had told me that the will prepared by me was correct. It is not true to suggest that Parmeshwara Urala never instructed me to prepare a will, and I had prepared a same at the instance of the Narasimha Urala and Krishnamurti only. It is not true to suggest that neither me nor Parmeshwara visited any notary and I am deposing falsely. It is not true to suggest I am deposing falsely based on the Narasimha Urala, who is my friend. It is not true to suggest that physically and mentally incapable of getting the will drafted in the length which is at Exhibit D9. It is not true to suggest Narasimha Urala only. The measurement of the property was mentioned in the will after going through the measurement given by Parmeshwara Urala. As well, after measuring the property, we might have taken about 45 minutes to complete the process. This is the cross-examination portion of the scribe, my lord. Now you will ask me what exactly the pleadings of the before the court below, my lord. You may request, my lord. There are all are filed a written statement. Only I will confine to rejoinder portion of the my rejoinder before the court below. Only very limited short rejoinder. You may request, my lord. Page. They might differ. The learned judge has extracted. Page 32 is the rejoinder. This is the will has been set up only after filing of the suit, and after then with the permission of the court under order 829, the rejoinder is permitted and we filed it. Only 2 paragraphs that are there in the rejoinder. The defense with and substance, my lord. The allegation of the allegations of defense that the deceased Parmeshwara Urala executed a will dated 16th is false and incorrect. Para 2. The third paragraph, the mother of the party dies in the year 1994. The deceased S.A. Parmeshwara Urala was suffering from loneliness after the demise of the mother of the party, that is the wife of S.A. Parmeshwara Urala. You knew of the various facts, including the conduct of his children. The plaintiff submits that the deceased Parmeshwara Urala was suffering from various ailments, including diabetic, blood pressure, and varicose vein. He was also operated and was suffering from stress and strain. The deceased Parmeshwara was not in a position to understand the things properly. He was not in a mental condition to take proper decision of his own. Fourth para is relevant. The plaintiff submit that first defendant had dominated the will. Well, I may kindly appreciate. The plaintiff submit that the first defendant dominated the will of S.A. Parmeshwara Urala, as he was residing with the first defendant in collusion with the witness to the will, namely Narasimha Urala, in order to knock off the properties of the joint family of my father at Saligrama, Udupi district. The first defendant in collusion with the second defendant and the said witness had misguided and influenced the S.A. Parmeshwara Urala to execute the alleged will. The alleged will has come into existence in a suspicious circumstances, and which will has also not brought into the picture till 2006. And further, the said will was not acted upon by any of the party. The allegation that scheduled properties were transferred to the respective parties is incorrect. Further allegation that the knowledge about the will is false. The allegation defend that deceased permission kept a notarized copy of the will was distributed to children and the FDRs. This is based on the pleadings of the court below, my lord. The 5 issues are only the relevant issue to be your lordship at this stage, only the issue number 4. Whether now so far the execution of the will is admitted, my lord. There is no dispute. The property is a self-acquired property, there is no dispute, my lord. The relationship of the parties is also not in dispute, my lord. Your lordship may kindly appreciate whether what exactly the law relating to the proving of the will, only in fact, recently also there is what I try to pursue, my lord, is, here is the case, my lord. Your lordship may kindly appreciate, it is an undisputed fact, the will was in 2000. The father, the one who was the executant, was passed away in 2006. All are residing in the same building, my lord. Now, that is an admitted fact. All children of the Parmeshwara Urala, all are residing there only. And there is a categorical admission by the PW, that is the DW1 himself, stating that there is at no point of time during the lifetime of the Parmeshwara Urala, he has been treating all children equally. That is a categorical admission by the person who is a beneficiary to a larger extent and unequal share. That is the only point for your lordship kind consideration at this stage. Here now suppose assuming for a moment, my lord. Now there all the children are well placed. Now the sister, one of the sister and the present plaintiff are only the 2 parties. They are disbelieving the manner in which the will was the disproportionate of the. Yes, that is the one that some amount has been now. Pardon me?
You are advocated that the man of working is a disciplined man. You also admit that the man of service, where in a political function, you are very disciplined. You take decisions independently. You also admit that you are elder brother and more parents to ask questions to his father. So he's an independent man.
That is. That is because it is not supported by your lordship is right, but that is not supported by. No. Your lordship is right. Gathering the cross-examination as a whole, what your lordship has pointed out is right. Because your lordship is the cross-examination, some of the cross-examination portion, the relationship between the father after the marriage was of the present context, that is exactly starts. ಹೌದಾ? There is a one few judgments. What exactly what your lordship is? One point out. ನೀವು ಹೇಳಿದ್ರಲ್ಲ, what your lordship is now pointed out to me, they relating to the unequal shares. So for the ಅದಕ್ಕೆ ಒಂದು that court has also your lordship. That is I do agree. Exact. Your lordship can take after the matter was argued before this court. They have fairly conceded They are also of the opinion, no, somewhere there is some error to be corrected ourselves, Santa. They felt it. They are of the opinion, the other defendants, other. ಅದನ್ನ ಏನಿಲ್ಲ ಇದು.
ಇಲ್ಲ ಅನ್ಫೇರ್ ಅಂತಲ್ಲ, ಸುಮ್ನೆ ಇವ್ರು ಜಗಳ ಮಾಡೋದ್ ಬೇಡ, ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡ್ಸಿ ಸಮಾಧಾನ ಮಾಡೋಣ ಅಂತ ನಾವು ಸೆಟ್ಲ್ಮೆಂಟ್ ಟ್ರೈ ಮಾಡಿದ್ದು.
One more, the point is, whatever the money was withdrawn from the bank, he is not a nominee. He was not a nominee. Under the will.
ಅದೆಲ್ಲ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ. You have admitted in your cross examination that you have received your share of money and fixed deposits.
I am not.
Why are you raising new dispute?
I am not disputed either.
Then let us not waste the time of the court.
No. I am the Sitaram Rao. But what best we, your lordship? That's what the Supreme Court judgment conscious of the.
Marriage also he was against. Marriage he was against.
Conscious of the ultimately.
Taken care of his father. Otherwise you would have given him what is it.
No. But
ಇಲ್ಲ
the court.
ಯಾರಿಗಾರು ಕೊಡ್ತಾ ಇದ್ರು, ಯಾರಿಗಾರ ಜಾಸ್ತಿ ಕೊಡೋರವ್ರು. ಈ ಕಡೆಯಲ್ಲಿ ಯಾರು ನೋಡ್ಕೊಳ್ಳೋದಿಲ್ಲ, ಎಲ್ಲ ಕೈ ಬಿಟ್ರು ಅಂತ ಹೇಳಿ ಕಡೆಗ ಕೊಯಮತ್ತೂರಿಂದ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಕರ್ಸ್ಕೊಂಡು ಅವ್ರಿಗೆ ಜಾಸ್ತಿ ಕೊಟ್ರು. ಕಡೆ ಮಗನ್ ಇಟ್ಕೊಂಡಿದ್ರು ವಾಸುನ, ಬಿಕಾಸ್ ಹಿಸ್ ವೈಫ್ ಕುಡ್ ನಾಟ್ ಗೆಟ್ ಅಲಾಂಗ್. He remains unrepresented in this court.
ಇವರು
ಅವ್ರೊಬ್ಬರೇ ಇದ್ದಿದ್ದು.
ಸೀತಾರಾಮ್ ರಾಯರವ್ರ ಜೊತೆ ಇದ್ರು.
ನಾನ್ ಅವ್ರ ಜೊತೆಲಿ ಇರಲ್ಲಪ್ಪ, ನಿಮ್ ಕ್ಲೈಂಟ್ ವಾಸ ಮಾಡ್ತಿದ್ದಾನಲ್ಲ ಆ ಮನೇಲಿ ಬಾಡಿಗೆಗಿದ್ದೆ ಅಷ್ಟೇ.
ಮನೇಲಿ ಬಾಡಿಗೆ ಆಗಿದ್ರು ಒಂದು ಪೋರ್ಷನ್.
He knows everything. That's why the right for.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ತುಂಬಾ ಕನ್ಫ್ರಂಟೇಷನ್ ಬೇಡ ಬಿಡಿ, ಈ ಅಪೀಲ್ ಹೋದ್ಮೇಲೂ ಏನನ್ನ ಮಾತಾಡಕ್ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ. ಅದಕ್ಕೆ ಜಗದೀಶ್. Even after his appeal is dismissed, we will explore the possibility of some settlement.
That's all the only the.
Respondents in submission, respondent number 2 ಗೆ ಒಂದು ಪೋರ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನು ಈ ಮಂಜುನಾಥ್, that is this appellant, is keeping that property with him and under will also ನೋಡಿ ಬಂದಿಲ್ಲ ಇಲ್ಲಿ ಬಂದು ಕೊಟ್ಟಿದ್ದಾರೆ.
You are not file a count up.
ಇರ್ಲಿ ಬಿಡಿ, ಈಗ ಅದೆಲ್ಲ ತುಂಬಾ ಕನ್ಫ್ರಂಟೇಷನ್ ಬೇಡ. ಈಗ ಮೊದ್ಲೇ ಹಠದ ಜನ,
ಕ್ಯಾರೆಕ್ಟರ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಬೇಡ ಅದೆಲ್ಲ. ಈಗ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದು 10 ವರ್ಷ ಕಿತ್ತಾಡ್ತಾರೆ.
Yes. There is no law as your lordship has suggested. Unequal share ಇದ್ದಾಗ to interference by the court. What exactly?
It cannot be done. Court cannot tinker with any will once if it is proved.
Any particular portion of the cross examination which you want to be.
Well, one submission.
The authority. ಅದರಲ್ಲಿ
Respondent 3, my lord. Authority on that alone is not a ground. Unequal substitution is not a suspicious circumstance I am citing.
Portion ಒಂದು recent judgment they referred that has been, but that has been the unequal share is the court can't interfere in the recent view of this court.
ಅಲ್ಲ ಸಾಹೇಬರು ಓಪನ್ ಮಾಡಕ್ ಮುಂಚೆನೆ ಹೇಳ್ಬಿಟ್ಟಿದಾರೆ ಅದನ್ನ.
ಹೌದು.
He could not have, he could have denied even 1 inch of space to you. That's what the honorable judge observed in the opening of the case.
ಇವ್ರು ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ 50%, ಇವ್ರೇನಾದ್ರು ಶೇರ್ ಕೊಡ್ಬೋದು.
ನೋಡೋಣ ಯಾರ್ಯಾರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತ.
Arbitrator is the right person.
No arbitrary.
Audit. Yes. Next. Yes. 2003 matter. ಯಾರು ಇವರು ಬರ್ತಾರೆ ಇವ್ರು ಕೋರ್ಟಿಗೆ? And who is G. Nataraj?
ಗಂಗಾಧರ್ ಐತಾಳ್.
ಇದೇನು ಫ್ರೆಶ್ ಫೈಂಡಿಂಗ್ಸ್ ಬಂದಿದೆಯಲ್ಲ? ಫ್ರೆಶ್ ಫೈಂಡಿಂಗ್ಸ್ ಏನ್ ಬಂದಿದೆ? I think comes to court. G. Nataraj yaru? All right. None appears for appellant and respondent. By way of final intelligence, really this matter on 29. Yes.
17.
17. ಫೈನಲ್ ಡಿಗ್ರಿ ಏನಾಗಿದೆ ಅಂತ ನೋಡೋದು ಗೊತ್ತಾಗ. ಇವ್ರು ಯಾರು? ಸಂಪತ್ ಶೆಟ್ಟಿ ಯಾರು? Yes, madam.
Appearing for respondent, my lords. My lords, the parties are negotiating settlement, my lords. If taken back the file, will report the settlement in or the possibilities in next week, my lords. 2 weeks, my lords. Serial number 17, my lords.
Yes, by tomorrow you verify and make a submission tomorrow.
My lords, they have just taken back the file.
No. Where is the senior madam?
Sorry.
2005 matter.
Yes, my lords.
Huh?
They've just taken it back 2 days back, my lords. 2 weeks, my lords.
No, I'm sorry. Next Thursday. Council appearing for respondent submits that the parties are negotiating and there is a possibility of settlement at her request. List it on so and so date.
Oblations.
Number 18.
Yes, sir.
ಅದರಲ್ಲಿ
ಗೊತ್ತಿಲ್ದಾ?
ಸೆಟ್ಲ್ ಅಂದ್ರೆ ಅವ್ರ ಕಡೆಯಿಂದ ಒಬ್ರು ಪಾರ್ಟಿ ಬರ್ಬೇಕು, ಅವ್ರು ಬಂದಿಲ್ಲ.
Next Thursday, council appearing for appellant and respondent submits matter is settled. Seek short accommodation to report settlement. Report settlement ಅಂದ್ರೆ ಬರ್ತಾ ಇದೆ ಅದು.
ಒಬ್ರು ಬಂದು ಇನ್ನೊಬ್ರು ಬಂದಿಲ್ಲ.
But on next date, I'm going to decide it on my.
Otherwise, I will argue. If he has
Thursday,
not
next
come.
Thursday.
Number 19. G. Narasimhamurthy.
G.V. Narasimhamurthy.
Next, next, ಇದರ ಇವರೇ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ.
ಇಲ್ಲಿ ಬರೋದು speak my lord.
2005 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸೀನಿಯರ್ ಅಂದ್ರೆ ಸೀನಿಯರ್ ಇರ್ಬೇಕು ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳಂಗಿಲ್ಲ. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ when the matter is called. Who are you, plaintiff or defendant?
I am for the appellant dependent.
Defendant.
Yes.
Decree for specific performance. It's
If-
granted.
Not to me. It is declaration and injunction.
Or declaration and injunction. Okay, next Thursday.
Much.
Number 20. Harish Pandari.
I appear for the appellant here in Lordship. Senior is held up in another court hall. The suit is for specific performance, Lordship.
You are well equipped to argue on facts. You narrate facts, your senior
Yes,
will
Lord.
join.
But here there are a lot of agreements involved here, Lordship, due to which senior has to address it.
Already make notes, let your friend open up this. Facts here, in matter, you appear for.
For Lord.
This appeal is by whom?
Second respondent.
This appeal is by whom?
Filed by the plaintiff.
Plaintiff.
Counter appeal also, filed by the
Yes.
first respondent.
ಏನು ರಿಫಂಡಾ?
Refund is ordered.
ಅದಕ್ಕೂ ಬಿಟ್ಟಿಲ್ಲ, ನೀವು ಬಿಡ್ತಾ ಇಲ್ವಾ? ಅದಕ್ಕೊಂದು ಅಪೀಲ್ ಹಾಕಿದ್ರು.
ನಾನು ಪರ್ಚೇಸರ್ಗೆ ಬೋನಫೈಡ್ ಪರ್ಚೇಸರ್ ಅಂತ ಹೇಳಿ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
You purchased before filing suit,
Before filing suit, and my agreement is prior in nature.
prior to plaintiff's
It's,
agreement.
her agreement.
It's a very confused situation, Lordship, here. I was a tenant initially. The appellant herein was initially a tenant. If I could, in the suit, Lordship, the first defendant was the owner. Initially, he enters into one agreement. Initially, he takes a part consideration from me, that is the first from me. There's a first agreement on 8/2/97
Your agreement is dated?
to the plaintiff, Lordship, 8/2/97.
Marked as exhibits?
P1, Lordship.
Date?
8/2/97. For a total consideration of 2,65,000, Lordship.
Advance?
25,000 was given on the said date.
With possession or without possession?
He was a tenant in that premises, Lordship.
What's the property involved? Residential house?
Yeah, he was in that property. We were residing in that property initially.
Whose
It
property?
is not a residential, it is a
Non-residential.
non-residential
Non-residential.
Top.
shop premise.
You appear for second defendant?
I
Second defendant,
represent second.
all right. Second defendant agreement, according to you,
Please, my lord.
ನಿಮ್ಮ agreement?
ನನ್ನ agreement is dated, my lord, it is 1996. One minute. Notes not found. Answer.
Lordship, there's another agreement subsequent to that. Even though he receives amount from us, he enters into an agreement with defendant number 3. That agreement is, Lordship, 13/4/97.
ಏನ್ ಸರ್ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ನೀವು ಹುಡುಕ್ತಾ ಇದೀರಿ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ. ಏನ್ ಸರ್, ವಾಟ್ ಇಸ್ ದಿಸ್?
ಆಯ್ತು ಅಂದ್ರೆ ಮಿಸ್ ಆಗೋಗಿದೆ.
ಏನ್ ಮಿಸ್ ಆಗತ್ತೆ ರೀ?
Sorry. Lord,
24/3/1996.
1996, yes, agreement of sale in my favor, 24/3/1996.
Sale deed?
Sale deed, my lord, in favor of me, 17/10/1998.
17?
Also
17?
17/10/1998.
17/10/1998.
This sale deed is not under challenge before your lordships.
Need not challenge it.
Second scheme.
And when suit is filed? And what was the period stipulated in your agreement?
Yes, Lordship.
What was the time stipulated in your agreement?
Lordship, initially, after the time period is over, they have extended the agreement further,
No,
Lordship.
first you answer my question.
Yes,
What is this, madam? What was the time stipulated under the first agreement? 8/2/1997,
6 months from the date of agreement.
6
Lordship.
months.
Date of filing of the suit is 14/12/1998.
Suit filed on?
14/12/1998. My agreement is 24/3/96. Their agreement is 8/2/97.
Yes.
My sale deed is 17/10/98.
Suit filed on 14/12/1990.
That means as on the date when the suit was filed, the property was disposed of in my favor. So they had all the knowledge.
Lordship, there are other aspects involved here, if I could address your Lordship. 6 months was the time period prescribed for our agreement, Lordship, for executing the sale deed. Subsequently, there are payments which has occurred. But the surprising fact is, Lordship, on 13/4/97, there is a new agreement which comes into picture which was not aware to the plaintiff herein. That is the agreement entered by defendant in favor of defendant number 3. If your Lordship could peruse the plaint everments, Lordship.
There is one more agreement dated 13/4/97.
There are many agreements involved here, Lordship.
13/4/1997. There is one more agreement.
That
in
is
favor of
agreement.
third defendant.
Third defendant.
He files a suit, Lordship.
Culprit is first defendant.
First defendant is involved here. He files a suit.
Based on this sale deed, I file an ejectment suit before the trial court. That suit, my lord, is decreed. Confirmed up to RSA before this court. 6 months' time was granted to vacate this man. He does not comply. Lord, based on the plea that my suit for specific performance is pending consideration, he dragged on. I filed a contempt petition before this court and took possession by virtue of contention.
You are second defendant, no?
I am second defendant. Refund of money has been directed to be given
A refund by D1.
by D. And
There is a cross appeal by defendant
was
number.
appealed by D.
Who appeals for defendant number 1?
Vishwanath. ಇದ್ರು
Idru alla. Idru andre ಏನು?
ಇದ್ರು ಅಂದ್ರೆ ಇದ್ರು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಡಪ್ಪ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ.
All right, ಬರ್ಲಿ. ಇದು first appeal. It will go for some time.
ಆಯ್ತು. Based on this particular third agreement, Lord,
Yes.
this third defendant files a suit for not bare injunction.
Temporary injunction.
ಯಾವುದು?
Third defendant files a suit
Ah,
for bare injunction.
I-
That injunction, my lord,
Is it tagged here?
ಇಲ್ಲ, tag
ಅದೇ
ಆಗಿಲ್ಲ. He withdraws the suit
Withdraws.
and he becomes a consenting witness in my sale deed.
In your slip.
Yes. Because I came to know that there is an agreement with this man, and thereafter, since my agreement was earlier in nature, my lord, this man consents to my sale deed.
Lordship, the surprising fact is that when the suit was stayed, a temporary injunction suit which was filed by defendant number 3 as against the defendant number 1, when the suit was pending, Lordship,
Madam, read only finding on additional issue.
Lordship, I have to address certain.
No, madam, please read, I'm saying. I will permit you
Yes,
to
Lordship.
argue.
Yes, Lordship.
Read. Where is the finding on additional issue? I think 6 and additional issue taken together or 1, 2, 3 and additional issue number 2. Oh, that is for loan. Security for loan anta. Where the finding on additional issue number 1,
Lord, page 118 of the paper book.
paper book.
13. Issue
That-
number 6 and additional number issue 1.
Paragraph.
13, Lord.
13.
Correct. They are taken together.
They are taken together.
That is the core issue. So you have to read that. You have to overcome the findings recorded on issue number 6 and additional issue number 1.
Yes, Lordship. But the aspect is here, Lordship, defendant number 3 has filed a suit for a temporary injunction. That suit was stayed, Lordship. When the sale deed what is executed, which is the other party's sale deed, that sale deed was executed when there was stay pertaining to the said property, Lordship. Subsequently, he files a memo withdrawing the case. But the sale deed what has been executed here, that is executed at the period when the stay was functioning, Lordship.
At whose instance? Not at your instance.
In respect of the entire property, what is the
Not at your instance.
I was not a party in that case initially.
Then
Lordship.
how you can
I
take
get
the-
myself impleaded there. Once I file my impleading application, they take nearly 1 month time to file the objection. Immediately, they file a memo stating that the matter has been settled between the parties and they withdraw the case. During the pendency of that
Read
case.
this finding, madam.
Yes, Lord.
Para 13.
Lordship, if it could be passed over, if senior could address the argument.
No, I'm not deciding it. Please read it. Yes, sir.
Was held up in the other court. 213.
Yes, Mr. Bandari.
Please, I'm sorry. Your Lordship, the agreement entered, Your Lordship, with me on 8/2/1997, Your Lordship. That part payments has been made, Your Lordship, that is subsequently, Your Lordship, endorsement was made, Your Lordship, continue the agreement, Your Lordship, which was not taken place within the period of 6 months. Then, Your Lordship, we came to know that a suit has been filed, that 365 of 2012, Your Lordship, before the court, Your Lordship, based on the another sale agreement. That is on 13/4/1997, claiming that on 13/4/1997, one Devaraj, that is the defendant number 3, Your Lordship. Defendant number 3, Devaraj files a suit, Your Lordship.
Yes.
against the first defendant owner, saying not to alienate the property.
Yes.
In that suit, your lordship, I have made an impleading application. Immediately, it was published in the newspaper. Then I made an application to implead me as one of the party to the suit in 563. And the objections has been filed, and your lordship to hear, it was going on for hearing the IA orders against Hotaito. At one fine day, your lordship, they withdraw the suit saying that matter is settled out of the court. Then we came to know, your lordship, the sale deed has been executed in favor of the second defendant, based on claiming to be another agreement was existing prior to these two sale deeds, which was not at all in exist, because that is all not at all been elicited by the respondents before the under 365 suit. And all of a sudden, your lordship, it's 96 so ಇದರಲ್ಲಿ ನಾವು ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಅದರ ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದ್ದಕ್ಕೆ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಳ್ತಾರೆ ಅದನ್ನ. My submission, your lordship, if that 96 agreement was pre-existing, your lordship, when I made the payment to him, and subsequently he endorses the sales to continue the date for extension of the date by accepting another 50,000 rupees. At no point of time, to your lordship, he has not disclosed that there is a existing agreement. Nevertheless, the existing agreement, then your lordship, at no point of time, your lordship, it is his case that he has sold the property as of the date of.
Bandari, you can find fault with the defendant number 1. Suppression is at the end of defendant number 1.
Yes.
How to overcome the sale deed in favor of defendant number 2? And his agreement is prior to your agreement.
Agreement is prior to my agreement.
He is not party to your transaction.
No, he is not.
Right is created. You are only entitled for refund and some cost, additional cost. Now, first defendant has challenged that refund also.
First defendant has challenged the refund. First defendant has challenged the
Maybe you
refund.
are cheated. You are
Now,
cheated
my
by
submission only this much, if the pleadings, your lordship, the reading of the examination portion, your lordship, to fix your lordship. There is not, ultimately, your lordship, to defraud my client, your lordship, this tactics has been taken place.
No, but his agreement is prior to yours, Allah. That is the difficulty.
Yes, your lordship. That's a created document ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳೋದು ನಾವು.
ಎಲ್ಲಿದೆ ಅದು created ಅಂದ್ರೆ ಹಾಗೆ?
Because your lordship,
where is that evidence to show that it was created?
Portions, your lordship. Cross examinations portions, your lordship.
ಎಲ್ಲಿದೆ ಅದು ಸ್ಟಾಂಪ್ ನೋಡಿ ಯಾವ ಪರ್ಚೇಸ್ ಮಾಡಿದಾರೆ ಅದು?
21/3. 24/3 is the agreement date. 21/3/1990.
See, stamps were purchased. Who purchased? Defendant number 1?
Defendant number 1 purchase.
ಮಾಡಿದಾರೆ ಅವ್ರು ನಿಮ್ಗೊಂದು agreement, ಅವ್ರಿಗೊಂದು agreement, defendant number 3 ಒಂದು agreement.
3 ಜನಕ್ಕೂ agreement.
You can find fault with defendant number 1. But you can't make any allegation against second defendant. His transaction is independent.
His transaction is independent.
Independent. And what is the law on that point? If the property is already sold to a third party, you are not entitled to the discretionary relief. Allah, contest relief, court is still not bound to grant you main relief, isn't it? It's a discretion, even if you prove agreement. Now, third party rights are created.
No, what they're saying, your lordship, the first agreement which you are now relying upon, in that agreement, what they say is, your lordship, I have paid the cash of rupees 30 lakhs as on the date of entering the agreement. So, sorry, 30,000. And the said 30,000 will be refunded while entering the sale deed. ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತಾರೆ ಅದರಲ್ಲಿ. ಬಟ್ ಸೇಲ್ ಡೀಡ್ ಎಂಟರ್ ಆದಾಗ 30,000 ಯಾವ ತರ ರಿಫಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. That pleadings are not coming. That statements are not coming. So some shabby underground works has been taken place ಅಂತ ನಮ್ದು ಒಂದು ಅಷ್ಟೇ ಇನ್ನೇನು.
ಅವ್ರದ್ದು agreement ನಿಮ್ಮ subsequent ಇತ್ತಂದ್ರೆ that entire burden is on him to prove that is a bona fide purchaser.
That is true.
And the burden on him is only to prove the agreement. Alva?
That is true.
Astela? Yes, sir.
But now, your lordship, because of this, they have challenged the awarding the repayment of the.
Vishwanath Hegade alli. ಹಿಂಗೆ ಇದು ಕ್ರಾಪ್ ನಾಳೆ ಹಾಕೊಳ್ಳೋಣ. Today will decide this.
both are club together.
Where's the club together?
Club together. ಎರಡು ಕ್ಲಬ್ ಆಗಿದೆ.
ಆಗ್ಲಿದ್ರೆ ಅದು ನಾಳೆ ಮಾಡ್ತೀವಿ, ಇಲ್ಲಾಂದ್ರೆ ಆಗೋದಿಲ್ಲ. ಹೇರ್ ಮಾಡಿಬಿಟ್ಟಿದೀನಿ ಈಗ.
ಆಯ್ತು.
Very difficult to extract work in old matters.
ಅಲ್ಲ ಈಗ ಅದನ್ನು ಮಾಡಿದ್ರೆ at
ಅಲ್ಲ
least-
ಅದು ನಿಮಗಲ್ಲ, ಅದನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಕಾಸ್ಟ್ ಹಾಕಿ.
ಅಲ್ಲ ಕಾಸ್ಟ್ ಹಾಕಿ at least ನನಗೆ interest rate your lordship. Interest rate your lordship that
ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ ನಿಮಗೆ ಏನು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡೋದು ನೋಡೋಣ, ನಾಳೆ ನೋಡೋಣ. ಟುಮಾರೋ ವಿಲ್ ಸಿ. ಬರ್ಕೊಡ್ರಿ.
but one point your lordship, one point your lordship, that is OS 563 was pending. ಅದರಲ್ಲಿ ಸ್ಟೇ ಇತ್ತು, ನಾಟ್ ಟು ಎಲಿನೇಟ್.
your colleague told.
Yes.
ಏನು
ಸ್ಟೇ ಇದ್ದಾಗ
ಅದೇನ್ ಸ್ಟೇ ಇತ್ತು ಅದರಲ್ಲಿ?
ನಾಟ್ ಟು ಎಲಿನೇಟ್.
Not to alienate.
ನಾಟ್ ಟು ಎಲಿನೇಟ್. ನಾಟ್ ಟು ಎಲಿನೇಟ್ ಇದ್ದಾಗ ಬೇಸ್ಡ್ ಆನ್ ದ 96 ಸೇಲ್ ಡೇಟ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಸೇಲ್ ಮಾಡಿ ಆಮೇಲೆ ಬಂದು ಸಬ್ಮಿಟ್ಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್ ಸೇಯಿಂಗ್ ದಟ್ ಇಟ್ ಇಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಸೆಟಲ್ಡ್.
Stay was obtained by third
Yes.
defendant.
Against the owner.
Let me clarify. It was obtained by third defendant. Third defendant, my lord, if at all, he is the person who is aggrieved on. If there were to be any transaction executed by.
Whether you were a party to that injunction suit?
I was not a party to that injunction suit
You were not.
also.
You are not party to
No,
that.
I was not a party to that injunction suit also. I came to know.
Now, whether in cross examination to you, whether there is a suggestion that you were aware of that injunction suit and interim order?
I came to know of it. I came to know of it.
Yeah.
I came to know of it. Subsequently, my lord, third defendant sails with me, accepts my agreement of sale.
All that is a consenting.
Consenting witness. He becomes the consent. My lord,
He
what
ratifies.
happens is-
ಅಲ್ಲ ratification ಬಿಡಿ.
ಅದು ಆಗೋಯ್ತು, ratification ಆಗೋಯ್ತು. So ಆದ್ರಿಂದ ಅಗ್ರೀವ್ ಆದ್ರೂ ಅವರೇ ಆಗಿರ್ಬೇಕು. In fact, this court, while hearing this matter earlier, my lord, had tried to, my lord, initiate contempt proceedings against the first defendant. Based on that same, probably my learned friend is trying to focus that. My lord, based on that, notice was issued to the first defendant. Then subsequently, my lord, taking note of the fact that there was already an arrangement between the parties, that is settlement between the parties, contempt was dropped.
All right, there is no issue on that regard.
Insofar as that is concerned, there is no issue.
There is no issue on that point.
There is no issue in that. And I also say, my lord, that my sale date was earlier in nature, prior to he filing the suit. My lord, third party rights were already created. He had knowledge of that. He ought to have challenged it before this court. I can understand, my lord, if it were to be created during the pendency of the suit.
Yes, sir.
That is not challenged before this court also.
Anything else? That's
I
all.
don't have anything, that's all.
Yes, Bandari, ಕೂತ್ಕೊಡ್ರಿ. Bandari, ಕೂತ್ಕೊಡ್ರಿ. The caption first appeal is by the unsuccessful plaintiff who has challenged the dismissal decree passed in a suit for specific performance in OS 191 of 1998. For the sake of brevity, rank of parties, facts leading to the case is as in the plaintiff instituted a suit against defendants seeking relief for specific performance of contract. Plaintiff claimed that defendant number one offered to sell the suit property for a sale consideration of 1,45,000 and accordingly executed an agreement on 8/2/1997 by receiving an advance amount of 25,000. Plaintiff further claimed that it was agreed that sale transaction will be completed within a period of 6 months. Plaintiff contends that that he was tenant and he was already in possession of this commercial property owned by defendant number one, and defendant number one was collecting rents from plaintiff through bank checks. Plaintiff has further contended that defendant number one in the month of January 1994 has further received ಅದು ಡೇಟ್ ತಪ್ಪಾಗ್ತಾ ಇದೆಯಲ್ಲ.
Please.
As further received a sum of month ಬರಿಬೇಡಿ, as further received a sum of 50,000. On 8/5/1997, which is subsequent to suit agreement. Thereafter, defendant number 1 sought for extension of time to register the sale deed on the premises that is required to clear the bank loan.
Yes.
Plaintiff claim, next part. Plaintiff claimed that he was ever ready and willing to perform his part of contract under the sale agreement dated 8/2/1997. Plaintiff further alleged that defendant number 1 executed one more agreement in favor of defendant number 3. And this led to filing of an injunction suit by defendant number 3, wherein defendant number 3 obtained injunction against defendant number 1 from alienating the social property. Plaintiff, having come to know about the filing of the suit, got himself impleaded and filed objections, got impleaded. However, defendant number 3 reported that the matter is settled out of court and filed a memo and withdrew the suit. Plaintiff claims that it was only in second week of November 1998 came to know that defendant number 1 has executed a sale deed in favor of defendant number 2 on 17/10/1998. Hence, the present suit. Second defendant with the contesting defendant filed a written statement and stoutly denied the entire averments made in plaint. Second defendant asserted that his agreement was prior to plaintiff's agreement and therefore contended that on 24/3/1996, defendant number 1 agreed to sell the social property and has executed an agreement on 24/3/1996. Second defendant further contended that defendant number 1, honoring the terms and conditions of the agreement, has concluded the transaction by executing a sale deed on 17/10/1998 and hence prevailed for dismissal of the suit. Next paragraph. Defendant number 1, who is the owner, has also filed a written statement and has contested the suit. First defendant has admitted that plaintiff is his tenant and is collecting rents from plaintiff. Defendant number 1 further admitted the receipt of 50,000 by way of check.
Agreement is denied.
But however disputed that this amount was not towards sale consideration.
Security.
The defendant number 1 admitted the filing of a suit by defendant number 3 in OS 563 of 1996. First defendant admitted the transaction with second defendant and also acknowledged the receipt of advance amount of 30,000 and execution of agreement to sell in favor of defendant number 2 on 24/3/1996. Defendant number 1, however, disputed the transaction with plaintiff and contended that he had availed a loan from plaintiff. He had availed a loan of 1 lakh from plaintiff, and therefore by way of as security, a nominal agreement was executed by him. Next. Trial court, based on the pleadings of the parties in all framed framed 8 issues and 2 additional issues. While answering issue number 1 to 4 in the affirmative, trial court held that plaintiff has succeeded in proving the agreement dated 8/2/1997. However, while answering issue number 6 and additional issue number 1 in the affirmative, recorded finding that second defendant has succeeded in substantiating that defendant number 1 executed an agreement to sell on 24/3/1996 and subsequently received entire sale consideration and executed sale deed in favor of defendant number 2 on 17/10/1998. The trial court, having held the sale transaction in between defendant number 1 and 2 as valid and genuine, declined to grant larger relief for specific performance of contract. On the contrary, trial court partly decreed the suit and partly decreed the suit, thereby directing defendant number 1 to return the advance amount of 1,45,000 with interest at the rate of 24% per annum. Next, the plaintiff challenging the denial of larger relief for specific performance of contract has filed an appeal in RFA 2014 of 2005. Defendant number 1 assailing the decree for refund of 1,45,000 with interest at the rate of 24% has filed a cross appeal in cross objection number so and so. The counsels in RFA 2014 of 2005. I've given my anxious consideration to the pleadings, oral and documentary evidence let in by plaintiff and defendants 1 and 2. Following point would arise for consideration. Whether the judgment and decree of the trial court in ordering refund of advance amount suffers from perversity and warrants interference at the hands of this court. Whether trial court was justified in declining to grant larger relief for specific performance of contract. Question, Badri. Second. Finding on points number 1 and 2. On reassessing the entire material and record, it is evident that plaintiff has instituted a suit for specific performance to enforce the agreement dated 8/2/1997. Second defendant is resisting the suit on the ground that his agreement, which is dated 24/3/1996, is prior to plaintiff's agreement, and the same as and the same as concluded, stood concluded. And defendant number 1 has executed a sale deed on 17/10/1998. Next, it is a trite law that where a sale deed is obtained by a third party, the right of a plaintiff in a suit for specific performance is subject to the genuineness of the subsequent transaction. However, on meticulous examination of rebuttal evidence let in by second defendant, agreement in favor of second defendant is dated 24/3/1996. Therefore, if second defendant has succeeded in securing a sale deed on 17/10/1998, which is much prior to plaintiff instituting the suit, which is dated 14/12/1998, D-House plaintiff succeeding in proving the agreement to sell while exhibit P1 and payment of advance amount, plaintiff, this court cannot exercise the judicial discretion in favor of plaintiff. Before plaintiff's initial transaction could be concluded, defendant number 1 has played a mischief and has concluded the transaction with second defendant. Defendant number 1 has succeeded in suppressing the transaction with second defendant while executing the suit agreement in favor of plaintiff. Though there is a clear mischief by defendant number 1, the right created in favor of second defendant cannot be taken away. While granting discretionary relief of specific performance, the courts are required to examine the equities and the rights created pursuant to agreements. Though in the present case on hand, plaintiff has succeeded in substantiating the due execution of suit agreement in view of transaction being concluded with second defendant, the judicial discretion cannot be exercised in favor of plaintiff. Next paragraph. As rightly pointed out by learned counsel appearing for second defendant, pursuant to decree passed by the court, by the trial court, second defendant having acquired a title pursuant to sale deed executed by defendant number 1 on 17/10/1998, filed a ejectment suit against plaintiff. It is brought to the notice of this court that suit is decreed and confirmed by this court, and plaintiff has delivered possession in contempt proceedings. Next paragraph. If these significant details are taken into consideration, this court is of the view that that though plaintiff has succeeded in proving the agreement, this court is also not inclined to exercise discretion in favor of plaintiff. Any indulgence at this juncture in favor of plaintiff would seriously prejudice the second defendant's rights. Second defendant has not only succeeded in substantiating that his agreement was much prior to plaintiff's agreement, but has also succeeded in substantiating that the further rights are created and possession is recovered from plaintiff. Though plaintiff's counsel tried to pursue at this court on the ground that the transaction between defendant number 1 and defendant number 2 is collusive, and the same was intended to defraud plaintiff, on meticulous examination of evidence let in by plaintiff. This court is of the view that plaintiff is not in a position to substantiate that The transaction between defendant number 1 and defendant number 2 is a collusive transaction. A feeble attempt is also made by the counsel appearing for plaintiff to contend that the transaction between defendant number 1 and 2 was in violation of interim order granted granted in OS 563 alladu.
Also, 563.
563 of
Around 1997. 1997.
so and so 1997
563 of 97.
97. This court is of the view that the alienation made by first defendant in favor of second defendant will not affect the second defendant's right on 2 counts. Firstly, defendant number 2 was not a party to the injunction suit filed by defendant number 3. Even if the alienation was in violation of an interim order granted by the court, the fact that defendant number 3 has signed as a consenting witness clearly ratifies the transaction between defendant number 1 and 2. Therefore, the said fact will not inure to the benefit of plaintiff so as to claim a larger relief for specific performance of contract. Next, trial court, while examining the evidence let in by plaintiff and rebuttal evidence let in by second defendant, has declined to exercise judicial discretion. The finding recorded by the trial court on issue number 6 and additional issue number 1 is based on the cogent evidence let in by defendant number 2. The reasons assigned by the trial court strictly aligns with the settled principles relating to grant of specific performance of contract. I do not find any serious infirmity or perversity in the findings recorded by the trial court, while declining to grant larger relief for specific performance of contract. For the foregoing reasons, point number 1 and 2 are answered accordingly. Appeal is devoid of merits. Accordingly, stand dismissed. Please inform.
Message kalasde.
Lord, I appear for the cross objector, my lord. Lord, my cross objection is limited to, my lord, awarding interest in excess of 9%, my lord.
Justified in this case.
It is contrary to section 34 of the CPC, my lord.
ಅದು ಬಿಟ್ಟು ಮತ್ತೆ ನಿಮಗೆ ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಹೇಳಿ?
ಏನಿಲ್ಲ ಸರ್.
3 ಅಗ್ರಿಮೆಂಟ್ ಮೂರ್ ಜನ ಕಡೆ ದುಡ್ಡು ತೋಡಿದೀರಾ, ಸ್ವಲ್ಪ ದುಡ್ಡು ಕೊಡಿ ವಿಶ್ವನಾಥ್ ಅವರೇ.
Lord, only to the limited extent, Lord, I have said, Lord, regarding section 34.
What to do, but they have to face. Paid from the estate of defendant number 1, that's all. ಏನು ಇಲ್ವಾ?
ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ. By the time he died, my lord, he was a pauper. ಎಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಕಳ್ಕೊಂಡು
ಈ ತರ ಮಾಡಿದ್ರೆ ಪಾಪರ್ ಆಗದೆ ಇರ್ತಾರ.
ಏನ್ರಿ
ಕಾನ್ಶಿಯಸ್ಗೆ ಹೇಗೆ ಆಗಿ ಹೋದ್ರೆ?
A fair lawyer representing a mischievous litigant. Tell me, what is your argument?
Lord, no, the fate of the person, Lord, nobody could determine. He had several properties. He was one of the richest persons in Davanagere. And finally, he, Lord, died as a pauper, my lord.
Why he became a pauper? Because he kept cheating people. God punished him, it appears.
In fact,
24% matra na.
This person was the owner of the property. The plaintiff was a tenant.
Yes, I was a tenant.
No, I'll tell you, Agade sir.
Please, my lord.
I'll tell you. See, I have a view in a suit and specific performance.
Please.
See, a party invests in an immovable property at a relevant point of time.
Please.
And see, money value is the important ingredient, isn't it?
Very true, my lord.
Now, what was sought to be purchased in 2002, or rather 97.
Yes, my lord.
See, with that money, he can't even dare to go and find out a property now, isn't it?
Please, my lord.
That money value is already lost. You can't compensate him actually.
Please.
Apart from paying interest, I think compensation should be paid where larger relief is declined.
Lord,
and there is no fault. He has proved agreement. He has proved his readiness and willingness.
Yes, my lord.
He is outrightly cheated by your client. What should happen to him?
My lord,
Now,
in
even
all
on this
cases,
censure, even if you are to pay him, I don't know when you're going to pay.
my lord, I don't know, my lord, because
Ah.
there are two sons, my lord. They are not. They have not succeeded to any property, immovable property by.
How come? How come? You said that you are the richest man. What
He
is done
was,
with
my
all the
lord.
properties?
No, he started borrowing loan in respect of this property from the tenant. Ultimately, my lord, by the time he died, my lord, he died in very, very late, my lord. By the time he became a pauper.
ಇದು commercial transaction ಅಲ್ಲ ಯಾಕೆ ಕೊಡಬಾರದು?
ಇದು commercial ಅಂದ್ರೆ property was commercial.
No, transaction ಅಲ್ಲ agreement to sell commercial ಅಲ್ಲ ಇದು.
Of course, my lord, it can be held as commercial transaction.
ಮತ್ತೆ why?
In 2018, he died, my lord. By that time, there was nothing with him left with him.
ಅಲ್ಲ ವಿಶ್ವನಾಥ್ ಅವ್ರೆ, ಈಗ ನೀವು ಹೇಳೋದು ಅವ್ರ ಹತ್ರ ಏನು ಇಲ್ಲ ಅಂತ. At least a poor plaintiff, let him have a paper decree with interest at the rate of 24%.
Lord, I will leave it at that, my lord. I will leave it at that, my lord.
Very sorry, State of
Please.
We'll dismiss Mr. Bandari, our appeal.
Please.
Some cost may be. Some cost may be imposed.
Cost ಹಾಕೋಣಲ್ಲ, ಎಷ್ಟು ಹಾಕೋಣ? ಹೆಗಡೆ sir, cost ಎಷ್ಟ್ರಿ?
Lord,
will you be able to recover it?
No,
but the original defendant is not alive, Big Bandari.
I guess the LRC.
Cost, but I will only dismiss it. ಅವರಿದ್ರೆ ಹಾಕ್ತಿದ್ದೆ 1 ಲಕ್ಷ. ಇಲ್ಲ, he is not alive. We'll dismiss.
I leave it to us.
Please.
ವಿಶ್ವನಾಥ್ sir, ಏನ್ರಿ ground ಏನ್ raise ಮಾಡಿದೀರಾ?
Lord, I have only said, my lord, it is contrary to section 34 of CPC. And more than that, my lord, I have challenged interest in excess of 9% only, my lord. I have said that under 34 only 6% is permissible. But in the cross objection, I have paid court fee in respect of interest in excess of 9%.
Yes, sir. The crop is filed by defendant number 1. Assailing the interest awarded by the trial court on refund at the rate of 24%.
Interest in excess of 9% only is challenged, my lord, in cross.
Correct. ಅದರಲ್ಲೇ ಬರ್ದ್ಬಿಡೋಣ, ಕನೆಕ್ಟೆಡ್ ಮಾಡೋಣ ಅಲ್ಲ, ಅದರಲ್ಲಿ ಬರ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ನಂಬರ್ 3 ಮಾಡ್ರಿ. Whether trial court was justified in awarding 24% interest while ordering refund of 1,30,000.
Lord, 1,45,000 is the refund order. Out of that, my lord, 15,000 is the security deposit given by the tenant to the landlord.
Allah, but decree part is only 1,30,000. Vishwanath sir.
Please, my lord. Yes.
Decree part is only 1,30,000. Yes. My finding on point number 3 in crop so and so. Letter counsel for appearing for defendant number 1 has vehemently argued and contended that the trial court exceeded in its jurisdiction in awarding interest in excess of 9%. And the same clearly contravenes section
34
of Civil Procedure Code. Though interest awarded by the trial court is on the high side, this court is not inclined to grant any indulgence, having regard to the conduct of defendant number 1 in the case on hand. On examining the records, this court is more than satisfied that the conduct of defendant number 1 is found to be grossly unfair and unreasonable. Defendant number 1 has conveniently suppressed the transactions. Defendant number 1 during his lifetime has executed in all 3 agreements, one in favor of second defendant, third defendant, and the present plaintiff, which is the subject matter of the present appeal and cross objection. Plaintiff with a bona fide intention has entered into a transaction with defendant number 1, and the agreement to sell dates back to 8/2/1997. Plaintiff under the bona fide belief that defendant number 1 will execute sale deed has invested 1,30,000 way back in 1997. This court has noticed that defendant number 1 has died and his LRs have come on record. Counsel appearing for defendant number 1 submits that defendant number 1 became bankrupt and was a pauper at the time of death and has not left any immovable properties. When a citizen invests money in a immovable property, the investment is made with a view to acquire a property at a relevant point of time. Plaintiff has mobilized funds and has invested 1,30,000 in 1997. The above details, the above significant details gives an impression that plaintiff may further has to fight a long battle to recover this amount in the light of statement made by the counsel appearing for defendant number 1. The money value of the advance amount that was invested in 1997 has lost its relevance in 2024. 1,30,000 was a substantial amount in 1997. With the same amount, including with the interest at the rate of 24%, may not get an equivalent land at this point of time. Therefore, even though this court accedes to the argument advanced by the counsel appearing for defendant number 1 that interest is on the higher side, this court is not inclined to accede to the is not inclined to modify the interest as that would as the same would compensate the plaintiff negligibly. Negligibly. Though the interest awarded is found to be in excess of is found to be contrary to Section 34. However, having regard to the fact that it is a commercial transaction and the fact that plaintiff has to recover this amount, this court is not inclined to reverse the decree granted by the trial court while ordering for refund of 1,30,000 with interest at the rate of 24%. Accordingly, point number 3 is answered in the negative. For the foregoing reasons, the appeal and cross appeals are dismissed. Yes, sir.
ಪಾಪರ್ ಅಂತ ಓಡ್ಬೇಡ, ಯಾಕಂದ್ರೆ ನಾಳೆ ರಿಕವರ್ ಮಾಡಕ್ ಹೋದಾಗ ಅವರು ಮತ್ತೆ ಪಾಪರ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಅಬ್ಸರ್ವೇಷನ್.
ಅವರಲ್ಲ, ಅವರು ಆಗಿದ್ದಾರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು. ಅವ್ರು ಆಗಿದ್ದಾರೆ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಲಾರ್ಡ್ಶಿಪ್ ಕೋರ್ಟ್ ಫೀ ವಿಚ್ ಹಸ್ ನೌ ಹಿ ಹಸ್ ಈಗ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಫೀ ಹಸ್ ವಿಚ್ ಹಸ್
ಯಾವುದು
4 and above 9% ಕೋರ್ಟ್ ಫೀ ಅನ್ನು ಹಾಕಿದಾರಲ್ಲ, ದಟ್ ಮೇ ಬಿ ಮೇಡ್ ಗುಡ್ ಟು ದಿ ಪ್ಲೇಂಟಿಫ್.
ಯಾವುದು ಅಲ್ಲ, ನಾನು ಇಂಟರ್ಫಿಯರ್ ಮಾಡಲಿಲ್ಲಲ್ಲ. ಅವ್ರ ಕ್ರಾಪ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀನಿ. ಯು ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ 24%. ಯಾವ್ದಯ್ಯ?
ನೋ ಕೋರ್ಟ್ ಫೀ 4 and above 9% ಮೇಲೆ ಹಾಕಿದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು. 9% ಮೇಲೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿ ಕೋರ್ಟ್ ಫೀ ಹಸ್ ಪೇಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡೆಪಾಸಿಟ್ ಕೋರ್ಟ್ ಫೀ that may be refunded to the plaintiff.
ಅಲ್ಲ, your suit is decreed with cost, so you will get it. Your suit is decreed with cost, no? ನಾವು ಅದನ್ನ ಏನ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಅದ್ ಮಾಡ್ಬೋದಾ? ಅಲ್ಲ, in his appeal we can say that ಅಲ್ಲ. Refund. That includes court fee also. Cost ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿಂದ ಕೋರ್ಟ್ ಫೀ ಸಿಗುತ್ತೆ. ಇಲ್ಲಿ ಸಿಗುತ್ತೆ.
ಅವ್ರು ಇಲ್ಲಿಂದ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
ಇಲ್ಲಿ ಬರಲ್ಲ. ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್.
ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಅವ್ರ ಕ್ರಾಪ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಸಾರಿ ಬಟ್ IA ಏನದು? IA ಯಾರ್ದು ನಿಮ್ದಾ?
ಏನಿಲ್ಲ ಇವಾಗ.
ಅದೇ ಇದು diseased R3 has died. 3 is brought on record.
Yes.
ಅದು ಅಲವ್ ಆಗ್ಬೇಕಾ?
Have entered appearance for R3.
IA 2 of 22 is allowed. Delay in filing LR application to bring diseased, to bring proposed LRs of diseased R3 is condoned. Consequently, abatement is set aside. Appellant is permitted to bring diseased LRs of R3 on record. Counsel for appellant to forthwith amend the cost title and file amended cost title. ಇದು final hand.
Mobilization.
Yes, sir.
Others matter? Number 48, MC Ravi Kumar.
Appellants, needful is done. I paid the amount here.
48.
I serving the copies.
Yes, sir.
So far, no copies are served, my lord.
I'm
So far, no copies are served. Now he is filing, my lord.
No,
I'm relying on one judgment, my lord.
I
of
had
the
sent-
Supreme Court.
ಏನದು?
ಅಲ್ಲ ಅದನ್ನೇನೆ ಈ ತರ ಅರ್ಜಿಗಳನ್ನ ಈ ತರ ಮಾಡೋದನ್ನ ಅಲೌ ಮಾಡಬಾರ್ದು ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೈಕೋರ್ಟ್ ಅದನ್ನ ಇದು ಮಾಡಿದೆ ಸರ್. ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ
copies not.
for the sake of your lordship convenience, without permission ಅದನ್ನ ಮಾಡಬಾರ್ದು.
Copies good.
All these applications were dismissed for want of prosecution. Under the circumstances, there was no question of allowing MCF or seeking restoration of so-and-so. High Court, without again any reason whatsoever and in very casual manner, has allowed this application for restoration of so-and-so. No litigation should be permitted to be sole authority and apathetic, much less should be permitted to misuse the process of law, as the respondents have sought to do. The High Court has committed gross error in allowing such vexatious application, that too without assigning any reason. My lord, how many applications, my lord? If it is okay, once, twice, 4, 5, and not even surveys on the other side, and they don't appear also. Applications are dismissed, my lord. And kindly see, my lord, one order, my lord, order dated 7/9/2021, my lord. There.
All right, sir.
My lord, only one sentence.
ನಾಗರಾಜ್ ಅವರೇ ಹೇಳಂತೀರ ಇದು ಸೈಟ್ ಮಾಡಿದಿರಲ್ಲ,
ಹೌದು.
ಇದು ಯಾವ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದು? ದಿಸ್ ವಾಸ್ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ವಾಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್? MCA ಅಂದ್ರೆ ಏನದು?
ಅದು ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ರೀಕಾಲ್ ಮಿಸ್ಲೈನಿಯಸ್ ಅಂತ ಮಾಡ್ತಾರೆ. ಅದೇ ಸೇಮ್ ಡಿಸ್ಮಿಸಲ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿ ಅವ್ರು ರೀಕಾಲ್ ಹಾಕೊಂಡದ್ದು MCA ಅಷ್ಟೇ. ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್
ಅಲ್ಲ, ಅದು ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಅದು ಅಪೀಲ್ ಯಾವ್ದು ಅಪೀಲ್?
ಸೇಮ್ ಅಪೀಲ್ ಏನೇ
ಆಗಲ್ರಿ, ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅದು.
ಹೌದು, ಅಪೀಲ್ ಏನೇ. ಆಮೇಲೆ ಸ್ವಾಮಿ ಈ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಆರ್ಡರ್ ಆಫ್ 7/9/2021 may kindly be perused, my lord. In this appeal 7/9 in the Swami. Kindly see, my lord, last page. Hence, the earlier order of dismissal is confirmed and the applicants are rejected. When the earlier order of dismissal is confirmed, appeals are dismissed, my lord, rightly or wrongly, my lord, he has to approach the Supreme Court.
ಎಲ್ಲಿದೆ ಅದು? ಎಲ್ಲಿ ಓದಿದ್ರು?
This court's order, my lord, order dated 7/9/2021. Last para, my lord, last 2 lines. Hence, the earlier order of dismissal is confirmed. Confirming the dismissal of the appeal. Yes, are rejected, my lord. How can he come before this court now, my lord? He has to challenge it before the Supreme Court only, even if it is wrong. This court becomes functus officio.
ಇಲ್ಲ ಆಗ್ಲಿಕ್ಕೆ
ನಮ್ copies.
ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಹಳ ಬಿದ್ದು ಬಿಡುತ್ತೆ.
ಅಲ್ಲ,
ಬಟ್ ನಾಗರಾಜ್ ಸರ್, we'll do one thing.
Yes, ma'am.
I'm not going to recall this applications.
Yes, ma'am.
You should argue on merits on the same level.
Yes, ma'am. Tomorrow.
Yes.
Like, because LRs they have to be brought on. record.
ಯಾರು ನಿಮ್ಮೆಲ್ಲ ಅಪಲೆಂಟ್
Some LRs, because 7/9/2021.
No appellant LR, sir. Bring it. You're not supposed to take notice on those applications.
No, I am not supposed to. I am appearing for
You're the
appellant.
appellant. Just come prepared tomorrow, sir. 2005. I'm not
2005.
even granting passover in 2005 matters.
Yeah,
Tomorrow.
and
You're lucky because it's 4:30.
not to, next week, please. I'll because, no, then no, please, your lordship, what is lordship, because
Nagaraj, sir. Doubt ಇದೆಯಾ? Decide ಮಾಡಲ್ಲ ಅಂತ? Just a minute, I'll decide it. Now we can't. Absence record ಮಾಡಿ merit ಮೇಲೆ ಬರ್ತೀನಿ. Absence record. Absence record ಮಾಡಿ merit ಮೇಲೆ ಬರ್ತೀನಿ. Let him go to Supreme Court. Yes, sir. Next Thursday.
lordship, because,
Next
yes,
Thursday.
yes, your lord.
Next Thursday.
Yes, your lord.
Cost is paid.
Cost, yeah, it is paid.
ಯಾರಿಗೆ ಕೊಡೋಕೆ ಹೇಳ್ತದೆ?
For advocates clerk, I have deposited it.
Counsel appearing for appellant submits that cost imposed by this court is paid. His submission is taken on record. Though this court is not inclined to grant any adjournment, the learned counsel for appellant ensures this court that he will go ahead with the matter on the next date of hearing. List this matter in hearing, final hearing on next Thursday. Yes, Nagaraj sir. It is made clear that no further adjournments will be granted on the next day. Yes. Yeah, you will allow this matter. We'll allow it on the same day. You come prepared final hearing. Yes. 2:30. Yes. 49. 49.
I will not file any objection for these
Bad,
applications because.
bad. Merit ಮೇಲೆ ಮಾಡಬೇಡಿ ನಾಗರಾಜ್.
Yes, my friend. Much of it.
Yes, sir. Yes. ಏನಿದು?
Needful done, my.
Needful done. Acceptance of process fee in respect of appellant has paid PF. Counsel for appellant submits that needful is done, office to verify. Next.
Mobilize.
ಏನ್ರಿ consideration of await service. List it on so and so date.
51.
Notice ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ, ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ. ನೋಟಿಸ್ ಆರ್ ಸರ್ವ್ಡ್ ಮೋರ್ ದಟ್.
ಸರ್ವ್ಡ್?
ಹೌದು.
ಯಾರು ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ, ಯಾರು ಬಂದಿಲ್ಲ, ಬಟ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ನೋಟಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸರ್ವ್ಡ್ ಮೋರ್.
Served. Proposed LRs of R10 are served and unrepented. There is no contest to these LR applications. Accepting the cause, I-1 of 2016 is allowed. Appellant is permitted to bring the proposed LRs of disease R10. Appellant, counsel for appellant to forthwith carry out amendment.
Please, ma'am.
Yes. Partition suit, ಏನಿದು?
ಇಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಬ್ಯಾಂಕ್ ಕೈಂಡ್ಲಿ ಸಿ ಕನೆಕ್ಟೆಡ್ 1034 ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, ಐ ವಿಲ್ ಫೈಲ್ ದಿ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ 1033/560 ಅಲ್ಲಿ R13 ಕಾಂತಮ್ಮ ಈಸ್ ನೋ ಮೋರ್ ಮಾಲ್ ದಟ್. ಅದಕ್ಕೆ ನಾನು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ R13 ಎಲ್ಲಾರ್ಸು ನಾ ತಂದು ಬಿಟ್ಟಿದ್ದೀನಿ. ಸೊ ಎಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ ನಾನು ಟು ಕರೆಕ್ಟ್ ದಿ ಕಾಸ್ಟ್ ಟೈಟಲ್. ಆಲ್ ದಿ ಅಪೀಲ್ಸ್ ಆರ್ ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್ ಸೇಮ್ ಜಜ್ಮೆಂಟ್. ಅದಕ್ಕೆ ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ. ಈಗ 1033 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ, ಎಲ್ಲಾರ್ಸ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್. 560 ಅಲ್ಲಿನೂ ಅವರು R13 ಕಾಂತಮ್ ಎಲ್ಲಾರ್ಸ್ ರೆಕಾರ್ಡ್ ಮ್ಯಾಗ ಬಂದಾರೆ. ಸೊ 2004 ಅಪೀಲ್ ಆಗಿರೋದ್ರಿಂದ ಮತ್ತೆ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವ್ರಿಗೆ ನೋಟಿಸ್, 2 ಅಪೀಲ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ. ಸೊ
ಎರಡರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ.
ಸರ್ವ್ ಆಗಿದೆ ಅವ್ರಿಗೆ.
But application was filed, only filed in
connected appeals. That arising out of same judgment, all the appeals are. 560 FDP ವಿರುದ್ಧ ಹಾಕಿದ್ದು, ಇವೆರಡು ಜಜ್ಮೆಂಟ್ OS ಮೇಲೆ ಹಾಕಿರೋದು.
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ?
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವುದು ಇಲ್ಲ.
ಏನಿಲ್ಲ ಸರ್. ಮೆಮೋ ಡೇಟೆಡ್ ರಿಗಾರ್ಡಿಂಗ್ ಫೈಲಿಂಗ್ ಆಫ್ ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲಾರ್ಸ್ ಬರ್ಕೊಡ್. ಬಟ್ ನೋಟಿಸ್ ವಾಸ್ ಸರ್ವ್ಡ್ ಇನ್.
ಕನೆಕ್ಟೆಡ್ ಅಪೀಲ್ ನೋಟಿಸ್ ಹಾಕಿಂಗ್ ಸರ್.
ಇಲ್ಲೂ ತೋರಿಸ್ಬಿಟ್ಟು, ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅವ್ರನ್ನ R10.
ಇಲ್ಲಿ ಪೇಪರ್ 560 ಅಲ್ಲಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅವ್ರದ್ದು ಇದೆ. ದಟ್ 532-34 ಆರ್ ದಿ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ದಿ ಕಾಂತಮ್ಮ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡಿದ್ದೀನಿ ನಾ 560 ಅಲ್ಲಿ.
560
ಹೌದೌದು ಸರ್. R32-34 ಆರ್ ದಿ ಎಲ್ಲಾರ್ಸ್ ಆಫ್ ಕಾಂತಮ್ಮ.
R32-34
ಮಾಡಿ.
You have taken by way of paper publication.
ಹೌದೌದು.
ಅದೇನೇ ಇದೆಯಾ? ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇದೆಯಾ?
ಇದೆ.
ಯಾವಾಗಿತ್ತದ ಅಪಿಯರೆನ್ಸ್? ಇವತ್ತೇ ಇತ್ತಾ?
ಅಪಿಯರೆನ್ಸ್ ನಿನ್ನೆ ಇತ್ತು 21st ಇತ್ತು ಸ್ವಾಮಿ ಡೇಟು ಬಟ್ ಇಟ್ ವಾಸ್ ನಾಟ್
ಬರ್ಕೊಡ್ರಿ. Respondents 30 to 34 are served. ಎಲ್ಲ ಬರೋದು. Respondent 21 to so and so are served by way of paper publication. Service is held sufficient. Office to print the name of the respondents. 51.1 ಅಲ್ಲಿ ಏನಾಗಬೇಕು?
10th ಅಲ್ಲ 1034 ಅಲ್ಲಿ ದಟ್ ಮೆಮೊ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ಸಾಕು. ನಾನು ಅಮೆಂಡ್ಮೆಂಟ್ ಕಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿಬಿಟ್ಟಿದ್ದೀನಿ.
Memo dated 19/7/2024 is accepted.
And post for admit ಆಗಿದೆ appeal. Post for final hearing paper book
ಹಾಕಿದ್ದೀರಾ? Audit. Did this matter in final hearing on so and so.
Please ma'am.
Next. 52 ಏನಿದಲ್ಲ? ನನ್ನ PS list it on.
Number 53.
I am for the appellant in this case, my lord. ಇದರಲ್ಲಿ appellant
await notice ಏನಿದು? await report.
await report ಅದು mediation ಅಲ್ಲಿ ಹೋಗಿ
was also ready for the compromise. ಅವ್ರದ್ದು ಸ್ವಲ್ಪ ನೇಮ್ಸ್ ಚೇಂಜಸ್ ಇದೆ ಅಂತ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. Even some other respondents ಇದ್ದಾರೆ, but ಎಲ್ಲರೂ ಏನು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಎಲ್ಲರೂ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. The same will be allowed. And one more submission, Your Honor. Hospital respondent 1AB ಅಂತ ಮಂಜುಳಾ ಅಂತ. ಅವ್ರದ್ದು ವೇರ್ ಅಬೌಟ್ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ. ಅವ್ರದ್ದು ವೇರ್ ಅಬೌಟ್ ಗೊತ್ತಿಲ್ಲ, ಎಲ್ಲಿದ್ದಾರೆ ಏನು ಅಂತ. ಅವ್ರನ್ನ ಬಿಟ್ಟು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಸಿಗತ್ತಾ?
What was the ranking before the trial court? Our ranking ಏನಿತ್ತು trial court ಅಲ್ಲಿ?
1AB.
What was the ranking?
1AB.
1AB.
Trial court ಅಲ್ಲಿ?
She is brought on record. ಎಲ್ಲಾರ್ಸ್ ರೆಕಾರ್ಡ್ ತಗೊಂಬಂದ.
At least effective representation ಇದೆಯಾ? Effective representation ಇದೆಯೇನ್ರಿ? ಇಲ್ಲಿ ಕೊಡ್ರಿ ನೋಡ.
ಮಂಜುಳಾ R1AB. ಅದು
ಇವ್ರಿಗೇನು ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ ಶೇರ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಸುಶೀಲಮ್ಮಗೆ ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಸುಶೀಲಮ್ಮಗೆ ಅಂತ ಶೇರ್ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ. They are agreeing.
Then it can be dispensed. There is a effective representation. Other ಎಲ್ಲರೂ ಸಾಧ್ಯ?
ಎಲ್ಲ
ಯಾರು? ಶಶಿಕಲಾ ಮತ್ತೆ ಯಾರಿದ್ದಾರೆ? ಜನಾರ್ದನ್.
ಎಕ್ಸೆಪ್ಟ್ ಮಂಜುಳಾ.
ಯಾಕೆ ವೇರ್ ಅಬೌಟ್ಸ್ ಗೊತ್ತಿಲ್ವಾ?
ಗೊತ್ತಿಲ್ಲ, ಬಟ್
ಹಾಸ್ಪಿಟಲ್ ನಲ್ಲಿ R1AB ನನ್ನ but we have not filed ವಕಾಲತ್ for her. ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಈಗ? ವಾಟ್ ಯು ವಾಂಟ್?
ನಾನೀಗ ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಹೆಸರುಗಳು ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗ್ತಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ ಆಗ್ಬೇಕು.
ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲ ಹಾಕಿ ನಾನು ಅಲೌ ಮಾಡ್ತೀನಿ ನೋಡ್ಬಿಟ್ಟು. ಬಿಕಾಸ್ ಮ್ಯಾಟ್ರಿ ಸೆಟಲ್ಡ್ ಅಲ್ವಾ?
ಹೌದು, ಸೆಟ್ಲ್ ಆಗಿದೆ.
ಯು ಫೈಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಪ್ಲೇಂಟ್. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅಮೆಂಡ್
ಇಲ್ಲೇ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್
ಹಾಕಿ ನಾನು ಅಲೌ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು, ಅದೇ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಲೆಟ್ ಮಿ ಫೈಲ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಪ್ಲೇಂಟ್. ಐ ವಿಲ್ ಅಲೌ ಇಟ್.
ಆಯ್ತು,
ಹಾಕಿ ಆದಿಸ್ ನೋಡೋಣ.
ಪ್ಲೀಸ್
ಒನ್ ಡೇಟ್ ಕೊಡ್ರಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎನಿ ಡೇಟ್ ಪ್ಲೀಸ್.
ಒನ್ ಡೇಟ್ ತಗೊಳ್ಳಿ. ಯಾವುದು?
ಮೀಡಿಯೇಷನ್ ಅದು
ಡೇಟ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲೊಂದು ಪ್ಲೀಸ್. ಟ್ಯೂಸ್ಡೇ ಆದ್ರೆ ಆಗ್ಬೋದು ಸ್ವಾಮಿ, ಪರವಾಗಿಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಮತ್ತೊಬ್ಬ
ಯು ಹ್ಯಾವ್ ಟು ಕಮ್ ವಿತ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ.
Yes.
ಒಂದು ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ತಗೊಂಡ್ ಬರ್ಬೇಕು. ಯಾರ್ಯಾರು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದಾರೆ ಅಂತ ನೋಡ್ಬಿಟ್ಟು ಅಲೌ ಮಾಡೋಣ.
ಆಯ್ತು ಸ್ವಾಮಿ.
Praise appellant, my lords. Praise for week time, my lords. Senior is out of station. Senior is out of station.
You are not allowing to make submission. What is the problem?
Apology, man.
ಅಂದ್ರೆ ಏನು, ಅವರು ಸಬ್ಮಿಷನ್ ಮಾಡಬಾರ್ದಾ? Yes, sir.
I appear for respondent number 46. Respondent number 46 is been impleaded before this honorable court by the order dated 24/6/2024 recently. The notice of such application was served on me by way of hand summons without any copy of the application or any detail on 22/6/2024, that is Saturday. So we were not aware of them. I have been included, that is one side of this thing. On 3/7/2024, I have filed my power before this honorable, wakalat before this honorable court representing the respondent number 46. The matter was listed on 19/7/2024, my name has not been shown. Though there was no defect in my wakalat, my name was not shown. On that day, they have insisted on an application for injunction against me, restraining from putting up construction on my property, which I have explained in my objection to that application. Please note, they have suppressed the fact that, please note, they were not enjoying any interim order passed by this honorable court or before the trial court. In fact, this honorable court had permitted all the respondents from 3 to 44 to develop the property and enjoy the property subject to result of the suit.
I'll hear it on Tuesday.
Please, madam.
ನಿಮ್ಮ ಹೆಸರು ಈಗಲೂ ತೋರಿಸಿಲ್ವಾ?
ಈಗ ತೋರಿಸಿದೆ, ಇವತ್ತು ತೋರಿಸಿದೆ. Now we went office inquired and we made it.
Interim order extension.
ಆಯ್ತು.
Interim.
Last ಕಡೆಗೆ Tuesday ವರೆಗೆ. Please mention at Tuesday. I'll hear you on Tuesday. ಮಂಗಳವಾರ.
Tuesday.
List it on. Yes. Next.
May I please, lordships? But item number 55 and item number 50, my lord, they go together. But on the last occasion, on 12/8/2024, this honorable court was pleased to permit me to serve notice for the unserved respondent R4, Mr. M.S. Devaraju.
R4 is consent.
So I have
Receive ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. Authority. And 2 weeks time to.
I'll one submission. Now, when we filed the writ petition and the matter came before this honorable court preliminary hearing, Lord, because the impugned order is of the year 2019, to which I am not a party, this honorable court said that serve the summons and thereafter the interim order will be considered. So we have served Lord Mr. Devaraju for R4.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ ರೀ ದೇವರಾಜು. Ready to show the name of so and so to R4. Since counsel for petitioner is pressing for interim order, let this matter and preliminary on ಒಂದು.
ಅದು item number 50 also same. ಅದು ನಾವು
55 and 50.
Yes.
16 preliminary on so and so date. Preliminary. ತಪ್ಪರಿ ಕೇಳಬಾರ್ದು.
1 week.
2 ವಾರ ಕೇಳಬಾರ್ದು. ಈಗ preliminary ಇಂದಲೇ 2 ವಾರ ಕೇಳಬಾರ್ದು.
1 ವಾರ.
Yes. List it on so and so date. Date ಕೊಡ್ರಿ.
Next week.
4/9
will be 2 weeks hence. Actually. ಇವತ್ತಿಗೆ ನೋಡಿದ್ರೆ ಮುಂದಿನ ವಾರದಲ್ಲಿ
ಅದಕ್ಕೆ ಅವರು ರೆಡಿಲಿ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಬಿಟ್ರು ಅವರು.
ಬುಧವಾರ ನೆಕ್ಸ್ಟ್ ಬುಧವಾರ ಸಬ್ಜೆಕ್ಟ್ ದಿ
ನಾವು ಡೇಟೇ ನೆನಪಿರಲ್ಲ ಈಗ. 28. You have to seek instruction for preliminary. Interim order oppose ಮಾಡಕ್ಕೆ limited instruction.
ಈಗ ಬುಲ್ಡೋಸರ್ ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ ಮೇಲೆ. Bulldozer is brought on our land. And lords, now they want to create third party interest because this land, they want to allot it to lords, sightless people, etc. Whatever action subject to them next week.
28 ನೋಡ. Yes, both connect ಮಾಡಿ. Connect ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ.
Submission number 41. Serial number 41, my lord, 2001 matter. Appeal is of 2010.
We had been trying our best.
May fix a date, my lord.
5/9.
Tumba.
Serial number 42, my lord.
We'll assign dates.
29.
Quote, sir. 47.
12/9, sir.
12/9.
Sir, 36. 36.
Court officer, sir.
36.
Court officer.
Serial number 21, 29/8, 22, 29/8. 23, 24, 25, 29/8. 26, 27, 29/8. 29 to 30, 29/8.
29/8.
31, 32, 29, 8.
ನಂದು ನಂಬರ್ ಕೇಳ್ಬಿಡ್ತೀನಿ ಇರಿ ಸ್ವಾಮಿ.
33, 29, 8, 34, 35,
42.
29, 8. 37, 29, 8, 36, 29, 8.
Court of sir.
38, 29, 8. 39, 59, 40.
Sir, 40 ಏನು?
Sir, 39, sir, serial number 39.
12 ಬೇಡ 59 ಹಾಕಿ.
42.
Sir 42.
44, 12, 45, 29, 8. 46, 28, 8. 47,
59
29.
Sir 42, 12 ಬೇಡ 59 ಹಾಕಿ.
serial number 28. Hello.
ಇಲ್ಲಿ ಸ್ವಲ್ಪ
Sir.
25 serial number 25 ಯಾವಾಗ?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Court officer, serial number 25.
ಕೋರ್ಟ್ ಆಫೀಸರ್
Serial number
ಸೀರಿಯಲ್
25.
ನಂಬರ್ 40 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಮಿಸ್ಟರ್ ಕಾಮತ್, ಯಾಕೆ ಇಷ್ಟೊಂದು ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದೆ?
ಏನ್ ಗಿರೀಶ್?
Madam.
Court officer.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇಲ್ಲಿ ದಯವಿಟ್ಟು ಇಲ್ಲಿ ಕೇಳಿ ಒಂದು ನಿಮಿಷ. Serial number 25 ಯಾವಾಗ ಅಂತ ಕೇಳಿ.
ಇಬ್ರು ಒಪ್ಪರಲ್ಲ, ಇಯರ್ ವೈಸ್
ಅಲ್ಲಲ್ಲ court officer, serial number 25 ಯಾವಾಗ?
29, 8.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
49, 16, 10. 50, 28, 8. 51, 59.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
56, 53, 27, 8.
Court officer, ದಯವಿಟ್ಟು ಕೇಳಿ.
28, 8, connect with serial number. Devaraj, MS Devaraj for R4.
Court officer, serial number 25.
ಇದು ಕಾಣೆ ಇವತ್ತು ಡೇಟ್ ಸಿಗಂಗ್ ನಮ್ಗೆ.
ಇಲ್ಲ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರಲ್ಲಿ ಫಿಸಿಕಲ್ ಆಗಿರೋ ಹೇಳ್ತಾರೆ. ಡೇಟ್ಸ್ ಕೊಟ್ಟರೆ ಆಗ್ಲಿ ಎಲ್ಲಾ ಕೇಸ್ಗೂ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಗೊತ್ತಾಯ್ತು. ಮತ್ತೆ ರೀಚ್ ಆಗಿದ್ರೆ ಬೇರೆ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಸರ್. ಇದು ಲಾಂಗ್ ಡೇಟ್ ಕೊಡಂಗಿಲ್ಲ ಹಳೆ ಅವ್ರಿಗೆ. ಈಗ ಅವ್ರದ್ದು ಫೋನ್ ನೋಡಿದ್ರೆ
Court officer, ಕೇಳ್ತಾ ಇದೆಯಾ court officer? ದಯವಿಟ್ಟು ಕೇಳಿ. serial number 25. serial number 25 court officer.
ಆಯ್ತು, ಇರ್ಲಿ ಬಿಡಿ, ಅವತ್ತೇ ಬರ್ಲಿ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
29, 8. 29, 8.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಹೇಳಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಯಾವತ್ತು ಸರ್?
39. 59, 39.
ಥ್ಯಾಂಕ್ ಯು.
25 court officer, serial number 25.
22.
Hello, court officer, serial number 25.
ರೆಡ್ಡಿಂಗ್ ಇಲ್ಲ, ಅದೇ ಬ್ಲಾಕಿಂಗ್ ಅಲ್ಲೇ ಮಾಡಿ.
court officer ಕೇಳ್ತಾ ಇದೆಯಾ?
29, 8.
29, 8, 25.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಏನ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
59.
59 ಆ?
59.
ಓಕೆ.
59.
ಮಸ್ತ್.
ನಂದಕುಮಾರ್ ಹೇಳಿ, ಏನ್ ಬೇಕು ನಿಮ್ಗೆ?
serial number 25 ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ?
25.
ಹಾ,
29, 8. 29, 8 ಸರ್.
ಅಲ್ಲ ಬೇರೆ ಇನ್ನಾದ್ರೂ ಡೇಟ್ ಕೊಡಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಗುರುವಾರಕ್ಕೆ.
ಅಲ್ಲ ಬೇರೆ ಇನ್ಯಾವ್ದು ಡೇಟ್ ಕೊಡಕ್ಕಾಗತ್ತಾ ಅಂತ? 29 ಸ್ವಲ್ಪ ಬಿಸಿ ಇದೆ ಅದಕ್ಕೆ.
ನೆಕ್ಸ್ಟ್ ಬಂದಾಗ ಕೇಳ್ಕೊಡಿ. ಓಕೆ, ಬಾಯ್.